Yes. Yen fresh matter. Monday date given fresh matter. Tomorrow or day after, tomorrow or Friday, give it. GMCPC, yeah. Friday or Monday, Bharat Kodi.
Well, in this matter, the defendants have encroached.
Give the memos, sir. Give the memos.
For tomorrow, my lord, the urgency is that an order of status so comes to be granted by the coordinate bench of this honorable court. The petitioner and for the respondent, petitioner has suppressed the material fact that another coordinate bench of this honorable court had injuncted him to use the public road.
So who has granted? Where is it? Where is the matter pending?
Before your lordship,
I have granted an order. Then?
Coordinate bench in the GMCPC matter.
Solid. Give it.
For
Yes.
tomorrow, my lord, there is some urgency, my lord.
No, tomorrow.
The public road is being utilized.
Oh, you parvailla. Angar urgency nahi illa kodi. Yes.
Monday. In this matter, the defendants have encroached.
Yalla give sir. Give the memos. General award kodi. General award ella naಳೆ ಹಾಕಿ madam.
Lordship.
My lord, in this matter, my lord, one submission.
Pending matter Monday ಬರಲ್ಲ ಸದಾನಂದ.
My lord,
It will come on Tuesday or Thursday.
Any date may be given that.
No, that I won't give. ಒಂದಕ್ಕೆ pending matter ಕೊಟ್ಟರೆ ಎಲ್ಲದಕ್ಕೂ ಕೊಡ್ಬೇಕು. I am following method of seniority. It will come.
Because of the fact that the Chinnapanadi main road is being obstructed by the petitioner, there is.
That we'll see.
Otherwise,
Yes.
I would have made.
Yeah, government has not taken any action.
No, my lord.
Why?
Already there is an order by the coordinate bench directing the BBMP to remove the encroachment. Partially it has been removed. What the petitioner does
So
is
not
that-
according to your satisfaction.
Not that,
Then-
what the petitioner does is he files an original suit claiming that he has right title and interest. No order came to be
We'll
passed.
see. Yes.
Yeah.
Bharat, next week Bharat.
my lord, in this matter,
Give all the memos, sir.
Lordship. CMP
this
matter.
ಎಲ್ಲ GMCPC Monday ಮಾತ್ರ ಕೊಡಿ. ನಾಳೆ tomorrow and Friday ಯಾವುದಿಲ್ಲ ಕೊಡಿ. Wait, LABDA will come on Tuesday. Fresh matter. Thursday. Yes.
Lordship.
FR ಇದ್ರೆ ಕೊಡಬೇಡಿ. Yes. Next Thursday. This Thursday full. Yes.
Lordship.
Pending ಕೊಡಿ. ಡೇಟ್ ಕೊಡಲ್ಲ pending ಕೊಡಿ. No, ಏನಿದ್ರು ಕೊಡಲ್ಲ ಕೊಡಿ ಡೇಟ್.
Lordship. CMP
It will
matter.
come.
Your Lordship.
Yes. There are 5,000 memos before you, sir. Please give.
Lordship.
Where do I go? Yes. Vacating stay ಇದ್ರೆ ಕೊಡಿ. Give it. Vacating stay ಇದ್ರೆ ಕೊಡಿ. 99 matter ಯಾಕಿದೆ ಇಲ್ಲಿ? ಸರಿ ಅದಕ್ಕೆ don't say 99 matter madam. 24 23 25 ಮತ್ತೆ ಕೊಡಿ. You projecting as though it 99 ill pending ಇದೆ. Why all this? Vacating stay ಹಾಕಿದೀನಿ ಅಂತ ಹೇಳಿ ತಗೊಂತೀವಿ. Give it. Vacating it will come. Today it won't come. It will come on. ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್. ನಾಳೆ ಅಲೋ ಮಾಡಕ್ಕೆ ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ ಅಂತ ಹಾಕಿ ಮೇಡಮ್.
Lordship. CMP matter. Your Lordship.
CMP is not before me. Sir.
Lordship, that is decided by the Lordship and it was pending for orders on IA
For what, sir?
reappointment and reappointment of
Then you give
arbitrator
it.
and
Friday will post it. Give it.
my lords,
Tomorrow.
my lords,
ಏನ್ CMCPC na CRP na? Fresh matter.
my lords, my lords,
No date. Yes, give it. Fresh matters ಕೊಡಿ. FR number ಇದ್ರೆ ಬರಲ್ಲ. If you complain ಬರುತ್ತೆ. Yes. ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ಮೇಡಮ್ ಬರುತ್ತೆ. ಇರ್ಲಿ Thursday.
my lord,
For what, pending or fresh? Monday.
my lords,
No, not according to you, according to the court. Give it. Innu having case in? Give the memo back. Yes. Don't move it till he finishes that case in Gulbarga. Yes.
my lord,
GMCPC matter, commercial OS eviction suit, the there is an order of admitted rents to be paid.
Hmm.
In spite of the
You are the tenant.
admitted rents to be paid. by its
Tenant.
honorable- Please, my lords.
Pay, sir.
My lords, what has happened is they have repeatedly filing amendment applications.
Correct, no
frivolous
problem.
applications.
You pay, that doesn't mean that you should not pay the rent.
No, no, I am the landlord.
Yeah, ಮತ್ತೆ ಅದನ್ನ ಕೇಳ್ತಾ ಇದೀನಿ, tenant or landlord. Give it, yes.
My lords,
Monday.
my lords,
Fresh matter Monday
GMCPC.
Monday. So what? Why great urgency? You are the JDR. You are the JDR. Are you the judgment debtor? Ah, yes. No, yes,
My
tell me.
lords, GMCPC.
It will come, sir, Monday. Fresh matter, ah? Fresh matter Monday,
My lords, GMCPC fresh matter.
Monday.
My lords, one humble submission.
Yes, sir.
Actually, the JDR has also approached this honorable court. This honorable court had actually granted stay on the execution proceedings. My lords, that is on factual grounds. They have said that the court did not have the jurisdiction to entertain not only the.
All right, what is your problem? Tell me now.
My lords, the point is in
Not the
commercial
point.
AP.
What is the problem?
My lords, in commercial AP, the court had obtained deposit pursuant to MSMED Act Section 19.
Again, have you filed vacating stay?
My lords, I have filed a WP.
Separate WP.
Separate WP.
Monday it will
challenging-
come.
My lords, the issue is that they have filed another repetitive application before the commercial courts. They, it has been reserved for orders.
That is not
my
the
lords.
concern of the court. Monday, your petition will come, we'll pass orders. On that day, whatever point you want to make out.
My
please
lords,
make out.
they have filed an application before the commercial courts for withdrawal of the deposits today. And the orders are reserved for today.
2:30, give it.
Much obliged, my lords.
ಅದನ್ನ ಫಸ್ಟ್ ಹೇಳ್ಬೇಕು, ನಾಟ್ ಬೀಟಿಂಗ್ ಅರೌಂಡ್ ದ
Yes, my lords.
Yes.
Much obliged.
230, my lord. Dispersal, not to disperse compensation. AD.
Memo ಕೊಟ್ಟಿದ್ದೀನಿ.
ಏನಿಲ್ಲ ಅದು, ನಾಳೆ ಹಾಕಿ, ನಾಳೆ ನಾಡಿದ್ದು ಹಾಕಿ,
No, my lord, one.
ಏನಾಗಲ್ಲ. 28 crores
No, my lord.
ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ
Another-
ಆಲ್ರೆಡಿ.
No, no, another property, my lord, adjacent property.
Oh.
Once they have released this compensation, that's why we have filed.
At 2:30, give it. Give it, sir. Give the memo.
My lord,
Give the memo next Tuesday. Yes.
one matter, my lord.
Give all the
One
memos.
Fresh matter, my lord.
Fresh matter ಎಲ್ಲ Monday ಕೊಡಿ.
That's land-
GMCPC Monday, make it Tuesday. Give it.
That's matter
Give it. No problem, madam.
Allotment,
Give it, give
matter
it.
pertaining to land acquisition.
Give it.
Directed to
If you want, give the memo. I'll call the cases now. Please give the memos.
Vacating stay order, my lord, GMCPC.
ಅದೇ CRP ಇದೆ, Thursday ಬರುತ್ತೆ ಕೊಡಿ. Thursday, ಆ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ? ಏನ್ ಪರವಾಗಿಲ್ಲ, ಬರುತ್ತೆ ಬಿಡಿ. ನೋ ಪ್ರಾಬ್ಲಮ್, ಥರ್ಸ್ಡೇನೆ ಬರೋದು. Next Tuesday. Give
My
it.
lords,
Land acquisition matters ಎಲ್ಲ ಕೊಡಿ.
With your land, my lord.
Give all the land acquisition matters also.
Order has been passed. by-
Tomorrow and day after, I am not taking anything, sir. ಏನ್ urgency? Wait. ಏನ್ urgency?
2010 notification. In that my name was there.
ಈಗ ಏನ್ urgency ಅಂದ್ರೆ don't go to history.
2010 my name is not there. Now the notice is the set of disposal from the land.
ಕೊಡಿ, Thursday.
My lords.
Thursday.
Lordships covered.
ಆಯ್ತು, 2:30 ತೊಗೊಳ್ಳಿ.
my lords,
Which jurisdiction is this, madam?
GM ಇಲ್ಲಿ ಬರಲ್ಲ
ಇಲ್ಲ,
ಮಾ.
ಇಲ್ಲ madam, ಆ court, ಬೇರೆ court.
My
My lords,
My
my
lords.
lords, one indulgence.
Lordships, his lordships has
Give-
passed.
My lords,
passed
one
an order,
indulgence.
Lordships. Justice Devdas has passed the order. KIDB matter, lordships. It's
Disposed?
Allowed, your lordships. I even produced a copy of the order
ಕೊಡಿ,
also, your
ಆ
lordships.
lines ಅಲ್ಲಿ ಬೇರೆ ಎಲ್ಲ ಕೊಡಿ.
Two
My
ma-
lords.
two matters
My lords.
also I have given. Order copy also, his lordship's order copy. I've
My
given
lords.
the relevant pages because it's more than 135 pages, your lordships. I've given. the
ಮೆಮೊ ಕೊಡಿ
relevant
ಸರ್.
Fresh matter, my lord. We take
Monday.
up tomorrow.
GMCPC na?
House.
Monday.
Huh.
Yes.
pages. Nice.
my lords, respondent bid has demolished my property, my lords.
Already demolished.
Demolished, my lords. Is it
Pending or
precipitated?
fresh?
Fresh matter, my lord.
Give it. Tuesday.
Lords, pending matter, my lords. My lords,
Give the
the
pending.
EA for written
No,
statement
no,
after lapse
no
of 7
date
years,
on
my lords.
pending memos, please give. Yes.
My lords,
ಏನ್ urgency? Pending matter? Fresh Monday ಕೊಡಿ. ನಾಳೆ ಆಗಲ್ಲ. Monday. ನಾಳೆ there are 120 matters already, sir. ಅದೇನ್ ಬೇರೆ senior engage ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ. Yes.
My lords.
That's not the ground at all.
My lords, vacating stay application for KIDB. My layout, arterial roads are blocked because of stay orders.
What?
Arterial roads for the development are blocked because of the
Stay
stay.
order.
Vacating, we have stay in the land acquisition proceedings. My lords.
When I have granted,
My lords, 2025 petition and 24 petition.
stay I have granted,
My lords, one of them, my lords have wanted one earlier.
followed that.
We have filed vacating stay application.
Vacating stay
My lords, may date may.
Thursday vacating stay Thursday
Madam, Thursday, ಮೂರಿವೆ.
ಯಾರು ಸೀನಿಯರ್ ಎಂಗೇಜ್ ಮಾಡಿದ್ದೀರಾ? ರವಿಶಂಕರ್ ಹೇಳಿ
Deeply
ಕೋರ್ಟ್ಗೆ ಇವತ್ತೇ ಬರ್ಬೇಕು.
Deeply obliged.
ಏನ್ ಬಂದವ್ರೆ? ಅಸೋಸಿಯೇಷನ್ ಮಾತಾಡ್ಕೊಂಡ್ ಬಂದ್ರ? ನಾಳೆ ಹಾಕ್ಸ್ಕೊಳಪ್ಪ ಅಂದ್ರ ಹಾಕಲ್ಲ ಅಂತ ಹೇಳಿ. ನಾಳೆ ಆಗಲ್ಲ ಅಂತ ಹೇಳಿ ಫ್ರೈಡೆ ತಗೊಳ್ಳಿ.
My lords, there's a contempt.
Hey, that's not the ground, sir. Please.
My lords, there's a contempt petition filed against me. There's an FIR also filed against me where there's a B report filed. If the matter may be had on Monday.
What? For what? What is that?
We are challenging we have challenged an IA for restraining to construction that is being appealed in the lower court, Your Honor.
GMCPC.
GMCPC.
With my lord's name, my lord. One GMCPC matter.
You have filed vacating stay, is it?
Yes, Your Honor.
Madam, ಅದು vacating stay ಹಾಕಿ.
My lords,
With my
the
lords.
suit has become infructuous, my lord.
Thank you, madam. Give it. Yes.
With my lord's leave, one
My lord's
GMCPC
fresh
matter.
Influxes ನಾಳೆಗೆ ಹಾಕಿ.
One GMCPC matter. My lord, may I request my lords to kindly have it tomorrow, my lord. Urgency is this. My sale deed, my lords, is in the year 1996. Trespasser, my lords, creates a false business card.
ಆಯ್ತು
as
ಏನ್
ministry of
ಪ್ರಾಬ್ಲಮ್ ಏನಾಗಿದೆ ನಾಳೆಗೆ ಹೇಳಿ.
Construction is stopped.
ಅಷ್ಟೇ ಅಲ್ವಾ?
I've taken a loan.
ಫ್ರೈಡೆ ಕೊಡಿ ಫ್ರೈಡೆ. ಏನ ಹೆವೆನ್ಸ್ ಆರ್ ನಾಟ್ ಗೋಯಿಂಗ್ ಟು ಫಾಲ್. ಫ್ರೈಡೆ ಎಸ್.
My lords, fresh matter.
ಡಿಸ್ಪೋಸೇಷನ್ ಅದೆಲ್ಲ ಆದ್ರೆ 230.
I'm in possession, my lord,
So
since
ಅಲ್ಲ
1996.
ಆ ಮ್ಯಾಟರ್ಸ್ those things ಇದ್ರೆ ಮಾತ್ರ you project urgency. Your project has come to a standstill is no
My lord,
urgency.
I have taken a hand loan. I'm
No,
an architect in a temple.
hand loan
my
why
lord.
did you take, sir?
I'm an architect in a temple.
Oh,
I'm
no
not an
problem.
income
Give
tax
it,
loan
sir.
assessee.
Give it.
One false business card.
ಇದೆಲ್ಲ
Ministry of Defense.
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. Then ಅದು ಯಾವತ್ ಮಂಡೆಗೆ ಹಾಕಿ.
My lord, lordship,
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ?
in the fresh matter.
ಮಂಡೆ. Yes.
Like, your lordship, may kindly have it on
Monday.
Friday.
Monday. No urgency. Monday.
My
Friday.
lords, fresh
You should
matter.
not project pseudo
No,
urgency.
no, my lord, my construction has come to a standstill.
That's why I said heavens are not going to fall.
Your lordship,
Monday.
may kindly
Yes.
have it on Friday, my lord.
No problem. No Monday. ಅದು FR number.
ಅಲ್ಲಿ ಇವತ್ತು ಫೈಲ್
ಅಲ್ಲೇ ಇಷ್ಟೊಂದು. Yes.
ಎಲ್ಲ ಫೈಲ್ ಮಾಡಿರೋದು ಇವತ್ತು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
ಅದಕ್ಕೆ ಮಂಡೇ. ಕಂಪ್ಲೈ ಮಾಡಿ ಮಂಡೇ ಬರುತ್ತೆ. Great. 2:30. Yes.
My lords, fresh matter.
Execution ಅಲ್ಲ 2197 application. Yes.
Millards, serial number 1, I'm applying for the petitioner, Millards. Millards, we're complying with the order, Millards. We're depositing both the DDs of 5 lakhs and 25 lakhs, Millards, as directed by this honorable court. May I only make one request, Millards. Let
Yes.
the amount be subject to the adjustment of the actual mean profit, Millards. After,
All right. This court on 11/6/2025 had passed the following order. And on 4/7/2025, the following order. In compliance with the order, demand drafts of rupees
5 lakhs and 25 lakhs, Millards.
25 lakhs and 25 lakhs is placed before the court to be filed before the registry. The same be
Amount may
filed.
be released, my lord, because
ನಿಮಗಲ್ಲ.
mean profits, sir.
Deposit ಆಮೇಲೆ adjustment ಆಮೇಲೆ.
Supreme Court has released 20 crores, sir, 3 years back. 3 years back, 20, the direction was there. That mean profit 20 lakh was paid to the 3 years.
Millards, enquiry is pending, Millards. This honorable court in one more writ petition has passed an order
Anyway,
that subject to the
we have
enquiry after
directed
possession.
deposit, you file an application accordingly if you want withdrawal. The
Application
same be filed before the registry. The DD numbers ನೋಡ್ಕೊಂಬಿಡಿ. So and so. For what withdrawal? Our copy serve ಮಾಡಿ. Yes, so and so. Counsel for the respondent, Shri P.D. Surana files an application seeking withdrawal of the amount. List the application on Friday. Yes. List the application.
Millards,
and
may I
the
request Monday,
hearing or
Millards?
interlocutory application on Friday.
May I request Monday, Millards?
ಆಯ್ತು Monday.
It's
Monday
grateful,
ಬೇಡ.
Millards.
Monday early, yes. Next.
Monday, Millards, GMCPC. Grateful, Millards.
Serial number 2.
For petitioner.
Yeah, being spoken to, madam. Chamber idana. Being spoken. Huh? Why is this from the chamber? Can we check? Wait, we'll pass it over. I don't know why it's from the chamber.
Order 3.
That's today I filed NOC Vakalat in the registry, my lords. My name may be shown in the cause list.
ಮೈಲಟ್ಸ್ ಇದು ಇದ್ರಲ್ಲೇ ಎರಡೆರಡು ಸಾರಿ ಫೈಲ್ ಮಾಡ್ತಾರೆ. ಒಂದು ವಾರಕ್ಕೆ ಮುಂಚೆ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು, ತಿರ್ಗಾ ಇವಾಗ ವಕಾಲತ್ ಇನ್ನೊಂದು ಹೊಸ
Interim order vacate ಮಾಡೋಣ ಅಷ್ಟೇ.
ವೆಕೆಟ್ ಐ ಹ್ಯಾವ್ ಆಲ್ರೆಡಿ ಫೈಲ್ಡ್ ಇದು.
Lords may have this matter tomorrow, my lords. We will address the arguments.
ಯಾಕೆ
ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. Lords, it has come to our office. Lords may have this matter
ಏನು
tomorrow.
CRP ನ WP
ಇದು ಎಲ್ಲೇ ಬಿಡಿ.
ಎಲ್ಲೇ ಬಿಡಿ.
ಮೈಲಟ್ಸ್ ಆಕ್ಚುಲಿ
Learned counsel for the petitioner, learned counsel Saravana submits that he has entered appearance in place of Aditya Prasad, memo for who has filed a memo for retirement in the light of the counsel Saravana entering appearance. Already ಹಾಕಿದಿರಾ?
ಇವತ್ತು ಹಾಕಿದ್ದೀನಿ digital file.
Already Saravana undertaking to enter appearance, memo is accepted. Aditya Prasad is permitted to retire from the case. List the matter on Thursday. It's made clear no further adjournment will be granted in the matter.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಡೋದು
Interim order subsisting will continue till the disposal of the petition. ಸುಮ್ನೆ ಇರಿ, next date of hearing. Yes.
ಪ್ಲೀಸ್
Interim order extend
ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಮಾಡಿ.
ಮೆರಿಟ್ಸ್ ಮೇಲೆ
ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಬರುತ್ತೆ.
ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್.
Sorry, my lord, my request for next Tuesday, my lord.
ಅವ್ರಿಗೆ ಹೇಳಿ.
Sir.
Tuesday, yes.
Tuesday. Published.
I have to file a memo with respect to the disturbance.
ಅವ್ರು ಮೇಡಮ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
Madam, ಕೊಡ್ತೀನಿ.
ಕಾರ್ತಿಕ್ ಯಾರು ಬಂದಿಲ್ಲ ಇವತ್ತುನು?
My lord,
ಕಾರ್ತಿಕ್?
I'm not Karthik, my lord.
Then who are you?
My lord, I'm Nagesh. I've entered appearance today.
This is not fair.
My lord.
Yes, anyway, I'm not going to permit you to argue at all.
My lord, if I may make one
This
respectful
Karthik has been, I have adjourned the matter 5 times awaiting
Please,
his
my lords.
appearance, and today he says this. No,
My lord, no, my lord. If I
Nothing
make
doing, I'm
one
not
submission, my lord, I'll not argue on
going to
merits.
permit you to argue. This practice should be deprecated.
If I may make one
Add
respectful
ಎಲ್ಲ
submission.
argument ಆಗಿ detect ಮಾಡ್ಬೇಕಾದ್ರೆ change in counsel, again this, nothing doing. Yes.
My lord.
This, I adjourned it only for the government's memo. Yes, sir.
The memo is filed, my lord. Annexure D is the preliminary notification, my lord, where the extent of the land is 4 acres, 35 guntas. The whole extent is acquired, my lord. And annexure E is the final
Whole
notification.
extent is acquired?
Whole extent is PN, my lord. Preliminary notification. In the final notification, 4 acres, 77 guntas was acquired, my lord. And in handing over of the portion 16-2, 4 acres, 16 guntas was given, my lord, as per annexure F, my lord. And as of right now, 4 acres, 6 guntas stands in the name of the NTI, that is the petitioner, and 29 guntas stands in the name of the respond number 4A, all 4. That's all.
Madam, you want to
here,
File my response to this memo.
only with
I think you should file.
only one sentence.
Entire thing acquisition ಆಗಿ ಎಲ್ಲ ಆದ್ಮೇಲೆ now you are coming up with this new story. We'll see.
My lord, also whether
Only-
by way of a memo, I'll take.
Memo,
No, by way of a memo, it can't be, but anyway, you
I
just
will
check with
anyway
this.
take, very well.
My lord.
Because it is not signed by any officer, it's a memo which is
No,
a
no,
community.
it is a document,
The
it
advocate
is a
and the
document which is furnished
Very
in the
well,
petition
I'll
itself. I have relied, my lord.
I'll take it on Thursday in the same stage.
Very well.
My lord, if I may make one
No, sir.
respectful. My lord.
This is,
I'll not argue on the merits, my lord. I'll just make one submission, my lord.
Yes.
My lords may, my lords, what has happened is there was some kind of miscommunication between the client, that is respond number 4A, and the counsel who had undertaken to file wakalat, my lord. And later on, he was not able to file wakalat due to that miscommunication. I have received the brief and the wakalat only yesterday, my lord, and I filed it today in the morning before the registry, my lord. This is my respectful submission, my lord. My lord, there was some miscommunication due to which this has happened, my lord. We will make sure to not take even one adjournment and proceed with the arguments.
all
my
right,
lord.
it's day after tomorrow, we'll see. Yes,
Please,
madam,
my
you
lords,
file a
please.
response to that.
Very well.
I may be permitted to argue on day after tomorrow on merits, my lord.
No adjournment at.
I will not seek adjournment, my lord.
My lords, but if he is to file something, then he will again.
No, nothing.
My lord,
He's
I
he's
will
only
file
argued
my
the matter.
objections in the open court itself, my lord.
You filed, is it?
No, my lord, I filed wakalat today, my lord. I'll file objections on day day after tomorrow, my
I
lord.
need an opportunity to controvert.
All right.
My
My lord,
lords,
I've
I
entered
know,
appearance today, my lord.
You serve the statement of objections tomorrow on, madam. Yes,
Please,
we'll see if you need time to that, we'll see it. Yes.
My lords, but your lordships are, it's quite visible what is happening. I'll leave it at that.
My lord, I have, my respectful submission is I have entered appearance today, my
If they
lord.
want to self-select and affirm that, up to them.
My lord, I'm not privy to that information as to what has happened between the counsel who has undertaken to file wakalat and the client, my lord. I have received the brief and I filed wakalat, my lord.
ಇದೆಲ್ಲ time ಕೊಟ್ರೆ ಇದೇ ಆಗೋದು.
I'm extremely sorry.
Day
my
after
lord.
tomorrow.
I'm grateful, my lord.
Yes.
Was the interim order made?
Interim order subsisting will continue to the next date of hearing.
Grateful.
5.
My lord, Learned Counsel, Karthik's name may be deleted and my name may kindly be.
Filed
deleted.
wakalat already?
I've already filed wakalat, my lord.
Learned counsel so and so submits that he has entered appearance for the petition. Respondent number 4, R4A.
R4A, my lord.
Yes.
Grateful,
We'll
my lord.
Print the name of so and so. Next.
5.
Just for petitioner, my lord. Writ of mandamus, my lord, filed seeking direction not to allot the encroached portion in favor of the respondent number 2.
Mandamus not to allot.
Not to allot the encroached
Sir,
portion,
yes,
it
Vachan.
belong to me, my lord.
Lord, civil suit pending between the parties, my lord. Claim is on an extent of marginal land. There's already an interim order passed by your lordship.
Interim order idea.
No, but
Civil suit, civil suit.
subject to result.
Civil suit, they seem to be claiming right over a certain piece of land, my lords. I meant to, a copy was served on me last week. I meant to obtain instructions.
Obtain instructions. The learned counsel B. Vachan seeks 2 more weeks' time to secure instructions or file statement of objections as the case would be. List the matter on 24th. Objections, if any, by then interim order subsisting will
My lord,
continue
in
to
the
the next.
meantime, now let them not take any action to allot this.
Interim order ideyala,
Interim
not to
order.
allot antane ide.
Yeah, my lord, subject to result of the petition of the my lord.
We'll see, yes.
My lord.
Don't precipitate the matter. Then if allotment is made, then I will take serious action about it.
I'll obtain instructions, my lord.
Yes.
My lord, kindly see the proceeding sheet of the BDA where they took legal
The
opinion.
respondent till the statement of objections are filed not to precipitate the matter qua the allotment. Yes. Next.
6.
Lordship, I need to take some instruction from the client, Lordship, and we'll
Then
complete
we'll
the
vacate
office
the interim
discrepancies
order.
in the meanwhile, Lordship.
We'll vacate the interim order if you want to take instructions.
No, it may be have it on
Office
15th,
objections.
Lordship, on the same day only.
Why
we'll
have you not
address.
complied with the office object? 2:30 move ಮಾಡ್ತೀರಾ? Interim order ತಗೊಂಡ್ಮೇಲೆ office objections comply ಮರ್ತೇ ಬಿಡ್ತೀರಾ?
We will do, Lordship.
I'll vacate
It may be have it on 15th,
What
Lordship,
have it
we'll
on
complete the
15th?
office discrepancies and we'll address the argument on the same day.
What will address, sir? Nothing. Tell me.
No, there are some
Tell me
confusions,
on the
Lordship.
merits, sir.
That kindly pass out over the matter, Lordship.
You are a judgment. We are an objector in the execution
Yes,
proceedings.
yes, Lordship. I'm the objector in the execution proceedings, Lordship. And my contention is this, Lordship, and they are not made me as a party in the OS proceedings as well as the,
Who are you?
I'm the tenant of the first floor, Lordship.
Tenant.
Yes, Lordship.
Yes, sir. ಆಮೇಲೆ.
I'm the tenant of the first floor, Lordship, and they have filed the case against the defendant, Lordship, respond number 7.
Second floor.
Second floor, sorry, first floor, Lordship.
Case filed against whom? Against the entire building, on the entire building.
Yes, Lordship, against entire building, Lordship. But they are not made me as in party, Lordship.
Post immediately, sorry. Notice agilva.
No, Lordship, the interim order was granted.
Petitioner to serve on the counsel who represents the respondent decree holders before the concerned court and file an acknowledgement to that effect by the 11th of July. In the event office objections and the compliance of filing an acknowledgement of such service is not complied by the 11th of July, the interim order subsisting will stand automatically vacated. Subject to the said interim order stands extended till the next date of hearing.
Grateful, Lordship.
Yes.
Preliminary hearing 7.
I appear for respondent number 2 and 3, my lords. Seek for short accommodation, my lords.
2016 matter
File
short
is
accommodation. File is misplaced.
2 days accommodation, my lords.
Despite 2 decades, award has not been passed, covered by several judgments. Till date, no
2
award
days
has been
accommodation, my lords.
Judgments ಕೊಡಿ
I have filed our objections, my lords.
ಯಾರು ಬಿಬಿ ಪಾಟೀಲ ಇಲ್ಲೇ ಇದ್ರಲ್ಲ ಈಗ
File is misplaced, my lords.
Where is he missing now?
He is in portal number 4.
Yes. ಕೊಡಿ ಇದ್ನ.
That's page 17.
ಅನು ಪ್ಯಾರಾಗ್ರಾಫ್ ಸ್ಟೇಟ್ ಮಾಡಿದಿರಲ್ಲ.
Please, page, in the compilation I have stated that.
Yes, ಹೇಳಿ.
Relevant paras. Page 17, my lords, the relevant paras, para 17. In page 34. In the instant case, the facts are very pertinent, though the preliminary notification was issued on so-and-so date and declaration and final notification under section so-and-so was issued on so-and-so date, no award has been passed till date. Even though the possession of land in question was taken on 26/6/1975, there has been no development of the said land precisely because no award has been made in respect to the said land in question. In the circumstances, even without reference to section 24(2), of the 2013 Act, having regard to the facts which emerge in the present case, we hold that there is abandonment of the acquisition process by the state government as well as the appellants herein. The acquisition has lapsed by virtue of abandonment of the acquisition process as for over 4 decades from the date of taking possession of the lands in question, and no award has been passed.
Yes.
It's 2 days. time.
List on Thursday. It is made clear no further adjournment would be granted in the matter. Next.
Obliged, my lords.
Similar to what was,
Previous.
2010, yes, 2010 preliminary notification. 2020 is the final notification, till date no award is passed.
Pradeep.
Lord, as my instructions, my Lord, now, my Lord, award has been passed.
When?
Lord, and 23/5/2022, my Lord, a notice was issued, my Lord, to the petitioner, annexure R5.
Objections hakidira?
Hakidim, sir. Page number 22.
Your lordships were to see that why should the KDB do this? I really don't understand. I have produced a copy of my sale deed where I have purchased this property in 2005. Now they have produced this annexure R5. Lordships may kindly see this, my lords. Just to say that they should have a defense. If your lordships were to see the document which is at
R5.
page number 27.
Yes.
Lords,
No,
at
R5 is page 20.
Lords, R5 is page 20. That your lordships may hold along with my sale deed at annexure A, page number 14. At page 24. Yeah, the Lord sign.
24, 23 schedule is 20.
Or Lords, page 27. Page 27 and 28. Serial number 3 is Y.R. Anil, to whom the letter is said to have been addressed.
Sale deed no hota idira ಏನು?
Lords, your lordships may come to the partnership deed of 2011.
Yes.
Sale deed also contains his signature.
All right.
If your lordships were to take page 28, Aarti, Sunil and Y.R. Anil, who is one of the addressee lords in that, the last one is his signature in that. Now your lordships may kindly say, my lords, annexure R5, the so-called my signature which is in the bottom of the page to say that they have served this notice on me.
Y.R. Anil. That's a signature, is it? Page 35? Why, sir?
Now, ಮಾಡಿರ್ತೀವಿ sir.
ಏನು
ಅವ್ರ ಕಡೆ ಯಾರು
ಹಂಗೆ?
ತಗೊಂಡಿದ್ದಾರಲ್ಲ ಗೊತ್ತಿಲ್ಲ. Lord, if that is the case, my Lord, I'll secure the original records. and
What
produce-
secure the original records?
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ನಾವು
My sale deed is also
ಅಲ್ಲ.
there. 2005 registered instrument is also
ಅಲ್ಲ,
there.
it is only notice, my Lord, issued, my Lord, and 29
Allah,
two, my Lord.
notice is, this is where you're trying to cover up everything. Saying notice was
Lord,
issued in
preliminary-
2022, award
preliminary
is passed in 2025.
Preliminary notification was issued in the year 2010.
10.
My Lord, 2020 final notification. My Lord, the acquisition challenge, my Lord, after 2 years. This notice, my Lord, was issued in the 2022, my Lord. My Lord, I don't know, my Lord, whether it's this, we have to relay.
Whatever you should tell me. ನಿಮ್ದೇ ಡಾಕ್ಯುಮೆಂಟ್ ಅದು R5 ನೀವೇ ಹಾಕಿರೋದು. ನೀವ್ ಹಾಕಿರೋ ಡಾಕ್ಯುಮೆಂಟ್
ಗೊತ್ತಾಯ್ತು, ಸೈನ್ ಅವರು
ಸೈನ್ ಅವ್ರದಂತೂ ಅಲ್ವೇ ಅಲ್ಲ ಬಿಡಿ. ಸೇಲ್ ಡೀಡು ಇದೆ, ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಇದೆ, ಎಲ್ಲ ಇದೆ. Y.R. Anil ಅಂತ ಇಂಗ್ಲಿಷ್.
assuming that, my Lord, it's notice, my Lord, to, my Lord, participate in the award proceedings.
That's all right, sir. Award, see, if this is not served at all, where is the question? Now we have passed an award saying that it did not come and appear. ಅದೇ ಮಾಡಿರ್ತೀರಾ ನೀವು?
Record ತಗೊಂಡು produce ಮಾಡಿ.
Get the records.
Please.
The learned senior counsel D.R. Ravishankar submits that the preliminary notification is in the year 2010 and the final notification in 2020, Allah?
Please.
2020, and no award is passed even as on date. To justify the passage of the learned counsel Pradeep Kumar submits that award is passed in the year 2025.
Not, Lord, this is a notice.
This notice. ಈಗ award ಆಗಿದೆ ಅಂದ್ರಲ್ಲ
Award
ಮತ್ತೆ?
ಆಗಿದೆ, sir.
Award is passed in the year 2025, preceding to which a notice was issued as obtaining in annexure R5 to contend that award is passed after prior notice to the petitioner. Petitioner ತಾನೇ ಅದು?
Please, one of the petitioners.
To one of the petitioners who has not appeared for inquiry, and therefore the award is now passed and deposited.
ಅದು check ಮಾಡಿ.
Therefore the award is now passed. The notice that is issued to Y.R. Anil, one of the petitioners, bears a signature which is at complete variance with the original signature, even without any further examination, as The sale deed and the partnership deed contains the signature of Y.R. Anil in a particular manner, and the receipt of notice is by some person who signature of which does not even match to its semblance. Therefore, the respondent shall place on record place the original records for the perusal of the court on the next date, next Tuesday.
Please, great.
The challenge is noted.
Yes, sir.
The challenge is to the final notification. Let's, the petitioner is a manufacturer of the ceramic carbon composite parts. For an extension, I filed an application before the SHLCC.
I heard you on the last occasion.
Heard on the last occasion.
I've heard you.
but
You ಹೇಳ್ಬೇಕಾಗಿತ್ತು.
No, certain documents I would request this honorable court to kindly look into before doing it. Kindly. That 12/6/2025, certain documents have been produced before this honorable court by the respondent, may kindly be seen once.
ಅವ್ರು ಹಾಕಿದಾರಾ?
ಅವ್ರು ಹಾಕಿರೋದು.
Objections ಹಾಕಿಲ್ವಾ?
ಹಾಕಿದ್ವಿ. ಇದರಲ್ಲಿ
Yes, sir.
The my lords, on 8/10/2021 at annexure H, the Verdal owner Munarsaya had expired. And this is, and my lords, the notice that has been sent to me on 16/12/2024. They said he has died in 2021 itself. And kindly, I have produced the death certificate.
16/12/2024 notice.
2024.
On whom is this?
It is on Muni Narsaya, it has been served, that's what exactly they say.
ಎಲ್ಲಿದೆ?
Because they have even
ವಿ
produced
ನರಸಯ್ಯ
them.
ಅಂತ ಎಲ್ಲಿದೆ?
ಅಲ್ಲಿ ಅವರೊಂದು ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ, ಇದ್ರ ಹಾಕಿದ್ದಾರೆ, ಪೋಸ್ಟಲ್ ರಿಸೀಟ್ ಹಾಕಿದ್ದಾರೆ.
ವೆಂಕಟ
ವೆಂಕಟ ನರಸಯ್ಯ, his name is ವೆಂಕಟ ನರಸಯ್ಯ, I'm sorry.
All right.
ವೆಂಕಟ ನರಸಯ್ಯ ಅನ್ನೋರು
16/12/2024 ಸರ್ವ್ ಆಗಿದೆ.
ಸರ್ವ್ ಆಗಿದೆ ಅಂತ. Has died on 8/10/2021 as per annexure H.
ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ.
ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದೀವಿ, ಅವ್ರಿಗೆ ಕಳಿಸಿದ್ದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಆಮೇಲೆ I would request this honorable court to kindly look into document that is at
annexure H page ಏನು?
Annexure H is page number 60, my lord.
Yes.
My lords, further, my lords, I would request this honorable court to kindly look into, the award is not yet passed. May kindly see, I think there's no pagination on this, but they have produced a document.
You are the landowner?
My lords, I am the son of the landowner. I am also the owner, the director of the company which has moved for the SHLCC for the.
You're not the purchaser.
I am not the purchaser. I am not the purchaser. I am the lord of this. Kindly, my lords, 25/3/2025, they have produced a document.
Page
is, my lords, they have not given the pagination.
ಆಯ್ತು, ಯಾವ್ದ್ರಲ್ಲಿ ಅವರ
They said, my lords, a document styled that they have sent a document for confirmation of the award passed. That is on 25/3/2025.
It's here, yes.
It's, my lords, have
Page 6.
Page 6. This is, my lords, only when I moved this honorable court for interim order, these things, the award came to be, said to have been passed. But these, my lords, may kindly see, I would request this honorable court to kindly look into certain dates. I would, my lords, in these circumstances, my lords, on 8/9/2020, my lords, that I have filed an application for grant of this thing. On 9/9/2020, SHLCC, it's been considered. Annexure C is the document.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
I would request this honorable court to kindly look into annexure C for a while, my lords. Annexure C is at page number 48. Lords, this is the order passed on 9/9/2020. This is the time when COVID was there. Lords, that is the prime COVID period. Till February 2022, even Supreme Court had condoned all these things. Lords, this is the period that they say that I have not implemented the project. May kindly see, my lords, I would request this honorable court to kindly see the order passed in relation to my objection.
Your allotment or acquisition?
My lords, they have acquired the land belonging to me. I have given a proposal.
ಅದಕ್ಕೂ ಪ್ರಾಜೆಕ್ಟ್ ಮಾಡದೇ ಇರೋದಕ್ಕೆ ಏನು ಸಂಬಂಧ?
ಅಲ್ಲ, ಪ್ರಾಜೆಕ್ಟ್ ಮಾಡಕ್ಕೆ ಆಗ್ಲೇ virtually ಆಗ್ಲಿಲ್ಲ. See, there are two reasons for this.
What is that got ಅಕ್ವೈರ್ ಮಾಡಿ ನಿಮಗೆ ಪ್ರಾಜೆಕ್ಟ್ ಮಾಡಕ್ ಕೊಟ್ಟಿದ್ದ ಅದು?
ಅಕ್ವೈರ್ ಮಾಡಿ ಪ್ರಾಜೆಕ್ಟ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಲ್ಲ.
You are the landowner, yes.
ಅಲ್ಲ, ಲ್ಯಾಂಡ್ ಓನರ್ who had expired on, let's make kindly see the.
All that is fine. Why are you linking this project not being able to commence with acquisition?
No, they have now acquired independently that land. KDB had independently acquired this land.
All right, yes.
That is what under challenge before this honorable court. I would request this honorable court to kindly turn to page number 65.
Notification ಹೇಳಿ sir.
Notification is at my lord's annexure L at page number 71.
Which is your land here?
Class item 10 may kindly be seen, 10 and 14 therein, page number 72, entries
72
72 page ಅಲ್ಲಿ
ವೆಂಕಟ ನರಸಯ್ಯ.
ವೆಂಕಟ ನರಸಯ್ಯ ಬಿನ್ ಚೆನ್ನಯ್ಯ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. We are the children of Venkat Narsaya.
All right.
Nasimaya bin Challaya. I would request this honorable court to kindly turn to annexure D for a while, my lords. The one of the condition is that I should get the change of the land use.
Annexure D ಅಲ್ಲ?
Change of land use. It's an agriculture land. I was required to get the change of land use.
Order, don't worry. Yes, next.
Therefore, my lords, I could not implement the project and I have explained it to them even. While considering that, I would request this honorable court to kindly turn to the order that has been passed with respect, considering my objection. That is at page annexure K, page 63. 11th page would be page number, entry 10 at page number 65. ಅದರಲ್ಲಿ page number 65 ಅಲ್ಲಿ entry 10 ಅಲ್ಲಿ the last column in this thing. ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿದೆ, ಆಕ್ಷೇಪಣೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ಈ ಜಮೀನು ಉದ್ದೇಶಿತ ಕೈಗಾರಿಕಾ ಪ್ರದೇಶ ಯೋಜನೆಗೆ ಅವಶ್ಯಕವಾಗಿ ಬೇಕಾಗಿರುವುದರಿಂದ ಭೂಸ್ವಾಧೀನಕ್ಕೆ ಆಕ್ಷೇಪಣೆಯನ್ನು ತಿರಸ್ಕರಿಸಿ ಭೂಸ್ವಾಧೀನ ಸಲ್ಲಿಸಲು ಆದೇಶಿಸಿದೆ. ನೆಕ್ಸ್ಟ್ ಒನ್ ಇಸ್ page 66 ವ್ಯಾಕ್ಯೂಮ್ ಕಂಪನಿ ಲಿಮಿಟೆಡ್ ಎಂಬುವರು ದಿನಾಂಕ 22/4/2022 ಲಿಖಿತ ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಿ ಈ ಜಮೀನು ಕೈಗಾರಿಕಾ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂ ಪರಿವರ್ತನೆ ಮಾಡಿಸಿಕೊಂಡಿದ್ದು ಉದ್ಯೋಗ ಮಿತ್ರದಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ಭೂಸ್ವಾಧೀನ ಕ್ರಮದಿಂದ ಬಿಡುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. Now may kindly see the ultimate consideration. None of my objections has been discussed and considered in the page number 68 and 69. ಇದರಲ್ಲಿ ಜನರಲ್ ಆಗಿ ಬರೆದ್ಬಿಟ್ಟಿದ್ದಾರೆ ಹೊರತು ನಂದೇನು ಅಬ್ಜೆಕ್ಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ. ಸ್ಪೆಸಿಫಿಕ್ ಅಬ್ಜೆಕ್ಷನ್ when the land has been, because my lords, under section 5 of the Facilitation Act, KIDB executive director is a member of the station level committee.
Correct. Yes, sir.
Yes, my lord, I have filed the objections, my lord. In the objection, they are saying in the petition, they are saying that Venkata Ramaya, the notice was served to the children's, my lord, because in the RTC was stands in his name. Hence, notification was issued in the name of Venkata Narasimhaya. And they have, the children's of them has filed an objections, my lord. Objection was considered and passed an order, my lord. Regarding they have saying that they are running they are intended to start an industry. My lord, in this regard, my lord,
industry ಯಾಕೆ ಸ್ಟಾರ್ಟ್ ಮಾಡಲಿಲ್ಲ?
They wanted to start an industry, my lord. There's no such industry is running. If their industry is running, my lord, we will not going to acquire those lands. There is a notification. Even Sikh industry also, my lord, we will not going to acquire all those land, my lord. Then the other point, my lord, they have raised regarding the award, my lord. Award, my lord, we have already sent, my lord, for approval of that, my lord. Even 29(2) also it was decided.
Why did you serve it on a person who was no more?
No, children have served, my lord.
ಎಲ್ಲಿದೆ?
They have filed the objections. Kindly see.
Award objection ಹಾಕಿದಾರಾ? Notice objection ಹಾಕಿದಾರಾ?
In my statement of objection, I have produced before this court on page number 5, my lord. 28/4/2022. The elder son on behalf of my family, legal heirs.
Page, sir.
Page number 5, my lord, in the objection statement.
And that is there. For preliminary notification.
Objection statement.
Yes, ma'am.
Objection statement. I have also produced that, my lords.
ಮತ್ತೆ ಯಾಕೆ ಸರ್ವ್ ಆಗಿಲ್ಲ ಅಂತ?
Preliminary notification objection ಹಾಕಿದ್ವಿ. Objection consider ಮಾಡಿದ್ರೆ ಆರ್ಡರ್ ಮಾಡಿದ್ರು.
Considered and we passed the orders.
That's what exactly I am trying to submit before this court.
And my lord, he wanted to start an industry, my lord. And alternative lands, even we will develop the land, we will give, my lord. Let him start the invention in that land, my lord.
But industry start ಮಾಡಿದೆ ಕಾರಣ ಇದೆಯಲ್ಲ, COVID.
Lord, that's we are going to give in the objections we said ಎಕರೆ ಒಂದಕ್ಕೆ 10,789 ಚದರ ಅಡಿ
ಅಲ್ಲ ಬೇರೆ ಲ್ಯಾಂಡ್ ಕೊಟ್ರೆ
ಜಾಗವನ್ನು
ಈಗ ಏನಾಗಿದೆ ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ಡ್
and position also taken
by KD.
Yes, my lord. and hand over to the
Any
board.
other land?
My lords, the problem is this, my lords, I'm already running an industry. It's only an extension of that industry.
Running an industry again,
There's no running
I have produced all the proposals in the additional document that I have produced, my lords. It's a project proposal itself has been given in that fashion. I have- may
Brochure
kindly
is
see
a
that I have
style.
an-
Where is the industry running?
Lords, the industry is running at a different place, but I would, my lords, may kindly see that I have produced already we are the defense component suppliers. I have produced all the document and the additional document I have produced. The my lords may kindly see this filed on 21/3/2025. Additional list that I have produced along with an IA.
But this is where, nothing has happened in this land.
No, nothing has happened in this land. Nothing has happened in this land. But we got obtained a permission to set up an additional industry in this land only.
How many acres is this land?
7 acres and onwards. Because that's an extended component with, my lords, may kindly see the project approval as annexed.
Reason for acquisition is that you have not started the industry.
We have not started the industry. Inta ಇಲ್ಲಿ ಬರೀತಾರೆ ಆದ್ರೆ ಅದನ್ನೇನು ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ.
I will see. Heard reserved. Yes.
One submission is but the executive director of the KIDB under section 5 is also a member of the committee. That is known.
Committee.
May kindly.
Next.
May kindly, Macho.
Lords, I appeal for the respondents.
Krishna, my lord. Lord, a few dates, my lord.
Only 2 dates, huh?
Few days.
Few days. Yes.
Preliminary notification 22/9/1970. 15/7/1971 final notification. Till today, no award is passed. Possession is not taken. I have filed their, with a memo, I have filed their.
Then National Highway Authority, huh?
ಇಲ್ಲ, BDA.
BDA. ಗಿರಿಧರ್ ಯಾರಿಗೆ?
ಗಿರಿಧರ್ ಬಂದಿದ್ದಾರೆ.
For the auction.
ಅದ್ರಲ್ಲಿ ಏನಾಗ್ತದೆ? Short point is this. I am restricted to survey number 54/1. Initially, I had said 54/1 and 54/2. I have deleted 54/2 from my writ petition. Now, this portion has been abandoned. Nobody has taken it. Now, BDA says that we have allotted site number 828 to Mr. Giridhar's client. I have taken a copy of the master plan which I have produced. There is no 828 in the master plan. All that I want, if the BDA, now BDA says we have allotted the land in 54/2 and 55/6. I am not concerned. I am in occupation of 54/1. If the master plan is there, that 828 will not be there. If the BDA can produce it, the matter itself can be closed.
It is also my case, my lord. It is in 54/2 and 56/1. I have also conveyed this property, and that's my statement of objections also. Now, my lord, there seems, and my lord, the piquant issue here, my lord, is that the petitioner, though says that his property is in 54/1, in his pleadings, he says that the very same site which is sold to Giridhar's client is his property. Now, there's an issue of identity
That
itself.
is which survey number?
He says now he says it's 54/1. Let us assume, my lord, it's 54/1. But identity itself is in question now. It is his case that his site, which is before this, which he says that is going to be demolished or allotted to the third parties, is a very same site which is belonging to Giridhar.
Why am I saying this?
No, my lord, identity itself is
54/1.
Produce ಮಾಡಿ.
54/1, Giridhar's
May I
client
just make
started
one
digging and
submission?
putting up rights. The
May I
only thing
make
is
one
they produced
submission?
master plan.
Yes, Giridhar sir.
My lords, the petitioner before this court is a purchaser of acquired land, my lords. He has no locus to file the writ.
Yes, I'll come to that.
His
No, no.
predecessor
ಅದನ್ನ
title
ಹೇಳಿ
does
sir,
not
first.
challenge.
First ಹೇಳಿ sir.
52 ವರ್ಷ ಆಗಿದೆ.
ಅಲ್ಲ, first come to the
No,
point.
first a few facts, then I'll come to
No,
that.
no, you,
That was the point.
come
My
to
lord,
that.
the fact that a purchaser.
Preliminary notifications.
I am not challenging the notification. I am not challenging the final notification. This division bench of this court and single judges have entertained writ petitions by subsequent purchasers
sir.
and granted reliefs.
No.
The reason is, as between me and the landlord, it's a valid sale. As BDA has not acquired, and because if I'm not challenging the acquisition, and if the BDA purports to allot site number 828 in my site, it's an illegality. If they produce the master plan, my lord, if you
When did you purchase the property?
95, my lord.
4/10/1995, my lords.
410?
4/10/1995. Two people purchased properties.
Annexure C, my lords.
What is the date of the preliminary notification?
22/9/1970.
71.
final notification 15/7/71. And no award, no possession taken till today of 54/1, which is as per the BDA record.
No award, no possession.
No award, no
4/1,
possession.
let him be specific now.
54/1.
One.
Survey number.
54/1.
All right.
My site measurement is 40 feet plus 30 feet into 25 feet. Well, and in the master plan, which I have managed to get and produce before this court, 820, now Mr. Giridhar's client is building on my property. I should, BDA by saying that this is the property, cannot force a citizen whose property is not acquired to go to a civil court and pay court fee. If they produce the master plan and show 828 there.
ಈಗ 54/1. Your site number ಏನು?
My site, my 898. 898 in survey number 54/1.
As purchased on 4/10/1995.
No, my lord.
54/1.
Yes.
My lord, the sale deed is produced before this court. There is no mention of survey number. May I request to kindly take Annexure C, my lords, and Annexure D, page 42, my lords. Annexure C, my lords, page 28. My lords will get the schedule at page 38, my lords.
Yes.
All that piece and parcel of house bearing HSP old Khata number 898, new Khata number 1891/898, new Tipasandra village, Kerpalli, Hubli, measuring east to west, north to south, so and so. Even the sale deed of his vendor is not reflected. And in the present writ petition, that sale deed of 1947 of his vendor is not produced.
The BDA says that.
No, how did your vendor come into possession?
There is no statement, my lords. The vendor only claims to be the owner of the property. May I request this court to kindly take internal page 3, running page number, my lord, 3 of the sale deed at page number 32, my lords.
Yes, vendor's absolute owner, so and so, so and so, so and so.
That's all, my lords. There are two, even in the next sale deed also, it starts, my lords, at Annexure D.
Annexure?
Annexure D, my lords, the next page at page number 42.
4th October 1995. What is that?
Yes, internal page 3, my lords. Vendor is the absolute owner of the scheduled detailed property bearing Khata number so and so.
My lord, the BDA
One minute.
One minute, sir. Scheduled to that sale deed is at internal page number 8. There is no mention of survey number. There is no mention of the previous sale deed of Kenchamma. That sale deed of 1947 is not produced in this present writ petition. Then, my lords, may I request this court, my learned friend said he has not challenged the acquisition. I will read out, my lords, some paragraphs in the writ petition where specifically they have challenged that the acquisition has lapsed.
Maybe you should have said abandoned, not lapsed.
No. I specific word lapsed, my lords. First is paragraph.
Abandon. You can't question, sir.
No, my lord, one submission. Please, just may I request your lord.
May I just finish, my lords? If my request, bear with me. My lords, page number 12, paragraph 4A of the writ petition, my lords. Third line.
Yes.
Petitioner and his predecessors are in settled possession for a period of 5 decades. Then paragraph 5, third line again. In respect of a layout has lapsed and further held that the respondents have no authority to take possession nor auction the property at any length of point in time. Then paragraph number 6, my lords. Again, the last 3 lines of paragraph 6. Petitioner submits that petitioner and predecessors are in settled possession of the property since 5 decades. Now, insofar as the ground is concerned, my lords, ground number 10 at running page number 12, my lords. Last 5 lines of paragraph number 10. BDA is required to take action for dispossession before the civil court or initiating proceedings under the Public Premises Act. Then, my lords, ground number 11. The entire scheme formulated by the first respondent has lapsed after the period of 5 years from the date of the declaration under section 27 of the BD Act 1976. As a provisional plot is clear, second respondents failed to execute the scheme. Substantially, the scheme shall lapse in the provisions of section 36 become operative. The second respondent, though has issued directions as way back as in declaration as in 1971, has not recovered possession and executed the scheme in respect of so and so. Therefore, in law, the right of the second respondent ceases on the lapse
One document. one document.
ಅಲ್ಲ
I-
books ಅದ
Paragraph
I
number
get that.
12. Paragraph number 12, my lords. Third
ಆಯ್ತು.
line, the respondents have
Next,
not
next.
executed the same substantial. My lords, they have claimed that. Now may I request this court to kindly see the prayer in the writ petition.
Yes.
My lord should get that at page number 21.
Yes,
My
yes,
lords,
sir.
what they cannot do directly, they cannot do indirectly. They know they cannot challenge it. My lords, prayer 2, my lords. Declare that the respondents have no right whatsoever over the petition schedule property comprised in so-and-so survey number so-and-so, pursuant to the final dated notification dated so-and-so as at annexure S. My lords, even if this court gives a declaration, the court still can't hold he's the owner. The object of this declaration still doesn't take him anywhere near ownership. Kenchamma has not challenged it. He is a purchaser 25 years after the acquisition. The only person who can challenge it is not before the court. My lords, my colleague is there, my lords. There are 5 judgments of the Supreme Court, my lords, on the issue. My lords, starting from 2008 SEC. May I just
One
request
fact
prosecutor,
mentioned.
All right, now, yes, Srivastava sir.
Please see the memo dated 4/11/2024 I have filed
Of,
in this writ petition where it's a category of record A of the BDA of the village.
one నిమిషం. Page, which memo, sir?
It's a memo dated 4/11/24.
So that is a 54/1.
That's what, sir. 1 minute, I'm coming.
4/11/24. All right, yes.
My lord, one submission.
My lord,
One ನಿಮಿಷ.
ಅಲ್ಲ,
I'll get-
ಅದಕ್ಕಿಂತ ಮುಂಚೆ before he shows those
54/1.
memo. 54/1,
One
my lord,
minute,
is
sir,
not a
I'm
subject
not
matter of
talking of
petition.
any other survey number except 54. I'm not talking of any
Sir,
other
wait.
survey number
Ah,
except
ಹೇಳಿ.
54/1.
All right.
54/1 Kenchamma. 2 acres 29 guntas, date of award passed. Your lordship has it. ನೋಡ್ಬಿಟ್ರೆ it's a long piece of paper like this.
ಕೊಡಿ ಅದು. I don't get that at all.
ತಗೊಳ್ಳಿ. Kenchamma 54/1, no award passed, no possession taken, built up. My case is that this 54/1, no further proceedings after the final notification was ever taken. And now what is happening
That
is,
Kenchamma can challenge.
no, my lord, may I make a submission? This
No,
also,
Kenchamma can
may I
challenge.
make a submission? My lord, as between.
And at the outset, your sale deed nowhere refers to 54/1. You show me one word of 54/1 in the schedule.
My lord, may I make, very well, I can't show it. My lord, in the master plan, if there is 828, my lord, I will withdraw the writ petition. In the master plan, there is
Not necessary.
very well.
Subsequent purchaser, ಅದು 25 years after the acquisition.
52 years. My lord,
52.
my lord, even after 50 years, they have not passed an award in respect of 54.
Kenchamma will tell that, sir. Why are you?
My lord, may I just point out a few judgments where this court has.
Oh, please, sir. Subsequent purchaser can challenge ಅಂತ ಒಂದು ಕೊಟ್ಬಿಡಿ sir.
He's a rank of a trespasser.
Give it.
Court. None they did.
A purchaser of a property pursuant to preliminary notification itself has no right to challenge.
No, my lord, that also was raised by the BDA, the division bench has said.
Yes, sir.
1 minute, where is my copy? Here, my lord, please come, first one, it's a division bench of 2015. May I request your lordship to come to.
Nagarajan. ಅಲ್ಲ, ಅದು ಕೊಟ್ಟಾಯ್ತು. That is subsequent.
Paragraph 5, second page. The appellant BDA contended the writ petitioner being the subsequent purchaser after initiation of acquisition proceedings has no right to challenge the acquisition proceedings, and BDA having taken possession, writ does not lie.
Supreme Court has said so, sir.
Then, my lord.
Yes.
Recently, my lord, if your lordship sees.
You mean to say a subsequent purchaser after the preliminary notification or the final notification has a right to challenge?
Provided if possession has been taken and award has, because acquisition ends with the possession being taken. Here, the acquisition is abandoned at the final notification stage as far as I am concerned. But as
Where is it?
As between me and.
Where is it?
My lord.
Where is it abandoned?
My lord, they have not, after 50 years, they have no award is passed.
54/1 ಅಲ್ಲಿ ನಿಮ್ದು 54/1 ಎಲ್ಲಿದೆ?
ನಂದೇ 54/1.
ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ 54/1
898 ಇದೆ, ಅವ್ರದ್ದು 828.
54/1 ಎಲ್ಲಿದೆ?
My lord, what happens is, my lord, the BDA as giving a fictitious number 828, which doesn't exist on the master plan. I produced a copy of the master.
Fictitious number sale khata number 898 ಅಂತ ಇದೆ. ಅದನ್ನ you are projecting to be.
ನಂದಾಯ್ತು ಸ್ವಾಮಿ, BDA 828 ಅಂತಾರೆ, ಗಿರಿಧರ್ ಅವರು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತಾರೆ. It is not in the master plan. Well, I am just a citizen is forced to go to a civil court, my lord, for something which the BDA should, if the BDA can show 828 on the master plan, I'll withdraw the writ petition. It doesn't exist, my lord. That 828, they're trying to knock off that.
That's all it, that is BDA's part. In your sale date, 54/1 doesn't exist.
898 is a.
ಅಲ್ಲ 898 ನಂಬರು ಇಲ್ಲ,
898 ಇದೆ ಸ್ವಾಮಿ,
ಖಾತಾ ನಂಬರ್.
Our site number is 828.
828 ಇಲ್ಲಿದೆ ಅಂತ ತೋರಿಸ್ಬಿಡ್ಲಿ, ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ಇಲ್ವೇ ಇಲ್ಲ. And now using that, they're coming, forcing me to go to a civil court. Well, this can be sorted out at before your lordship by just producing the master plan. Then it will save a lot of litigation.
First I have to answer your right.
Cannot lay, my lords, my
Your
lord.
right to challenge it, sir. Yes, Giridhar sir, what are those judgments?
Cannot, my lords, the judgments of the Supreme Court, my lords. May I request this court to kindly
Division
take.
bench will come to Supreme Court, sir.
All Supreme Court judgments only, my lords. My lord.
Right, yeah, all the judgments here.
All the judgments I don't think there's any judgment there which says that possession and award is not passed, possession is not passed.
Let the landowner come, sir. Landowner should, subsequent purchaser cannot.
But she's
That's
not
all the
alive.
judgments and abstracted the relevant paragraph
Not
of the
aware is a
judgment.
different thing. We can't answer your claim in her right.
No, but as between her and me, title has passed. As between her and me, just
That's
like
all right. That is
jurisprudence.
between you and her.
My lord, therefore, it's now I can step into her shoes.
No, no, sir. No. Partition suit ಅಲ್ಲಿ
What else do I do?
partition preliminary decree purchase ಮಾಡ್ದಂಗೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
My lords, my learned friend cannot lay this down for a benchmark for filing a civil suit tomorrow, my lords. This has to be conclusive settled. That is what my learned friend is trying to infer.
Yes, sir.
My lords, in fact, the Supreme Court goes to say he can at best claim the compensation which was not claimed by his vendor, my lords. That's all.
No, my lord, I don't think that may be very well, my lord.
We'll answer it.
I will
There in the judgments.
My only submission is, after the preliminary notification, no action being taken by the BDA.
Will give you a right to challenge it.
Yes.
Yes. Address out.
Grateful.
My lord, till your lordship passes orders, the interim.
Our interim order ಇದೆಯಲ್ಲ, interim order subsisting will continue till the disposal, the pronouncement of the order.
Grateful.
Till the disposal of the petitioner. Yes.
11.
Madam, previous matter.
But petitioner is the owner of the land. In survey number 164/2 of Bagpadi, Ulupadi village, blood Bangalore Taluk. Extend blood 4 acres.
Sections ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದೀವಿ. There is 14 years delay in filing the writ petition.
Yes.
My lords heard for
But I am
some
sure,
time.
my lord, there is absolutely no delay. I will convince your lordship. He cannot say so. But I will convince your lordship. Kindly take some dates, my lord. It will indicate who is blood, who has come, blood, who has blood caused delay. Lord, kindly see synopsis ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರಿ.
Good up, sir.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಲ್. But 19/8/2006 EC, my lord. On 19/8/2006 EC preliminary notification, 3-1 notification, 1-3 notification under the KRDB Act. My lord. 31/10/2006, my lord. 28/3 order is passed. Kindly note, on the same day, notice, on the same day, 31/10 order is passed.
You gave some judgments on the last.
My lords, yes, it's there.
ಎಲ್ಲಿದೆ?
But I have the judgment, my lord.
ಕೊಡಿ, ನಿಮ್ದು ಕೊಡಿ.
Yes, yes.
Put it. Latest judgment on the hand, my lord. KRDB Act also, my lord, by Supreme Court. Put it. I am not subsequent purchaser.
The issue is only delay.
Issue is delay, my lord.
You are not a subsequent purchaser.
No, my lord.
All right.
Question is, my lord, issue whether delay can be caused by me or by KRDB. Not 31/10/2006 CC, my lord, 28/3 order, which is quashed by this court, my lord, in 2011. Kindly take the list of citation order, my lord, though KIDB is a party, it did not disclose the same, not before this court while filing reply. Kindly take page 127. The very notification is quashed by this court. Page 127, my lord.
Yes, 1 minute.
Same question. ಇದಾದ್ಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರು?
120.
7, my lord, in my list of citation. 28-3 order is passed on 31-10-2006 on the same day.
ಇದು 20 minutes ಅಲ್ಲಿ ಆಗಲ್ಲ. I have a part matter 12 o'clock. We'll take it on Tuesday. Then I'll go through and come.
ಅಲ್ಲ, in fact.
Delay ಒಂದೇನಾ ನಿಮ್ದು?
ಅಲ್ಲ, in fact, my lord, the petitioner himself has produced, my lord, records showing that, my lord, he has participated in 28-3 inquiry. He was heard, and considering the objections, my lord, 1
He
acre
has
of.
challenged it after 14 years.
Yes, yes, and continuously he is, my
but
lord,
I have
and even
question-
otherwise,
Lord, I
in
have
2023 January, we have issued 12-2 notice to him. And, my lord, this writ petition is filed in December 2024, my lord, where there is a delay of about, my lord, 1 year, 10 months again. And, my lord, the petitioner has been, my lord, hesitating this matter. 1 acre land we have excluded, my lord. He says that he's a running industry. That 1 acre land in survey number 164/2 and entire, my lord, 2 acre 11 guntas in survey number 232 has been excluded, my lord, considering the fact that there is an industry. And, my lords, he has participated in the 28-3 inquiry. He's, my lord, thereafter, my lord, he has received, my lord, 9 and 10 notices in 2022. He filed.
You filed synopsis, dates of events?
Synopsis. And, my lord,
I'm
he
ready,
files.
sir. No delay on my part. I'll convince you, lord.
Tuesday.
What difficult at all.
ಅದು
List on
Tuesday ಇದು ನಾವು synopsis ಒಂದು ಸ್ವಲ್ಪ, my lord, I will modify.
modify ಮಾಡಿ ಕೊಡಿ. 12 o'clock there's a matter, so
My lord, may
be able to. Tuesday.
my synopsis and list of citation may be taken on that.
Tuesdays.
Yes.
Tuesday in the same stage, yes.
My lord, may interim order may be continued.
Interim model will continue. Next.
Position 2010 ಅಲ್ಲೇ
ಆಯ್ತು. Tuesday ವರೆಗೆ wait.
Position ಅಲ್ಲ, ಈ
Correct, synopsis ಒಂದು ಹಾಕ್ಬಿಡಿ.
My lord,
Heard the learned senior counsel, Ms. Bhagwat appearing for the petitioner, learned senior counsel Basavaraj Shabrad, representing the board, Allah,
Yes.
KIDB, to hear them further, list the matter on Tuesday.
but award is passed.
Interim order subsisting will continue to the next date.
But award is passed on 22 against all properties after not 14 years, 15 years.
Your lordship have posted it to, my lord, Tuesday. We can argue with that.
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, ತಾವು ತಮ್ಮ ಮುಂದೆ
We'll see, yes, yes.
It's a case brought to be examined, whether I
Yes.
win or not is a different.
We will examine it. Yes.
I am for the petitioner, my lord. I am filing memo for dispensation. to
End
respond-
dispensation now.
To respondent number 5.
12
PDO,
ಅಲ್ಲಿ
my-
dispensation.
For fourth
Oh,
respondent.
notice not ordered to R4 and R5.
Please, my lord.
Counsel for the petitioner files a memo seeking dispensation of issuance of notice to R4 and R5.
R5, my lord.
R5, the same is dispensed at the risk of the petitioner. Interim order ಇದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ ಅವರೇ.
ಏನ್ fresh matter ಆ?
ಹೌದು ಸರ್.
ಏನು?
For the purpose of widening of road, my lord, the respondents have acquired 1,260 square feet, my lord. And checklist was prepared for 3,09,126. And they have reduced the,
ಏನ್ represent full acquire ಮಾಡಿ ಅಂತನಾ?
ಮುಂಚೆ ಮಾಡಿದ್ದು ಈಗ 150 ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಅಕ್ವೈರ್ ಮಾಡಿದ್ರೆ ಫುಲ್ ಮಾಡಿ ಅಂತ ಇದ್ದೀರಿ.
check, ಸ್ವಾಮಿ ಅವರೇ, checklist ಗೆ ಅವರೇ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Consider ಮಾಡಿ ರಿಜೆಕ್ಟ್ ಮಾಡಿಬೇಕಾದ್ರೆ.
ಇನ್ನು ಆ ಕಡೆ
Of course, sir. Yes. The petitioner is before this court seeking the following prayer. The petitioner is said to be owner of the land measuring 1260 square feet out, which was notified for acquisition, and only 150 square feet is said to have been acquired. Representation is submitted seeking acquisition of the entire amount of entire land as it has become of no use for the petitioner today. In that light has submitted a representation. The representation of the petitioner is yet to be considered, though submitted on 10/1/2024.
Please, ma'am.
In the light of the prior being innocuous and the submission of the learned HCGP, that the representation will be considered on its merit within 8 weeks from the date of receipt of the copy of the order, within a reasonable time. I deem it appropriate to dispose the petition with a direction to the respondent VDA to state to consider the representation of the petitioner so submitted on 10/1/2024 in accordance with law, within an outer limit of 8 weeks from the date of receipt of the copy of this order. It is made clear that this court has not pronounced upon the merit of the claim of the petitioner. Next.
Much obliged.
13.
Petitioner, my lord, IA number 1 for dispensation
I
of.
seek for 2 weeks' time to file my statement, my lords. The issue is only this, my lords. The petitioner is before this honorable court on the ground saying that 6 kunta of land, which was total 10, 20.
File your objection. Yes.
My lord,
Learned counsel for respond
my
2
lord,
and
in
3.
this, my lord,
BDA, na?
My lord, one submission, my lord. In this case, my lord, there is no interim order and the adjacent properties are getting demolished, my lord. I'm in well-established possession since past 25 years, my lord. Some
Learned-
protection, my lord.
Learned counsel for the respondent 2 and 3 seeks time to file statement of objections. Till the filing of the statement of objections, no precipitative action shall be taken, qua the property of the petitioner.
Please.
Yes. List after 2 weeks. Next.
Utilization of land without acquisition.
Just council has, my lord, served copy, my lord, complete copy.
You have
But we
done a
need
good thing.
some-
What?
No,
Yes.
so just, my lord, 2 weeks' time maybe for filing statement of
Yes, sir.
objection.
Then Sachin copy ಎಲ್ಲ serve ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ?
No, no, he's served.
ಕೊಟ್ಟಿದ್ದಾನೆ ಇನ್ನೊಂದು ಕಾಪಿ ಬೇಕು ಅಂತ
Served,
ಹೇಳಿದ್ರೆ
he's
ಇನ್ನೊಂದು
served.
ಕಾಪಿ.
No, 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 earlier was not complete. Even impugned annexure was not there. But later, my
No.
lord, he served and
ಅದೇ
I have
done
received
something
complete.
unusual. So the petitioner. ಅವ್ರು ನೀವು ಹೇಳಿದ್ದಾಗಿತ್ತು.
No, no, he served
The
immediately.
learned counsel for the respondent submits that copy has been served upon her now and would seek 2 weeks' time to file statement of objections. Objections, if any, by the next date, list the matter on 31st.
Great.
For the petitioner, my lord, I appear for respondent number 2 and 3. I seek for time to file.
ಸಂದೇಶ್
objection.
ಚೌಟ ಸರ್ ಇದಾರ? Land acquisition.
My lord, I seek for 2 weeks' time to file objections. my lord.
File?
Objections, my lord. And our name may be shown in the cause title. Pradeep's name is showing.
Registry to print the name of Bibi Patil
Please.
in place of HL Pradeep Kumar, who is said to have entered appearance. The learned counsel for the respondent Bibi Patil seeks 2 weeks' time to file statement of objections. Again, list the matter on 31st. Objections, if any, by then. Interim order subsisting will continue till the next date.
31st, we have some inconvenience, my lord, so.
Why, sir?
Jai Nandalike is not there on that, my lord.
Any day, week after.
ನೀವಿಬ್ರಿದ್ದೀರಲ್ಲ?
So maybe
Yes.
posted on first week of.
After a week, your lordship may have.
After?
Week.
8th,
After a week. my-
6th, 7th August.
Great. Interim order, my lord.
Objection. Continue. Next. Oyo.
Short accommodation, my lord.
My lords,
Senior
the
some-
entire dispute between the parties is now before the arbitrator, my lords. If I point out the claim statement, probably nothing survives in the criminal matter as such.
As we may granted a short accommodation, my lord, till
Madam,
canvas.
how many times to hear?
As a last chance may be granted.
I have heard Prabhu sir at length.
My lords,
Him also at length. It's
as we will be able to.
prima facie, it's an issue with regard to recovery of money,
And also
which
charge.
is pending before the arbitrator. Even otherwise, it is settled principle that for recovery of money, you can't set the criminal law into motion, correct?
My lords, we will be able to canvas before your lordships, my
ಅದೇ
lord. There is more
ಆಗೋಗಿದೆ
to it.
ಅದೆಲ್ಲ. Yes.
That's one last chance may be granted.
ನೀವ್ ಯಾರಿಗೆ? ಅವ್ರಿಗೆ.
In fact, synopsis is there, the
No, he was
judgment.
here. I thought he's both sides.
We prepared a synopsis and the judgment supporting it, my lords.
Lalit Chaturvedi.
Number of issues, my lords. One is to say that predominantly of a civil nature, criminal law cannot be set into motion. The other ingredients of the offences are totally lacking.
406,
And the-
420.
Yes, my lords, and totally vexatious, my lords, where they have gone in for civil proceedings, they were unsuccessful before NCLT, then come with the criminal proceedings. And in the end of it, they say benchmark has not been paid to us. We are entitled so much money, which is subject matter of what is happening before the arbitrator now, my lords.
Similar cases quashed under my orders.
No, my lords, it was His Lordship Justice Hemant, my lords, 2 matters.
My lords, in fact, the charge sheet,
And in fact, my lords, now quite recently, Supreme Court, my lords, when they say civil cases registration of FIR They imposed a cost of about 50,000 on the state of UP, my lords. That's also one judgment which we have put.
That's a daily order.
Allah, it's come in the main order. It's
Kodi. ಈಗ CPC ಗೆ ಬಂದ್ಬಿಟ್ಟು ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ.
My lords, in serial number 5.
You already placed it?
You want to give this? Okay. My lords, we have that compilation. We will mark the relevant portion. Give the relevant, give this.
That's
The
better.
relevant portions are marked.
ಅದನ್ನ ಇದು ತಗೊಳ್ಳಿ, ಅದನ್ನ ಮಾರ್ಕ್ ಮಾಡಿ ಕೊಟ್ಬಿಡಿ ಇದ್ರಲ್ಲಿ.
ಇಲ್ಲ, mark ಆಗಿದೆ. I've got it set, my lords. I've also got it.
ನೀವು ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲ ಹಾಕ್ತೀರಾ ಮಾರ್ಕ್ ಮಾಡ್ಕೊ.
Yes, my lords, it's marked. I have marked that. ಅದರಲ್ಲಿ serial number 5, my lords, 18th April 2025, Recap versus State of UP. In that case, my lords, page 33, the court imposed.
Page 32.
How? They imposed a cost of 50,000, paragraph 27
Yes,
and
Sanjeevi madam.
29.
My lords, one last chance may be granted, my
Where is
lords.
sir?
My lords, he's on his legs, my lords.
Get him, pass.
Pass
Ask him to come at 5 o'clock.
Great.
4:45 or 5 o'clock.
Great.
Yes. But there's nothing.
My lords, in fact, there's a
You'll-
judgment of your lordships, my lords,
Ah,
wherein,
Kodi.
in fact, learned senior counsel was on my part, he was the respondent number.
He would have appeared for the respondent there.
The latest one is where my lords held both, it doesn't go on the size of the complaint or the size of the charge sheet. What needs to be seen is it a case of clever drafting for the complaint, my lords? That's my lord's judgment.
The offense is also similar in this matter, my lords, 406 and 420, my lords.
Their offense did give rise, madam.
My lords, in this matter as well,
No,
charge
that is
sheet.
forgery, madam.
My lords, in this also, there's been,
Here is case of breach of trust, cheating, correct? And also mischief, my lords, and criminal intimidation. That these are the 4 offenses that are
You had
listed.
appeared for the complainant there. That is why that's being shown. No, there was forgery. Oh, there's so many serious things in that. Which is this, Jaikumar S. Patil sir had appeared. That society matter, yes. The trust went on forging signatures and buying
Signatures,
things.
yes, my
Yes, that's the one.
pass over. My lords.
4:45. Yes.
May have it on Monday, my lords. We will-
Monday ಆಗಲ್ಲ, ಇರ್ಲಿ. List ಅಲ್ಲಿ ಇರ್ಲಿ ಬಿಡಿ. Yes. Whenever he finds time, come. Ask him to come, but today.
Please.
Yes.
Oblige.
C group 17.
This
ಏನ್
case,
ರುದ್ರಪ್ಪ ಇದು?
that they have filed, my lord, the challenging the order passed in, my lord, AC 15 of 2018. Lord, they have sought, my lord, interim order before this honorable court. Kindly see,
They have sought and they have granted.
granted. Ultimately, my lord, that they have admitted that I am entitled 50% by filing statement of objection. 50% amount may be released. With the time frame period, they have said they have filed suit for
ಆಯ್ತು,
declaration.
ಇನ್ನು NHAI ದುಡ್ಡು, wait.
ಅದೇ ನಮ್ದು for a moment, my lord, kindly
ಈಗ ಸ್ಟೇ ಇದೆಯಲ್ಲ, we'll take it on Tuesday.
serial 38, my lord, that they have cleared.
Tuesday. 17, 18, 19, Tuesday.
Interim order may kindly be extended.
Interim orders will continue. Yes.
My name may be deleted.
ಯಾರು ಶಿಲ್ಪಾ ಮೇಡಮ್ ಇದಾರಾ?
Shilpa Shah, her name has to be.
18 ಅಲ್ಲಿ registry to delete the name of Shobhit Shetty. Next 19, all on Tuesday.
20.
Madam, you need some more time to file objections?
20 I am applying for.
They have filed.
ಅಲ್ಲ, 18 ಅಲ್ಲಿ ready, Tuesday will take.
20.
20 I am applying for petitioner, ma'am.
15th, madam. 17th. Yes, 17th.
Please.
19.
Yes, sir. ಇದು ತಗೊಂಡಿಲ್ಲ.
But ಏನಾಗಿದೆ 19 ನಲ್ಲಿ there's a clear direction in writ appeal that garden lands must be deleted in pursuance of the judgment. But
In pursuance of what judgment? Circular.
earlier judgment.
Sitting in division bench, I have distinguished it and said necessary lands in a particular manner only can be done.
Correct.
Where is that judgment?
I'll get. And before the writ appeal, they report that it is garden land. In 2003 also, it is reported that it is a garden land with the number of trees located there, plantation trees. It is very clear that it is garden land. And what the authorities do, unfortunately, 2003, when they did the Mazar lot, they report then itself. And before writ appeal also, court directs, inspect and come back. There also it is reported, it is garden land.
Really? Respondent?
Rejected, my lord.
Huh?
Government has recommendation.
PDA has now said.
PD has recommended, government has rejected.
Government has rejected.
Despite this.
Despite what?
Despite the direction of the writ appeal court and despite it
Where
being
is the
garden land.
direction?
Direction is page number 209. 208, 209. Learned Senior Counsel
Authority itself.
submit that lands held by appellant number 5 and 6 also fall within the exceptions carved out in para B1 for the operative portion of the order disposing of the writ petition. Lands held by the appellants are admittedly garden lands, and the status of the lands has also been confirmed by the BDA in its status report filed before this court.
Yes.
And in that we would
Yes,
submit.
madam. ಈಗ status quo ಇದೆಯಲ್ಲ already. You're
Status
still
quo
in
ಇದೆ.
possession, right?
We are in possession.
File your objections.
Please, my lord.
But the respondents, the state and the respondents 2 and 3 shall file their objections, comma, if any, by the next date of hearing. If the petitioner, status quo ಕೊಟ್ಟಿದ್ದೀನಿ already.
ಕೊಟ್ಟಿದೆ.
Heard the learned senior counsel Vivek Reddy ಅಂತ ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ ಅದನ್ನ ಹಾಕಿ list the matter on 31st objections if any, by then interim order subsisting will continue.
First late ಆಗ್ಬಿಡುತ್ತೆ. Next week it. Any day.
ಚೇಂಜ್ ಏನಾಗಲ್ಲ.
16th.
ಅಷ್ಟು ಚೇಂಜ್ ಆಗುತ್ತೆ ಅಂತಿದ್ಯಾ?
16th.
16th ಬೇಡ, ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕಲ್ಲ. 24th.
23rd, not 23rd. 23rd, please.
23rd ಇಲ್ಲ, 23rd is Wednesday, GMCPC day, 24th.
And surrounding lands are also deleted.
ಆಯ್ತು, all that let, you file your objections.
Please, my lord.
Yes.
Please.
20, hearing on 8.
Yes.
Impleading ಯಾರು?
ನೈಸ್ ನ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕು ಅಂತ.
ನೈಸ್.
NIC. ನಂದಿ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್.
ನೈಸ್ NIC ಅಂತ ಗೊತ್ತು. ಎಸ್.
ನಂದಿ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್. I felt.
ಅಯ್ಯೋ ಅದು ಗೊತ್ತು. ಯಾಕೆ ಎಷ್ಟು ಎಕ್ಸ್ಪಾಂಡ್ ಮಾಡ್ತೀರಾ ಅದನ್ನ ಬಿಡಿ.
ಅಲ್ಲ.
ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಾ?
ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕು. For that reason I filed an application.
Application in IA 21 and 25 will be heard along with the main matter. Are they necessary parties? Agar yes, we'll allow it.
Allow.
May be allowed for the
For
proposal.
the reasons indicated in the affidavit accompanying the application, being satisfied with the same application in IA 1 of 2025, seeking to implead NICE as a party respondent to these proceedings stands allowed.
Here, a niece also, my lord, one more.
Niece allowed?
Covered by.
ಆಗ್ಲೇ ಹಾಕಿದ್ದೀರಾ?
ಅವರೇ ಹಾಕಿದ್ರು.
Both.
You have already filed your wakalat? Sorry.
Yes, ma'am.
So and so. Counsel SB Matapati has already entered appearance for the proposed fourth respondent, who is now the fourth respondent. The petitioner shall amend the cause title accordingly. List the matter on 24th.
Covered by.
24th.
21.
24/4/2025, consideration of interim prayer is kept open, my lord. This is a matter where.
ಮತ್ತೆ ಇದ್ಯಾಕ್, what is this?
The main responding, the contesting respondent is 2 to 4. It's the RCI, my lord.
2 to 4.
Advocate Anup
The authority,
Deshpande appeared for RCI.
Anup Deshpande.
Anup Deshpande.
One minute.
The lordship
Learn-
is correct that we accept notice.
Learned
and
counsel.
share his phone number with the matter.
Yes, yes. Learned counsel Anup Deshpande is directed to accept notice for respondents 2 and 4. 2, 4 or 2 and 4?
2 and 4.
2 to 4. Registry to print the name of so and so is appearing for respondents 2 to 4. 2 to 4. Petitioner to serve set of papers upon the aforesaid counsel forthwith. List the matter on next Thursday.
The orders list for consideration of.
Yes,
interim prayer.
correct, sir. List the matter on Thursday in preliminary hearing. Yes.
Reporting settlement 22.
Appearing for kindly pass on.
Pass on. All right.
2:30.
All right.
Great.
Further hearing 23.
Yes, Swami.
Please, my lord. In this matter, please, my lord.
Warrant number 11, my lords.
CBI.
Yes, my lords.
ಇದ್ ನೋಡಿದ್ದೀರಾ?
ನೋಡಿದ್ದೀನಿ, I've seen it. Now, your lordship kindly may not show the name of Mr. K.S. Hema.
ಯಾರ್ದು?
K.S. Hema
For
CBI, my lord.
Learned Counsel K.S. Hema accepts notice for the respondent CBI registry to print the name of so and so as appearing for respondent CBI. ಇದು ಮಂಗಳವಾರ ತಗೋಣ.
Please.
Oh, please. Tuesday. Yes. $12.
24.
The only matter left now.
Yes. We are obliged, my lord. It's indeed a privilege assisting your lordship.
Yeah, same here, sir. Yes. ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್. ಆಮೇಲೆ ಒಂದು ನಿಮಿಷ ರಿಟ್
My lord, there are three aspects to this case, my lord. One, my lord, is the interplay between section 79, interplay, my lord, between section 79 and 69A. That's question number one, my lord. The second question that arises for your lordship consideration is rule 3(1)D. The third, my lord, is with respect to what is called as Sahyog portal. Though, my lord, there are three aspects. It is not, my lord, that each one of them is a separate silo. Each has a bearing on the other, but they are intertwined.
Yes.
But there are three aspects. Now, my lord, from what I can see, my lord, and I'm going to take your lordships through the petition, our contention, and the statement of objections, my lord, and also show to your lordship what, according to us, is the law on the point. The entire case, my lord, rests on, if I may say so, a pure question of law. There aren't too many facts that your lordships need to go into in this case. The primary question, my lord, that arises for your lordship consideration is, can 79(3)(b) of the Information Technology Act be said to be a source of power?
Yes.
Can 79(3)(b), even if it is held to be a source of power, be read as a standalone provision independent of 69(A)?
Yes.
These, my lord, are the primary questions. And these questions, my lord, have to be determined in my respectful and humble submission in the context of Article 19(1)(a), read with Article 19(2), and more importantly, Article 14.
Yes.
It is our submission that 79(3)(b) is, first of all, not a source of power.
Yes.
It is next our submission that 79(3)(b), if at all is to be held to be a source of power, it is constrained by the requirements of section 69(A).
Yes.
Therefore, my lord, let me begin by pointing out to your lordships the provisions of law. If your lordships are kind enough, my lord, to take the act, my lord.
Yes, madam.
First, my lord, let me begin by pointing out to your lordship 69A. Oh, I'm sorry.
Yes, yes, it's here. Yes.
Oh, your lordship. Please be kind enough to turn to section 69(A) of the Act.
Yes, sir.
where the central government or any of its officers specially authorized by it in this behalf is satisfied that it is necessary or expedient so to do in the interest of sovereignty and integrity of India, defense of India, security of the state, friendly relations with foreign states or public order, or for preventing incitement to the commission of any cognizable offense relating to the above, it may, subject to the provisions of section 2, for reasons to be recorded in writing, by order, direct that an agency of the government or intermediary to block for access by the public or cause to be blocked for access by the public any information generated, transmitted, received, stored, or hosted in any computer resource. Now, your lordship will kindly see, my lord, in section 69(2),
Yes.
there are several grounds mentioned which can be the basis for the central government to exercise its power to pass what is called as a blocking order. And that blocking order can direct any agency of the government or an intermediary. And I am an intermediary, my lord. That factual situation is not in dispute.
That's Twitter is an intermediate.
Yes, my lord. We are now called X, my lord.
X, correct.
Yes. That X is a intermediary, my lord, is not in dispute. And I showed your lordship the definition of intermediary under the IT Act. Now, my lord, a blocking order can be passed. How can a blocking order be passed is the next question. Can it be done within the confines of the four walls of the chamber of an officer of the government? Answer, my lord, is no. Why do I say that, my lord? Please be kind enough to see subsection 2.
Yes.
The procedure and safeguards subject to which such blocking for access by the public may be carried out shall be such as may be prescribed. Now, my lord, we have the 2009 blocking rules.
Yes.
My lord, what we have done, my lord, is for the purpose of convenience, we have prepared a compilation of all the relevant statutes and rules.
Necessary.
It's very,
Yes.
it will be
So
all
that
in
we
one place. My lord.
Need not flip pages. of
No,
the
my
book.
lord, we
Yes.
don't. Your lordships. In fact, my lord, the first one is what I read to your lordships, section 69A.
Yes.
Then, my lord, your lordship gets the blocking rules. That is the 2009 rules. That
Yes.
2009 rules still continues, my lord. No difficulty about it. Now, my lord, please go to 79(3)(b). If your lordships are kind enough to turn to page 9.
79?
3B, which your lordship gets it in this compilation, my lord, at page 9.
Yes. 1 moment. Huh.
May I trouble your lordships, my lord, to please keep 69A and read it in parallel to section 79, because you will hear, my lord, this central government tell your lordships, and that's what they have pleaded in the statement of objections, that the scope of 69A is very different from the scope of section 79, and therefore 79(3)(b) is not circumscribed by the restrictions contained in section 69A. They, in other words, say, my lord, qualitatively, 79(3)(b) is different from 69A, and therefore do not read into exercise of power. According to them, my lord, is a source of power. What they would tell your lordship is, do not read into 79(3)(b) the restrictions as to procedure contained in section 69A2.
Yes.
Let it be read as a standalone provision is what the union government will tell your lordships.
It is that it should be read as a standalone provision,
Yes.
not a provision that has unbridled power.
My lord, they seem to think that it is unbridled power.
No, that is not the purport. That is not the purport of the objection. The objection is it cannot be read in tandem with 69A.
Yes.
It has to be read independently.
That's right. Now, if it is read independently, then, my lord, a plain reading of 79 will indicate it's unbridled power. No procedure. I'm going to develop that argument, my lord. In fact, that's going to be my submission before your lordships, that a plain reading of 79(3)(b) would indicate that it is unbridled power. Of course, my lord, it has to be read along with the intermediate rules of 2021, namely Rule 3(1)(d). I will come to that.
Procedure is there.
Procedure is there. Procedure, my lord, is there only to the limited extent of specifying some of the grounds specified in 19(2). How it is to be exercised? My lord, it is absolutely silent. That's our grievance, my lord. And as your lordships are aware, my lord, just to preface the submission which I'm going to develop in the course of my submissions, my lord, your lordships are quite aware, my lord, that Article 14, non-arbitrariness, is both with respect to substantive rights as also procedural safeguards. Now, if I am able to convince your lordships that procedural safeguards are absent in the matter of exercise of, I would put it in quotes, power. I am not saying that. I am putting it in quotes because I am quoting the other side. If in the matter of exercising that, in quotes, power, there is no procedural safeguards at all provided either under section 79 or in rule 3(1)(d), my respectful submission is that these provisions are violative, my lord, of non-arbitrary requirement under Article 40. That is the submission. So I want to make one point clear before I make it further, go further, my lord. My lord, it is not our case that a right like the one in the instant case given to an intermediary. And I'll tell you, lordships, what is the right given to you? Your lordships will ask me, what is the right that you have? After all, you are not writing the post. Somebody else is putting the post on your platform. What's your problem? I will answer that, my lord.
Broadcasting.
My lord, I wouldn't even say I'm broadcasting. I'm not even, my lord, I have no control. It's there. That's the power of the internet. Now, my lord, if that's the power of the internet, the question is, can I simply wash my hands off and say, well, even if there is something so offensive that is put on my platform, I say I can't do anything about it. Can I be indifferent? Answer is no. My lord, therefore, my lord, I'm making it clear at the outset, it is not our case that we can do what we want. I have no respect or regard for the laws of the country where I operate. Because, my lord, internet, my lord, as your lordships knows, is seamless. But each country has its own rules and regulations as to how what is good, my lord, in some other country may be offensive in this country.
Correct.
What is offensive in this country may not be offensive in some other country. Every country, my lord. Therefore, I have to obey the law. There's no question about it.
Yes.
But
you may think global, but act local. Important.
And obey local.
Obey local, yes.
That is the point. Act local and obey local.
Yes,
There's no doubt about it. There's no doubt about that. Therefore, my lord, I want to allay any impression, both in the mind of the Union government, as also make a submission before lordships. I know, my lord, your lordships have no impression. I'm making a submission.
Yes, yes.
That we are not saying I am above the law. The question, my lord, is simply as to whether the procedural safeguards contained in 69A, which is significantly absent in 79, will be in accordance with the provisions of Article 14 of the Constitution. That, my lord, is the main submission. There are a few other things, and there are so many other facets to this argument, which I'm going to place for your lordship consideration. Yes. But ultimately, my lord, it all boils down only to that one question. Now, therefore, my lord, I want to show to your lordship what is 79 for a minute. Please be kind enough to turn to page 9 of the compilation.
Yes, I'm there. Should I juxtapose it with the 69A?
Please, my lord.
Yes.
I would respectfully request your lordship
Yes.
to that. I will read 79.
Yes, yes.
Exemption from liability of intermediary in certain cases, notwithstanding anything contained in any law of the time being in force, but subject to the provisions of subsection 2 and 3, an intermediary shall not be liable for any third-party information, data, or communication leak made available or hosted by him. I pause for a moment, my lord, to explain to your lordship what 79(1) really means. 79(1) is popularly called a safe haven provision.
Yes.
In effect, what 79(1) does is to say that If a offensive post is put on my platform,
Yes.
and that offensive post may lead to a cause of action in some other proceeding, I will not be liable. It is a protection given to an intermediary. That, my lord, is the sum and substance, and on that, my lord, there is no
So
quarrel about it.
your suggestion is
Yes.
what comes into your platform and gets displayed,
Yes.
the consequences of that is not upon you.
Exactly.
It-
That is
No,
the
the
purpose of 79.
consequences cannot be saddled on you is
Yes.
what is.
For example, my lord, I'll give you a lordship as an example.
That's the suggestion.
Yes. For example, my lord, there is a defamatory post on my portal. A puts a post on my portal defaming B. There could be an action by B against A. Where is my role in that? The law says you have no role to play. That is why it says, my lord, and notwithstanding anything contained in of the time being in force, but subject to the provisions of 2 and 3, an intermediary shall not be liable for any third party information, data, or communication link made available or hosted by him. So therefore, it is a immunity granted to me from being exposed to an action arising out of a post on my platform. That is subsection 1. Now, subsection 1 itself says it is subject to 2 and 3. And that's where the problem lies, not in 2, but in 3.
Yes.
Manoj, I'll read 2, Manoj.
Yes.
The provisions of subsection 1 shall apply if the function of the intermediary is limited to providing access to a communication system over which information made available by third parties is transmitted or temporarily stored or hosted. Pause for a moment here, Manoj, to see that if I have any role to play with respect to the content of the information, then, my lord, I will be out of 2A. I have no role to play with respect to the information, then 2A will apply. Then, my lord, intermediary does not initiate the transmission, select the receiver of the transmission, and select or modify the information contained in the transmission. C, the intermediary observes due diligence while discharging his duties under this act, and also observes such other guidelines as the central government may prescribe in this behalf. It is this guideline, my lord.
Would you not be aiding the transmission of information?
No, my lord, I do nothing.
No.
I do
It's
nothing.
It's your platform.
That's all.
It passes through your platform.
That's all.
Now you said
Yes.
A defames B.
Yes.
The defamation is not direct. The publication, otherwise earlier it used to be there. Now the defamation comes through your platform. So is it that you're aiding the information
No, my lord, even that is not.
or aiding the act, whatever?
No, my lord, even that is
That's-
not. Because if your lordship will see the
Sorry,
definition.
but I'll keep asking
my
for
lord.
clarification. That's
No,
all.
my lord,
Yes.
I.
Then you should not mind that
No,
I'm
my lord,
cutting
no,
your
my lord.
flow.
No. No, it's in fact, it aids my thought.
Yes.
On the contrary.
Like aiding information.
Yeah.
Yes, sir.
My lord, please, in that, I'll bear your lordship's observation in mind, and I will show to your lordships after I have shown section 79.
Yes.
I will show to your lordship what is the definition of intermediary as under the act.
Yes.
The protection is given to an intermediary,
Yes.
and it is nobody's case in this proceedings, my lord, in this litigation, that there is any the section 7 by virtue of 79(2), 79(1) does not apply, is not anybody's case. So, my lord, that, if I may say so, need not detain your lordships. That I am aiding the flow of information. Therefore, I do not get the protection under 79(1) is not anybody's case.
All right.
That's nobody's case.
No, that's it.
The problem, my lord, is with respect to 79(3).
What is that?
That's the problem, my lord.
Huh.
My lord, kindly see 79(2) says 79(1) will apply in these circumstances.
Yes.
79(3) says it will not apply in these circumstances. Now we are concerned with 79(3). This is the real issue, my lord, in the case. the provisions of subsection 1 shall not apply if the intermediary has conspired or abetted or aided or induced, whether by threats or promise or otherwise, in the commission of the unlawful acts. Possibly this will give some light to the, as an answer to my lord's query. More importantly, the subject matter of the present controversy turns around interpretation of 79(3)(b.
Upon receiving.
Yes, my lord. The provisions of subsection 1 shall not apply. I'm reading it fully, my lord.
Yes, sir.
The provisions of subsection 1 shall not apply if upon receiving actual knowledge or, now that's the question, my lord. Now even that actual knowledge, my lord, is no longer a problem today by virtue of the enunciation of the law by the Supreme Court, my lord, in Shreya Singh's case. I will come to that separately. Even that we are not concerned. Now next point, next aspect of, that is the part B of 79(3)(b, or on being notified by the appropriate government or its agency that any information, data or communication link residing in or connected to a computer resource controlled by the intermediary is being used to commit the unlawful act. The intermediary fails to expeditiously remove or disable access to that material on that resource without vitiating the evidence in any manner. I will analyze this provision, my lord, so that the point I'm going to place for your lordship's consideration is better understood.
Yes.
My lord, first of all, it contemplates a notice to be issued to me by the appropriate government or its agency. And when can that notice be issued, my lord? When the information or data or communication link residing in or connected to a computer resource controlled by the intermediary is being used to commit the unlawful act. That's the second requirement. Now, who will decide as to whether there is a use to commit an unlawful act? If a plain reading of 79(3)(b is adopted, it appears as if the agency of the government or the appropriate government can decide. So therefore, my lord, there is one singular officer who has been designated by the various communications which I showed to your lordships, who will say, well, according to me, this information on your platform X is being used for the purpose of committing an unlawful act. I say so, therefore it is so. That's the second requirement. The third requirement is, we told you this, if in spite of it, you fail to remove, please mark these words, my lord, much turns on these words. If you fail to remove or disable access to that material, then consequence, my lord, is 79(1) protection goes. Therefore, my lord, there is a sanction. It is not an innocuous provision. 79(3), the failure to honor a notice received or issued by the government or by the agency of the government has a sanction behind it, namely you will lose the protection under 79. Therefore, my lord, as an intermediary, I'm saying, look, the government decides everything. The agency of the government, the officer who is nominated, I showed your lordship those notifications, I showed your lordship what they do. That officer thinks that this particular post is unlawful, is likely to create the commission of an unlawful act. That's the end of the matter. You say so, I don't obey you, I lose the protection automatically under 79(1). This is the purpose of this. Now, while on this subject, my lord, what is being told to your lordship is, look at 69A. Please read now, my lord, 69A. Your lordship, make a compare 69A. Page 2, my lord. But 69A tells your lordships the various grounds. Those grounds that are mentioned, my lord, in Article 19(2). And then, my lord, it says it's a direction. Direct any agency of the government or intermediary to block for access by the public or cause to be blocked for access by the public any information generated, transmitted, received, stored or hosted any computer resource.
Yes.
Then, my lord, the procedure is provided for in 69A2. And then kindly see 69A3. This is one of the points that is being told your lordship, that insofar as not complying with a direction under 69A1, the consequence is punishment under 69A3, whereas there is no punishment with respect to section 79. That's, my lord, the argument that is no place for your lordship consideration to say, while 69A uses the word block, your lordships will now see 79 does not use the word block. That is one difference that is being told to your lordships. And I will meet that point. I just want to point out to your lordships what is the difference between the two provisions. Second difference that is pointed out to your lordship is, while 69A is a direction, 79 is only a notice.
Yes.
69A is a compulsion. 79 is a volition. You don't want to obey the notice I have given you. Well, that's your option. But if you don't obey, protection under 79(1) will go, is what 79 says. Therefore, what is told to your lordship is 69A is a direction, 79A is a volition. 69A has a punishment, 79 does not have a punishment. 69A talks about a blocking. The word block is not used in 79. Now, my lord, please contrast 79. The distinction that is sought to be made with respect to the use of the word block in 69A and the non-use of the word block in 79 is actually, my lord, a difference between Tweedledum and Tweedledee.
Yes.
Now, my lord, please look at 79. What is the purport of a notice? What is it that the notice is required to do? And I'm going to read to your lordship those notices that have been issued to me. And it says, my lord, fails to expeditiously remove or disable access. It is true, my lord. Block, the word block is not used. But what does the word block really mean? It means nothing except in disabling access. My lord, this is semantics. And it is this semantics, my lord, they are taking umbrage in to say that 79 is different, 69A is different. And now, before I go to the rules, now, my lord, under 79(3)(b, rules have been framed. I showed to your lordship the rules immediately. But before that, my lord, can I show to your lordships one provision in the rules itself, which I don't think we have put it here. Have you put that
Which rules?
Punishment.
2009 rules or 21 rules?
Act. You not put, no? My lord, in fact, it's not been put. I'm sorry. Kindly see section 45 of the Act. To say, my lord, that there is no penalty provided for non-compliance with a notice under section 79 omits to take note of section 45 of the Information Technology Act. Whoever contravenes any rules, regulations, directions or orders made under this Act, for the contravention of which no penalty has been separately provided, shall be liable to pay penalty not exceeding 1 lakh rupees in addition to compensation to the person affected by such contravention, not exceeding 10 lakhs rupees by an intermediary, company or body corporate, or 1 lakh rupees by any other person. So, can it be said that non-compliance with the notice under 79 is free of penalty. Having regard to 45. It says it doesn't use the word direction as incorporated in 69A. True. But, my lord, it is not simply, it is, my lord, akin to, my lord, Krishna having told Arjuna all that at the end of the day, do whatever you want. But at the end of it, Supreme Court said it, my lord, in Spencer's Hotel case, that this is not to be understood that way.
Yes.
Now, if this is the position, 45 is one very important provision which has a role to play in the understanding of the statute.
So it is residuary penalty.
It
on
is
any
residuary
provision.
penalty for anything. That's why, my lord, it says, whoever contravenes any rules, regulations, directions, or orders made under this act, for the contravention of which no penalty has been separately provided for, unlike under 69A3, where there is a separate penalty provided, you shall be liable to penalty, etc., etc.
Yes.
Now, my lord, I want to take your lordship through the rules. Now that your lordships have seen it, my lord, there are two rules, my lord. One is called the blocking rules. The other, my lord, is in the compilation that we are giving your lordships. My lord, please don't trouble your lordship to even. My lord, the rules are found, my lord, at page.
First blocking rules at page 3.
My lord, I want to show to your lordships the 2021 rules at page 77, the intermediary.
Ethics rules.
Yes, my lord. Yes, it's called the IT Intermediary Guidelines and Digital Media Ethics Code Rules 2021.
Which page do I
Page
get?
77.
70s. Yes, sir.
In exercise of the powers conferred by subsection 1 clause Z and ZG of subsection 2 of section 87 of the Information Technology Act 2000 and in supersession of the Information Technology Intermediary Guidelines Rules 2011. In fact, this is the 2011 rules, my lord, were what was being considered by the Honorable Supreme Court in Shreya Singham. Except as respect things done or omitted to be done before such supersession, central government hereby makes the following rules. Now, my lord, your lordships may skip the first portion of these rules and straight away would your lordship be kind enough to turn to page 82.
Due diligence.
Yes. An intermediary, including a social media intermediary, a significant social media intermediary, and an online gaming intermediary, shall observe the following due diligence while discharging its duties, namely, now, my lord, please be kind enough to turn to D, which your lordship gets at page 84, which is relevant for the purpose of the present case.
Yes, sir. An intermediary.
An intermediary.
Yes.
An intermediary on whose computer resource the information is stored, hosted, or published. Upon receiving actual knowledge in the form and order by a court of competent jurisdiction, or on being notified by the appropriate government or its agency under clause B of subsection 3 of section 79, which your lordship saw, shall not host, store, or publish any unlawful information which is prohibited under any law for the time being in force in relation to the interest of the sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency, or morality, in relation to contempt of court, defamation, incitement to an offense relating to the above, or any information which is prohibited under any law for the time being in force. Grounds similar to what is contained in 19.2. But I'm using the word similar because they're not identical.
Yes.
19.2.
Yes.
Similar to the grounds contained in 69A, 69A1.
Yes.
My lord, if I don't, these are, my lord, the requirements, we have to observe all this. And what is required to be observed, my lord, now is if there is a notification by the appropriate government or its agency. And these are the grounds. Now, my lord, interestingly, the rules do not provide for the procedure required to be done. And that has to be contrasted with the blocking rules.
2011.
2011 under section 69A.
Yes.
No, my lord, blocking rules are 2009.
Yes.
Blocking rules are 2009. 2011 is the old rules. 2011 rules are the intermediary rules which were superseded by the 2021 rules.
Oh, come back. One.
Sorry.
2011 rules were superseded by 21 rules.
Yes, this is the one. That is the intermediary rules.
Yes.
Blocking rules 2009 continues to be as it is.
Yes. The blocking rules of 2000 still exist.
Yes, 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 yes.
Yes.
And the blocking rules for not are under 69A.
Correct.
And these are under 79. Yes. That's the difference. The blocking rules for not continues as it is. And the reason why, my lord, blocking rules become relevant is that the procedure for the purpose of issuing a blocking order under 69A is elaborately controlled by a mechanism provided under the rules. And I may point out your lordships, my lord, which I shall substantiate when I read Shreya Singhal. That was the reason why 69A was upheld. 69A was upheld by the Honorable Supreme Court because there are so many procedural safeguards in the rules itself. Therefore, my lord, 69A was upheld while 66A was struck down. And having done that, Supreme Court said, we are reading down 79(3)(b). Now, to what extent has 79(3)(b) been read down? And why was it read down?
No, Shreya Singhal reads down 79(3)(b).
Yes, yeah, these are the words used. Shreya Singhal reads down 79(3)(b). And the question, of course, my lord, that will arise for your lordship's consideration will be, to what extent is 79(3)(b) read down? And
what is the purport of the reading down?
What is the purport?
Yes.
That will be one question that your lordship will have to look at. It is our submission that 79(3)(b) has been read down because Supreme Court said it has to be read along with 69A. When I read 79(3)(b) along with 69(A), because 69(A) has been upheld because of the procedural safeguards contained in the blocking rules, it is our submission that the same safeguard should contain in 79(3)(b). This is.
It does not contain.
It does not contain. And I'm not attacking section 79 because 79 has been upheld. Once it is upheld, my lord, where is the question of challenging it again? Therefore, my lord, my prayer in the writ petition is, do not exercise 79 power, excepting in accordance with the procedure prescribed in 69A. And everything that has been done is on the basis that 79A is a standalone provision. Your lordship may kindly see my prayer in the writ petition.
79(3)(b) does not confer the authority.
Yes, that's what we have said. And your lordship may kindly see the prayer in the writ petition, my lord.
No, that's the prayer. I'm at page 98. It's prayer.
Yes, my lord. Issue a writ declaring that 79(3)(b) of the IT Act does not confer authority to issue information blocking orders under IT Act, and further declare that information blocking orders can only be issued under 69A, read with the
2009 blocking rules.
This is our submission. All these notices that have been issued is on a wrong premise that 79(3)(b) is a repository of power. And I shall make good that submission when I take your lordships through the reasoning contained in Shreya Singhal's case. And independently, it's going to be my submission, independent of Shreya Singhal. Because the other side will say, Shreya Singhal did not consider the second part of 79(3)(b). Shreya Singhal considered only the first part of 79(3)(b), namely communicating of a court order.
Correct.
My respectful submission, my lord, that reading may not be correct, and I shall place to your lordships what according to me is the correct reading of Shreya Singhal, independent of that. Independent of Shreya Singhal. Assuming for the sake of argument without conceding that the union government is right. In reading Shreya Singhal in that limited manner, Still, I would say the same reasoning that weighed with the Honorable Supreme Court to uphold 69A as a mirror reflection should lead to a declaration which I am seeking for with respect to 79. The reasons cannot be different. That is why, my lord, they now take umbrage under under semantics to say that block as a word is not used in 79A, and therefore 69A is totally different in its operation while compared to 79.
According to you, the result is the same.
My lord, result is the same. And these are mere words. What is the purport? It is a difference between a dozen and a 12. That's now, my lord, please be kind enough to turn to the blocking rules. And now, my lord, I want to point out to your lordships, when your lordships are at this 2011 rules, please be kind enough to turn to page 104. Now that your lordships are at the intermediary rules itself, let me complete this.
104.
Yes, my lord, please see what is the consequence of non-observance of the rules.
Yes.
Where an intermediary fails to observe these rules, rule 7, my lord, at page 104 at the bottom.
104, yes, sir.
When an intermediary fails to observe these rules, the provisions of subsection 1 of section 79 of the Act shall not be applicable to such intermediary. And the intermediary shall be liable for punishment under any law for the time being in force, including the provisions of the Act and the Indian Penal Code. Of course, now you read it as BNS.
Correct.
So therefore, my lord, if I do not obey a notice that has been issued under Rule 3(1)(d), I am visited with, if I may say so, with 3 consequences.
Residuary provision is always there.
And the 3 consequences, my lord, insofar as 79, because I'm showing that 79 is a more, 79(3) is more serious than even 69. And why do I say so, my lord? First, I lose a protection. If I lose a protection, my lord, I am liable to be prosecuted under any other law, whatever that law could be. Could be BNS, could be any other law. I would be liable for punishment under that law. Next, my lord, I would be liable for punishment under 49 because it's the IT Act punishment. So, my lord, I am visited with 3 consequences if I do not obey a direction or a notice. I won't even call it direction, my lord, because direction is a word used in 69A. The word direction is not issued here, makes no difference according to me. If I do not comply with the notice issued under section 79(3)(d), I am visited with 3 consequences. And I ask myself, independent of the punishment under some other law or under the IT Act, and more particularly 49 read with Rule 7, my lord, deprivation of a protection given to me by a statute visits me with civil consequences.
Read with 45, I guess.
49. 45 is it? 45. I'm sorry. 45.
Yes.
Independent, my lord, of 45. Independent of Rule 9. Independent of these 2 rules. Independent of Rule 45 and Rule 7. Independent of this. Deprivation of the protection given to me under 79(1) itself is a civil consequence. Yes. To say you are not affected is on the face of it wrong. Then why was protection given to me? Why was the safe harbor given to me under 79(1)?
No, it is taken away under certain circumstances. Not that it is taken away, en bloc. It's taken away under certain circumstances.
Yes. What is the circumstance, Manoj? That's what I'm questioning.
Prima facie, 3B indicates that 3D indicates that 2 indicates that unlawful act. It is going to result in unlawful. It is not that it is taken away completely. There is an obligation of performance of duty on your side, so then it is taken away if you don't perform it. That's the.
No,
that's
yes,
what-
my lord,
yes.
my lord, yeah, maybe, yes, my lord, partially what your lordships are saying is correct.
Yes.
But I should fill
No,
up the
no,
gap.
yes,
I will
no,
fill
no,
up the
no.
gap.
Yes, yes.
The, under 79 3D, I get a notice.
Yes.
If I get a notice, the decision that it should be, the access should be stopped, is a decision taken without any of the procedural safeguards as under 69A. It is not as if saying, I told you, you did not do it, and it stops at that. No. If I don't comply with your notice as provided for under 79 3B,
Yes.
I have to face the situation where I lose the exemption granted under 79(1). Nothing more.
No, is it
Nothing
that,
more is to be done.
is it that B would kick in once A is found?
No, my lord. No, my lord. B is a, kindly see, my lord, provisions
No,
of
upon
subsection.
receiving actual knowledge and information so and so, an intermediary, see 2A says, intermediary has conspired, abetted, aided, induced, whether by threats, promise or otherwise, in the commission of unlawful.
That's
It's
one,
a
that's one
standalone.
standard.
It's a standalone thing.
Standalone.
So B is independent of.
Yes, yes,
the others.
yes. B is independent of A. And B has two components. One is receiving actual knowledge.
Or being notified.
Or being actual knowledge, my lord, Honorable Supreme Court in Shreya Singhal has said it is on being receiving actual knowledge of a court order. I showed your lordships. They have said this upon receiving actual knowledge. Supreme Court has said it is actual knowledge
No.
of a court order.
Is not actual knowledge the information that you receive, which
No,
is.
no, my lord. Supreme Court has now interpreted
Let's
this.
see. Yes, yes.
This is how it has been read down now.
All right.
I showed your lordship. This upon receiving actual knowledge is actual knowledge of a court order. Now, my lord, or now second part of it is what is troublesome. Or on being notified by the appropriate.
One more, please.
I'm
Sorry.
I'm sorry.
Now, on receiving actual knowledge, if you travel down, it says actual knowledge, if you read with intermediary being used to commit the unlawful act, the intermediary fails to. So that actual knowledge or being notified, actual knowledge according to you is the court order which the apex court has interpreted.
Yes.
That we'll see. Actual knowledge is once it comes to comes on your platform is what I thought.
No, my lord. Supreme Court has said it is a court order. I'll point out that provision.
Yes.
We got para 121, 122 of
No.
Shreya Singhal says that, my lord, I take your lordship. My lord, I understand, my lord, because there is
The
some
clarification. Yes.
My lord, I bow down. I
Yeah.
bow down.
Yes.
Now, my lord, kindly see the second part is what is troublesome. On being notified by the appropriate government or its agency that any information, etc., is being used to commit the unlawful act.
Correct.
Now, that decision is made by whom? That a particular information is being used to commit an unlawful act is a decision that is made in an opaque manner.
No, unlawful act is there. Unlawful activities are
Who
defined.
decides, my lord? If there is, for example, my lord, if there is an act that has been, which is an offense under the Indian Penal Code,
Yes.
or now the BNS, like for example, defamation, that example I get. Now, my lord, a prosecution is launched. The court holds this does not amount to defamation. Here is the officer, the notified agency of the government who says, according to me, it is unlawful. Therefore, I am issuing a notice to you under 3(1)(b). That, my lord, look at the incongruous situation now. Therefore, my lord, we are saying that the notification is simply an act of giving information with respect to something else, which has already been determined. That is all that you can do. The officer cannot himself become a judge. Now, in the way in which they are implementing 79(3)(b), the officer is becoming a judge. The officer says, I will. Let me make the point.
So you mean to say that one should wait till a court proceeding concludes to say that you have brought, you have on your platform permitted some unlawful acts.
Yes.
It does not, the government cannot issue a notice to block those
Yes.
things. See
Or-
now, one.
I'm sorry.
Now,
I'm
an
very sorry.
illustration, this defame or some illegal act, unlawful act is on your platform. You mean to say the court should decide whether that unlawful or not and then issue the, so that goes on till the decision is taken by the court? It is there on your.
No, my lord, no, my lord. I see from where your lordships are coming from. Then issue an order under 69A. Of course, it is not as if, my lord, 69A, I will show to your lordships, is a complete code by itself. It even provides, my lord, for issuing an emergency order. It provides, my lord, that you can issue an emergency order even without going through the process. In other words, my lord, it provides for what is called as post-decisional hearing.
Then what's wrong with 79?
My lord, then
If you're accepting
yes,
that 69A itself gives power,
yes,
even without
Yes.
issuance of,
Yes.
it's not a pre-decisional hearing, but a
Yes.
post-decisional hearing. What's wrong with 70?
Oh, I'm not completely wrong, because my lord, 79(3)(b) does not even have the post-decisional hearing.
So on being notified.
That's all. That's the end of it. If I don't obey it, I lose the protection ipso facto by operation of statute of 79(1). Well, that is the problem, my lord, that we are facing.
So I'm only clarifying
No,
myself.
I-
Again, I'm saying. Yes, yes.
I'm not. I am beholden to the honorable court, my lord.
Yes.
Otherwise, my lord, this is an important question, and it has a bearing, my lord, not merely on the petitioner. It has a bearing, my lord, on the constitutional right, Article 14. It has, my lord, and it has received the attention of several courts. I'm going to show to your lordships. Bombay High Court has gone into it in full detail. Of course, my learned friend had appeared in the Bombay High Court too.
That Kunal case.
Yes. And that, my lord, two judges differed. Third judge
Third
concurred with His Lordship Justice Patel as it then was. I'm going to show all the.
All right. Yes.
Therefore, my lord, it is not as if 79(3)(b) doesn't even whisper about anything that is required as a protection contemplated under 69A. If the court were to say that 79(3)(b) is subject to compliance of 69A, then, my lord, this case is over, so far as I am concerned. That's the crux, my lord. Your lordships have, if I may say so, my lord, put your lordship's finger on the most sensitive issue in the case. There's absolutely no protection for me under 69A, having regard to their interpretation of 79(3)(b). They say, that is why, my lord, I showed your lordships their notification. Please be kind enough to see one notification that your lordships will kindly see. That's why, my lord, last time I pointed out your lordship the Ministry of Railways. Please see that.
One communication with the
one
Ministry of
glaring example of complete misuse.
That's on the last occasion.
Yes, I want your lordships
That
now.
we'll see.
Your lordships will now, if in the context of the submission I have made, if your lordship will kindly now see that. My lord, it is filed along with the memo.
No, last time I saw it's here.
Yes, my lord. Please look at that, my lord.
Car was driven on a track.
Yes. My lord, kindly say what?
It was wrong use. Misuse of a provision does not make the provision unconstitutional. I'll, my lord, show that.
My lord, please see, my lord. Well, I'm not on provision, my lord, misuse of. Therefore, my lord, we now understand. Now, do I take it that the stand of the union is that this was a misuse of provisions of 79(3)(b)?
No, that's only an illustration, I guess. That's not it.
No, this one.
Yes.
No, my lord, I'm now telling you, showing to your lordships how 79(3)(b) is capable of mischief, not because of any other factor excepting because of the understanding that 79(3)(b) is a repository of power. 79(3)(b) is a provision which is contained in under this heading of exemption. And I showed your lordships, some authorities say title of a section. When do you use title of a section to interpret the section.
Yes.
And in a situation of this kind, where there is ambiguity in the letter of 79(3)(b, would it not be appropriate for us to see what is the whole purpose of 79? Can it be said to be a repository of power? Or is it simply saying, if you don't do it, your exemption is taken away? Exemption, virtually it is a blocking order. If blocking order is contained on 69A, therefore if you don't, if after complying with the procedural safeguards contained in 69A, if a notice is issued to you and you still don't comply with it, you will suffer the pain of your exemption under 79(1) being taken away. Is this, I ask myself, not a reasonable way of harmoniously reading 69A with 79, consistent with Article 14 and the constitutional jurisprudence of this country? Please look at this particular document, my lord. Notice to, my lord, your lordship make.
That railways thing.
Yes, my lord.
All right. I think last time on quoted.
My lord, I'm given to understand, my lord, it has been filed along with the memo dated 1st of July.
Last hearing.
Yeah, I got it.
Oh, it's here. Yes, sir. Page?
My lord, it is
Ah,
at
it's here.
page 2.
The newsletter is.
It is at page 2. Notice to intermediary for disabling access to unlawful information.
Yes.
Ministry of Railways, being the appropriate government in respect of all subject matters of Indian Railways and its attached officers, is empowered under section 79(3)(b) of the IT Act to issue notifications to the intermediaries, including social media platforms, to remove, disable access to URLs, accounts, etc., where unlawful advertisements, endorsements, promotional content, etc. are published. And whereas, while Ministry of Railways notification dated 24 December 2024, the undersigned has been designated as nodal officer for the purpose of notifying the intermediaries in respect of unlawful information as per 79(3)(b) of the IT Act, read with Rule 3(1)(d) of the IT Rules, along with 69A of the IT Act and IT Rules blocking order. My lord, to a certain extent, I think, my lord, the officer who has issued this knows the law. Because he knows that 79(3)(b) I cannot do anything excepting that it depends upon 69A and he relies upon 69A.
Yes.
It has come to the notice of this ministry that several links URLs hosted on your platform XCOM are sharing video content having sensitive media, as it is depicting tendency to self-harm and also pose a threat to safety of rail users. It is also the violation of section 161, unauthorized driving at railway tracks is a punishable offence. Section 150 and 152, action to lead accidents or endanger human life of the Indian Railways Act 1989. This is not only against the ethical norms but also against the content policy of XCOM itself under suicide or self-harm. As sharing of such video may also disrupt train operation or encourage self-harm, it is categorically mentioned that the content showed in the shared URLs, links, attached appendix may be taken down immediately, as committing such type of act may lead to dangerous rail accidents and also affects Indian Railways train operation. Now, therefore, in accordance with the above mentioned provisions of law, the intermediary XCOM is hereby notified to remove and disable access to all URLs, links mentioned in Appendix A within 36 hours of the issue of this communication without vitiating the evidence in any manner. And kindly see, my lord, please be kind enough to turn to the various URLs are mentioned, my lord.
I know, all 200 pages are URLs.
Yes, yes. And kindly turn to page 12. What's so, what is so obnoxious about this? Maybe some deranged person.
The very act.
Did something. How does it have an unlawful impact? It has effect on railway safety. It is stupid thing that has been done by some lady. Yes, my lord, it's put there. That's what it says. A lady drove her car on a railway track. I mean, that's stupidity. I mean, it becomes news. Of course, it becomes news. As I told your lordship last time, my lord, if dog bites man, it is not news. If man bites dog, it is news.
Breaking.
Breaking.
Breaking news.
Yes.
Last time I told breaking
Yeah,
news.
your lordship said that.
It's breaking news.
Breaking news. What? I don't understand, my lord.
So that's why a car traveling on a rail track is a breaking news.
It's breaking news. But how does it amount to committing of an unlawful act, breaching the Railways Act, disrupting rail operations? Somebody did something, and what a funny thing this is. That's all there is in it, my lord. And another.
No, that's the menace of reels.
Menace of?
Menace of reels.
Yes, my lord.
Yes.
Correct. My lord, whether we like it or not, we now have to live with it. There are benefits, there are demerits. Ultimately, my lord, we have come to a stage where we cannot live without technology. Therefore, my lord, technology per se is not bad.
Technology per se is not bad. Unregulated technology is
Bad.
catastrophic.
Absolutely. There is no doubt about it. There is no doubt about it. Now the only question is, how did the parliament want to regulate technology? And that in this field of technology, my lord, dissemination of information which is seamless today all across the world, there are several players. There are, my lord, those who put in the data, the initiators. There are platforms who have no role to play.
Put in the data.
Originators.
Put in the data is the originator. Now you are the intermediary.
I have no role to play.
No, correct. You are the platform who receives that data.
I don't do anything, my lord. They put it and
No, that is what. You have a platform where they can easily put it.
Correct.
They put it and it is broadcast.
Yes. Now in this situation, the law recognized that here is an intermediary who really has no role to play. Therefore, as a matter of policy, they said we will give protection to an intermediary. And that policy was converted into a statute in the form of 79. So therefore, my lord, the special role which an intermediary plays in this, the full-blown activity of information technology, the dissemination of seamless information has been recognized. Now, as your lordship rightly indicated, my lord, that must have some restrictions. What type of restrictions? Restrictions are contained in 79.2 and 79.3. No problem, my lord. How should the restrictions be regulated is the question. Can it be regulated at the whims and fancies of a particular person? Because he says, I feel so, therefore it is so. My lord, is that the jurisprudence, my lord? I think we have long past that stage. There is no question of saying, I think so, therefore it is so. Exactly what 79.3b says.
Yes.
Now, my lord, please contrast this with the elaborate procedure prescribed under 69. Your lordship,
That is blocking rules 2009.
Yes. My lord, instead of reading to your lordships all the blocking rules and taking your lordship's time, I have prepared, my lord, a flow chart. So I'll give your lordship that. Don't put the memo and all that. Just give the flow chart. What have we done here? All right. My lord, I prepared a flow chart, my lord.
Yes, sir.
Where is it? So where is my flow chart? Okay. Give me a call. Give me. Yeah. Let us. Now, my lord, please look at this. How a order is passed, a blocking order is passed under 69A. And this is the reason why, my lord, 69A was upheld by the Honorable Supreme Court. My lord, there is a complaint to a nodal officer. Complaint can be made by any person other than the nodal officer to be sent with necessary approvals to the nodal officer of a concerned organization. Then, my lord, under 6.2, organization under Rule 2E.
Yes.
6.2, organization under Rule 2E to examine the complaint as per section 69A1 And then, my lord, after being satisfied, organization to send request through its nodal officer to designated officer in the form appended to the blocking rule. Therefore, there is a nodal officer, there is an organization, that organization has to be satisfied, then it is sent to a designated officer. Once it is sent to the designated officer, kindly see what happens. Forwarding of request.
Yes. Yes.
My lord, all these are contained in the rules. My lord.
No, for some other reason.
Oh, no.
Yes, yes, you can carry on.
Yes. Forwarding of request by organization to designated officer.
Yes.
And then, my lord, under 6.3, designated officer to acknowledge request within period 24 hours of receipt and assign a number to the request. And then what happens, my lord? Designated officer sends it to the committee to examine the request.
Yes.
And then, my lord, under rule 7, the committee, which consists of designated officer as chairperson and representatives not below the rank of joint secretary in ministries of law and justice, home affairs, information and broadcasting, and Indian computer emergency response team. That is the committee that is constituted, which will examine, my lord, the request for blocking that is received through the nodal officer. Nodal officer, as your lordship saw, sends it to designated officer. Designated officer then forwards the request, my lord, to the committee. Committee, my lord, examines it. If the designated officer thinks that there's nothing to be done, that's the end of it. The nodal officer's request is turned down.
Yes.
And then, my lord, please see what happens after the committee. On receipt of request, designated officer shall make all reasonable efforts to identify the person and issue notice to intermediary or such person to appear or submit their reply and clarification. If the person intermediary is a foreign entity, then notice by letter, fax or email signed with electronic signatures.
One clarification. Is this elaborate procedure
Yes.
contemplated even to block a particular URL or an intermediary by itself?
No, URL.
URL?
Yes.
Now, if this procedure has to
But
be
you are intermediary, they don't en masse block everybody.
that's what.
No.
I'm asking.
It is the URLs.
URLs, all right. Now, if this entire procedure has to be followed for a URL, suppose there is a news or whatever which incites communal violence in the platform, and this procedure has to be followed completely, takes month or two. By then damage is done.
No.
Then
That is why, my lord, there is rule 9. Kindly see left hand column.
emergency blocking.
Yes.
Huh.
My lord, everything is
You
contemplated.
said emergency blocking does not even require a notice to be issued.
Yes, correct. That's right. Rule 9.
That is what I'm seeing.
Yes, my lord.
Notice to be issued.
That is the answer to my lord's question.
73
That's nothing. There is no.
73 contemplates issuance of a notice.
No, my lord. This is
There also 73 says it is taking down of a particular information or deletion of a particular URL in a particular manner. Procedure is not there. You say procedure is there. We will hear the other side. But is it not an interim order? And see, an interim blocking order. Is it pursuant to a court order?
No.
Interim blocking order can
Under
be by
69A.
69A. It can be any person like the railways now who has said.
Only the committee. But the interim blocking order, my lord, is issued.
By whom?
By kindly see, my lord. My lord, kindly see rule 9. Give me the rules. My lord, your lordship may kindly see rule 9. Secretary meeting. One. Secretary meeting. I'll answer your lordship.
There's a particular
I will
designated
answer your
officer.
lordship's question,
Yes,
my lord.
that's all. No, that was my question.
Yes, my lord, I will answer your lordship's
Particular
question. Right.
designated officer. All right.
Page. My lord, may I trouble your lordship to kindly see page 5, my lord,
Yes, sir.
of the compilation that we gave your lordships?
Yes. Yes.
Yes. May I read 9, my lord? That answers your lordship's question. Notwithstanding anything contained in rules 7 and 8, the designated officer in any case of emergency nature for which no delay is acceptable shall examine the request and printed sample information and consider whether the request is within the scope of subsection 1 of section 69A of the Act, and it is necessary or expedient and justifiable to block such information or part thereof, and submit the request with specific recommendations in writing to the Secretary, Department of Information and Technology.
Yes.
Next, my lord. 2. In a case of emergency nature, Secretary, Department of Information and Technology may, if it is satisfied that it is necessary or expedient and justifiable for blocking for public access of any information or part thereof through any computer resource, and after recording reasons in writing, as an interim measure, issue such directions as he may consider necessary to such identified or identified persons or intermediary in control of such computer resource, hosting such information or part thereof, without giving him an opportunity of hearing. Then, my lord, designated officer, at the earliest but not later than 48 hours of issue of direction under sub-rule 2, shall bring the request before a committee referred to in Rule 7 for its consideration and recommendation. Kindly see, my lord, even where it is an emergency blocking order,
It has to go before the
it
committee.
has to go before the
That's why that
After
was
the blocking.
upheld. That's why it was in its entirety upheld. Is-
upheld, exactly.
That's your submission.
Exactly. And, and then, my lord, please see Rule 14 now, when your lordships are looking at this. Review committee.
Rule
And,
4.
yes, my lord, Rule 14. A review committee shall meet once in 2 months and record its findings whether the directions issued under these rules are in accordance with the provisions of subsection 1 of 69A of the Act, and if he is of the opinion that the directions are not in accordance with the provisions referred to above, it may set aside the directions and issue order for unblocking of said information generated, transmitted, received, stored or hosted in a computer resource of the
Now,
public.
Shreya Singhal interprets this.
All this.
All the blocking rules, 69A upholds it. What does the judgment in Kunal interpret, Bombay High Court?
Kunal, my lord, interprets the 21 rules where there is a provision, my lord, for what is called as a fact check unit.
That's by Bombay High Court.
Fact check unit. That's it. That is what was in question. Now, even there where there was a fact check unit.
And that's Bombay High Court.
That's Bombay High Court, of course, my lord. And I'm given to understand, my lord, though an SLP was filed, the union government did not take any steps to rectify the defects, and it has been whatever, man.
No, it is filed, it is pending. It will come on board anytime.
Very well. I'll take
Filed
it.
within
No,
limitation.
even otherwise,
It
even
is
if it is dismissed in limine, it would not.
No, it is not. It is not
Pending at all.
listed.
No,
It is not listed.
Not at all, man. Not at all. Even if all the judges of a different court say one thing, your lordships can say the other way. That I don't think it is only
Yes,
persuasive.
yes,
I agree, my lord.
Yes.
My lord, on this, I want your lordships to kindly see, my lord, para 5 of our rejoinder. My lord, before that, my lord, let me
you
complete
complete
this chart.
Marbut.
I'll
Yes.
complete this chart
Yes,
before
yes.
we'll otherwise. My lord, now, my lord, kindly see what happens when the committee meets, and then, my lord, please see, after the committee consisting of these officers are to look at it, they issue on receipt of request, designated officer shall make all reasonable efforts to identify the person and issue a notice to intermediary or such person to appear and submit the reply and clarifications. If the person intermediary is a foreign entity, then notice by letter, fax or email signed with electronic signatures.
Yes.
Then what happens, my lord? Kindly see Rule 8.4. Examine the request and printed sample in whether the request is covered under 69A1 of the IT Act and give a specific recommendation in writing to the request received from the nodal officer.
Yes.
And then, my lord, Rule 8.5. Designated officer to forward recommendation and request to the secretary of the concerned ministry, my lord, that is Ministry of Electronics and Information Technology.
Yes.
And then, my lord, designated officer upon approval from secretary direct blocking order. Look at the amount of procedural safeguards that is contained, and contrast it, my lord, with the complete absence of any procedural safeguard in 79.
Yes.
That is what makes 79 unconstitutional, but your lordships will always lean in favor of saving the constitutionality, and 79 has been saved by the Supreme Court in Shreya Singhal. Therefore, my lord, I would not be able to question the constitutional validity of 79 before this honorable court. Therefore, I am saying, having regard to the law laid down in Shreya Singhal and otherwise, read 79 not as a repository of power as a standalone basis. Read it as a provision which simply talks about when I will lose the safe haven provision under 79(1). This is the how, my lord, I would read 79. Otherwise, my lord, there will be a head-on collision between 69A on the one hand and 79 on the other. And that the courts normally don't do, my lord. The attempt is to harmoniously read the various provisions of a statute. And if it is read that way, I respectfully submit, my lord, that no prejudice is being caused to public interest. And as I indicated at the beginning of my submissions, my lord, it is not our intention to do anything which is likely to injure public interest. No, my lord, it's not. Nobody wants to do business in that way. Now, my lord, now that your lordships have seen it, now, my lord, I'll take your lordships to Shreya Singhal, my lord.
Yes.
If your lordships
Yes.
will now look at, I'll take my, I'll take. My lord, Shreya Singhal is found, my lord, at page, which page?
103.
Huh?
103.
103. My lord, it begins at page 103 of the writ petition.
Petition itself?
Yes, my lord. My lord, it is
Oh, it's
found
here, yes.
at page 103 of the writ petition itself.
Very
We have put it as annexure A.
better. Need not travel elsewhere.
No, my lord.
Yes. 103, yes, sir.
My lord, kindly just see what was the, how the court approaches, my lord. The reasonings of the court in Shreya Singhal, the judgment, my lord, after all the head note and the appearances, and, my lord, the written submissions. 227.
Yes.
My lord, your lordship may straight away go to page 227, my lord. No, it's okay, don't worry. No problem. My lord, your lordship may straight away go to page 227. Up to that, my lord, it is head notes and written submissions filed by counsels and appearances and all
Yes,
that, my lord.
yes.
I'll just quickly take your lordship through how the Honorable Supreme Court approached the entire matter. 66A, 69A, 79 rules, the 2011 rules, 31D. This batch of writ petitions filed under Article 32 of the Constitution of India, very important for far-reaching questions,
Yes.
relatable primarily to the fundamental right of free speech and expression guaranteed by Article 19(1)(a) of the Constitution. The immediate cause for concern in these petitions is 66A of the Information Technology Act 2000. This section was not in the Act as originally enacted, but came into force by virtue of an Amendment Act of 2009 with effect from 27/10/2009. I want to pause for a moment here and point out your lordships, my lord, that 79 also came because of 2009.
69A came because of
79?
79 was substituted.
No, 79 was substituted, 69A was introduced. But in any event, my lord, all these changes to the Information Technology Act came because of the Amendment Act of 2009. One was substitution, the other was introduction. That's not so material for the purpose of the present
Yes.
case. Since all the arguments raised by several counsel for petitioners deal with the unconstitutional section, it is set out here in below. My lord, these sections are all cited. I am going to,
A related challenge.
my lord, kindly see paragraph number 2. That is, my lord, that is the related challenge is also made to section 69A. Now that's important, my lord. That is what was upheld.
Yes.
And of course, your lordship will ask me, where is the reference to 79? 79 reference comes later.
Yes, yes.
It is not here.
Yes, sir.
My lord, your lordship may now kindly go to para 13. This leads us to a discussion of what is the content of the expression, freedom of speech and expression. There are three concepts which are fundamental in understanding the reach of this most basic of human rights. The first is discussion. The second is advocacy. The third is incitement. Mere discussions or even advocacy of a particular cause, howsoever unpopular, is at heart of Article 19(1)(a). It is only when such discussion or advocacy reaches the level of incitement that Article 19(2) kicks in.
Yes.
It is at this stage that a law may be made curtailing the speech or expression that leads to inexorably to or tends to cause public disorder or tends to cause or tends to affect the sovereignty and integrity of India, the security of the state, friendly relations, foreign states, etc. Why it is important to have these three concepts in mind is because most of the arguments of both the petitioners and the respondents tended to veer around the expression public order. It is at this point a word needs to said about the use of the American judgments, but I'm going to skip that. May not be necessary. Your lordships may now kindly go to para 21.
Yes.
Section 66A has been challenged on the ground.
Yes.
Has been challenged on the ground that it casts the net very wide. All information that is disseminated over the internet is included within its reach. It will be useful to note that Section 2V of the Information Technology Act 2000 defines information as follows. My lord, 79 has the same word, information. And kindly see, my lord, the same logic that is applied with respect to 66A would be applicable to 79, but because it is read down, the Supreme Court said it's all right.
Yes.
Then, my lord, please see para 23. One challenge to Section 66A made by Petitioners' Counsel is that the offence created by the said section has no proximate relation with any of the 8 subject matters contained in Article 19(2). We may incidentally mention that the state has claimed that the said section can be supported under the heads of public order, defamation, incitement to an offence, and decency or morality. Under our constitutional scheme, as stated earlier, it is not open to the state to curtail freedom of speech to promote general public interest. In Sakal, it was said, it may well be within the power of the state to place in the interest of general public restriction. I'm relying upon this judgment, my lord. This is a very important judgment.
Yes.
It may
No,
well be.
this is your sheet anchor.
Not, my lord, sheet anchor, my lord, is Shreya Singhal.
That's a judgment. That's what I said.
But the other judgments, my lord, Sakal is also very important.
All right. Yes.
And I'm going to give you a lordship the citations I'm going to rely upon. It may well be within the power of the state to place in the interest of general public restrictions upon the right of a citizen to carry on business, but it is not open to the state to achieve this object by directly and indirectly curtailing any other freedom of that citizen guaranteed by the Constitution and which is not susceptible of abridgment on the same grounds as I set out in clause 6 of Article 19. Therefore, the right of freedom of speech cannot be taken away with the object of placing restrictions on the business activities of citizen. Speech can be restricted only in the interest of security of the state, friendly relations with foreign state, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offence. It cannot, like the freedom to carry on business, be curtailed in the interest of general public. I pause for a moment here, my lord. Please permit me to give your lordship one chart that I have prepared. It is already, my lord, in the memo that we just gave to your lordships, my lord.
Flow chart.
No, my lord. Next to the sheet next to that, or before that. Flow chart is page number 3.
It is here. Yes, comparison.
Yes. Now, my lord, can see the comparison now. My lord, the law in Sakal, as noticed in Sakal newspapers.
Which is that judgment?
My lord, that's what I read, my lord, para 24 of Shreya Singhal.
Part of this judgment.
Yes. I didn't want to cite it separately, my lord, because it was. Now, my lord, in Sakal, the law is clear that if you want to come within the purview of Article 19(2), it must be within one of the 8 buckets contained in Article 19(2). It cannot go beyond that. Now, my lord, please look at what has happened in 79 now.
Yes.
My lord, 79 doesn't contain anything. The grounds are contained only in Rule 3(1)(d). Unlike 69A, which sets out the various grounds, which is in conformity with 19(2), 79 on the face of it does not have anything.
Yes.
But 79, if it is read with Rule 3(1)(d), then, my lord, grounds are specified. Please see, my lord, what the grounds are. Please see Article 19(2), my lord, at 8 heads, or what we may call as 8 buckets.
Yes.
For purpose of which a law can be made under 19(2)
Yes.
to abridge a right under 19(1)(a).
Yes.
No difficulty.
Yes.
Now, my lord, please see 69A. 69A, my lord, has in the interest of sovereignty and integrity of India, it is there. Defense of India, my lord, has been introduced for the first time in 69A. Defense of India is not there in 19.2 as a separate head. Unless you say that defense of India is part of the interest of sovereignty and integrity of India.
It is. Yes.
In any event, one of the constitution makers did not
That
use.
is why constitution, it's a living document, dynamic, not static.
I understand.
So-
But it is a dynamic document, not to be interpreted by a statute.
That we'll see, yes.
It can be done by the courts. It can be done by another constitutional amendment. Now, my lord, a new ground is introduced in 69A as defense of India. Then, my lord, we have security of the state, which is also there in 19.2. Friendly relations with foreign states, we have it there, my lord, in 19.2. Public order, we have.
Yes.
Now, up to here,
Decency and morality.
but I'll come to that one. I'll come to that for a minute. Now, my lord, please see that in Rule 31D, which is relevant for the purpose of Section 79.
31D is of 2021 rule.
Yes, sir. Yes, sir. Yes, sir.
yes,
That's
yes,
7/2021. All those grounds are stated. What is contained in 19.2 is stated. Then there is another serial number 9, a catch-all.
Where is serial number 9 here?
Well, kindly see, my lord, in the list.
Oh, last one.
Yes,
Any
yes,
information
yes.
which is
Yes,
prohibited.
that is the point. That is why I am saying. This is a catch-all. You don't need, my lord, anything from 1 to 8. 9 is enough. Is this permissible is the question. Now, I ask myself, by introducing 9 in Rule 31D, are you not adding a bucket to 19.2, which is impermissible? And Shreya Singhal says, with respect to 69A and 79, the only restrictions you can impose are those contemplated under 19.2.
Not beyond that.
Not beyond that. Now, has not, I ask myself, Rule 31D gone beyond that? That is why, my lord, we amended the writ petition to challenge Rule 31D.
Yes, now the challenge is to 31D.
Then now the challenge, that is the reason why, my lord, we have challenged it.
Yes.
This is what I wanted to point out to your lordships, having regard to what has been laid down, my lord, in Sakha.
And we'll continue at 2:30.
Can I come at 3 if your lordship? Half an hour.
How's Then who will?
My learned friend also, my lord, is giving us the privilege of addressing the.
No, that would be not more than 5 minutes, but your convenience.
Half an
And
hour.
the court's
Just
convenience. But
half an
I have finished my list. If you ask me to come at 3 o'clock, I will come at
half an hour.
But
I just
entirely your
want-
lordship's prerogative and my
I
learned
just want
friend.
half an hour.
3 o'clock.
Because I have only one matter, you would have other matters also.
We want to finish a matter and come.
ಎರಡೂವರೆಗೆ ಹಾಕ್ತೀನಿ.
ಆಯ್ತು ಸರ್. But ಅಲ್ಲಿ ಮುಗಿದೆ ಹೋದ್ರೆ?
Yeah, ಮುಗ್ದೋಯ್ತು. It is over.
So I'll.
If not over, I'll.
then
It is
we'll-
my commitment to this honorable court, my lord. This is my first.
Then we'll resume at 3 sharp.
3, I will be.
Please, sir.
I am obliged, my lord. I am sorry for
No,
making
that's
this
fine.
request. I am sorry, sir.
No, no.
Troubled you. That's kind.
Pronouncement. Pronouncement.
List number 2, pronouncement of order. Seal number 1.
Cancellation of bail.
Oh, so you are changing. 5 minutes, there's some pronouncements, I'll finish and take that.
Oh, very good.
Pronouncement ಮುಗಿಸ್ಬಿಡ್ತಾ ಇದ್ದೆ. Cancellation of bail rejected.
Great.
Next.
Number 2,
ಇದ್ರ ಜೊತೆದಿತ್ತಲ್ಲ ಒಂದು.
that is at serial number 3.
All right, yes. Criminal petition is allowed, proceeding in so and so stands quashed. It is made clear the observations are made for the purpose of consideration of the case of 482 of CRPC would not bind or influence the remanded proceedings in RA 296 of 2021.
Great.
One pending ಇದೆಯಲ್ಲ ಅದು. Yes.
Great.
3,
Criminal petition is allowed in part. The proceedings in CC 1029 of 2024 is quashed only in respect of alleged offense under section 354D stalking of the IPC. Criminal petition qua, all other offenses stands dismissed.
4,
The was 4 is what 343 ಅಲ್ಲ?
ಹೌದು ಸರ್.
340.
CRP 3.
CRP is allowed, the order impugns so and so passed with the in execution petition stands quashed. The concerned court shall now proceed to regulate its procedure in terms of the observations made in the course of the order.
Great.
5,
Dismissed.
6,
I appear for the petition.
Writ petition is disposed with imposition of exemplary costs of 2 lakhs to be paid to the petitioner by the chairman and members of the district caste and income verification committee Hassan from out of their own funds and not from the funds of the state. The cost shall be paid to the petitioner within 4 weeks from the date of receipt of the copy of this order. Petitioner shall also become entitled to all consequential benefits except salary and other monetary benefits.
10 months salary.
No work, no pay. Yes.
7,
Cost ಕೊಟ್ಟಿಲ್ವಾ ಅದಕ್ಕೆ? Yes.
7,
Writ petition is allowed, order dated 5/7/2024 and so stands quashed. IA 10 filed under order 16, order 6 rule 16 of the CPC in OS so and so is allowed and the defense of the defendant is stuck off in the said suit.
Outer limit for the,
Outer limit. Yes.
much obliged.
8,
Dismissed.
9,
Writ petition is allowed, the order dated 16/10/2024 stands quashed. The application filed by the defendant under section 8 of the Arbitration Conciliation Act stands rejected. Consequently, the suit in commercial OS 207 of 2024 stands restored for further proceedings.
10,
Dismissed.
11,
Petition lacking in merit stands rejected with cost of rupees 1 lakh to be paid by the judgment debtor to the decree holder. Interim order, if any operating, shall stand dissolved. Yes. Writ petition is allowed. The order dated 28/3/2023 passed by so and so stands quashed. The application IA 3 of the petitioners on order 7 rule 10 of the CPC in commercial OS 787 is allowed. The plaintiff is directed to be returned to the plaintiff taking appropriate action to be placed before the appropriate court in accordance with law.
Grateful.
Yes.
13.
The writ petition is allowed in part. The order impugned dated 7/4/2025 is modified and application filed by the petitioner plaintiffs and IA-8 seeking recast and drawing up of additional issues which is allowed in part is further allowed. The concerned court shall recast the issues by including the following issues 1 and 3. Whether the plaintiffs prove that they are in physical possession of scheduled property, and whether the plaintiffs prove that they are the prior agreement holders with respect to the suit scheduled property. The concerned court is directed to regulate its procedure in terms of this order before proceeding further. Writ petition is allowed. The order dated 16/1/2025 stands quashed. The concerned court shall now impound the document, impose stamp duty, and thereafter consider the instrument for marking, as also consider the application of filed by the petitioner seeking appointment of a court commissioner afresh.
Application is filed by the
Hello.
respondent.
Respondent afresh. If not already impounded, yes.
Registration, has to be registration, I have objected for.
Bearing in mind the observations, yes, yes. A delay of 14 years in preferring the application cannot be brushed aside. The concerned court has, on rendering cogent reasons, rightly rejected the application. The order does not warrant any interference. Petition rejected.
One observation that the observations here would not affect the.
Then affect others.
Since
Our
it is
617 order is challenged, that is
the
dismissed.
observations made in the writ petition will.
What will affect? I have only gone on due diligence. Proviso to 617.
Oblige. Pertaining to that one.
ಅದು ಕೊಟ್ಬಿಡಿ ಕೊಟ್ಬಿಡಿ.
Pronouncement. Number 1.
In the light of the law laid down by the coordinate benches and division bench of the other high courts, the unmistakable inference is non-entertainment of the petition qua the prayer that is sought. It is for the petitioner at every instance to knock at the doors of the concerned court by filing applications for release of gold or any other seized property. In the event such application is filed, the concerned court shall, in consonance with principles of natural justice, pass necessary orders in accordance with law. Except the aforesaid observation, no other prayer of the petitioner would merit any consideration. The petition is disposed in the aforesaid terms. Yes, sir. We'll resume. Sorry, 5 minutes late. Pronouncement.
Let's continue. 24.
Other 6 and 7. Yes, sir.
My lord, I was pointing out your lordships, my lord, the judgment in Shreya Singhal. I was inviting your lordship's consideration to para 24.
Yes, sir.
Where, my lord, reference is made to Sakal papers.
Yes.
And the law, my lord, is that if a law, my lord, kindly see the quotation from Sakal.
Yes, sir.
At page 237, line about 10 from top.
Yes, sir. Yes.
If a law directly affecting it is challenged, it is no answer to say that the restrictions enacted by it are justifiable under clauses 3 to 6. For the scheme of Article 19 is to enumerate different freedoms separately and then to specify the extent of restrictions to which they may be subjected and the objects for securing which this could be done. A citizen is entitled to enjoy each and every one of the freedoms together, and clause 1 does not prefer one freedom to another. That is the plain meaning of this clause. It follows from this that the state cannot make a law which directly restricts one freedom even for securing the better enjoyment of another freedom. All the greater reason, therefore, for holding that the state cannot directly restrict one freedom by placing an otherwise permissible restriction on another freedom. There, I point out to your lordships, my lord, in that chart I gave your lordships.
Yes,
How an extra reason is incorporated in rule, no, not this. In rule 3(1)D of the IT rules.
Chart covers your entire argument. Chart covers your entire argument.
Yes, it does. It does. It does.
Yes.
It
No,
does.
that's,
That's the reason why
no,
I.
it said picture is worth 1,000 words. Yes.
Yes. But actually, my lord, when a commission was constituted to find out the merits and demerits of the written argument system in US and, my lord, the oral argument system in England, the report came back, the commission came back and said a meaningful shrug of the shoulders of a Queen's Counsel is worth 100 pages of written arguments.
Yes, sir.
Now, my lord, I'm going to skip a few of these paragraphs, my lord. Then I'll come
Para
to
118, I think.
Yeah, no, my lord. I want to point out your lordships, my lord. Paragraph number 36, if your lordships
30,
are
all
kind
right.
enough, my lord.
Yes, yes, yes. Ram Manohar Lohia.
Yes, my lord.
Yes.
In Superintendent Central Prison versus Ram Manohar Lohia, this court held that public order is synonymous with public safety and tranquility. It is the absence of disorder involving breaches of local significance in contradistinction to national upheavals such as revolution, civil strife, war affecting the security of the state. This definition was further refined in Ram Manohar Lohia versus State of Bihar, where this court said, it will thus appear that just as public order in the rulings of this court was said to comprehend disorders of less gravity than those affecting security of the state, law and order also comprehends disorders of less gravity than those affecting public order. One has to imagine three concentric circles. Now, this is important, my lord, in the context of what is put. That how it has been explained by the Honorable Supreme Court is have three concentric circles. One has to imagine three concentric circles. Law and order represents the largest circle, within which is the next circle representing public order, and the smallest circle represents security of the state. It is then easy to say that an act may affect law and order, but not public order, just as an act may affect public order, but not security of the state. So now, my lord, in this context, please see what has been added. My lord, the addition, any information which is prohibited under any law for the time being in force is not something that comes within the purview of 19.2.
You are placing reliance on Ram Manohar
Yes,
Lohia
my lord, yes, my lord.
to say what is public order.
Public order. It can't be done.
There is a paradigm shift in thinking what is public order. 1966 and 2026.
But these cases
No,
have
this
stood the
is
test of time even in.
Correct, but the information was internet information, nothing was available then. Now security of the state in this is in these three circles is placed at the lowest. Now it is at the topmost. That's how the present scenario is.
Could be, it could be. But in Shreya Singhal itself, they have said.
That's what that will consider. Ram Manohar Lohia's judgment
But
was.
it has been quoted with approval in
Correct.
Shreya Singhal. And Shreya Singhal itself says, it is true that there is a paradigm shift in the spread of information and how one can motivate people to think in one way and another, which is one way good, one way bad. But there is no difference between print media and electronic media. The same principles apply. There is no question of, unless they say, well, having regard to the spread of electronic media and social networking platforms, we have to have different
So
set of constitutional values. That's a
information,
different
yes,
issue.
correct. Information may be the same. The speed is different.
Speed is different. And now we are not concerned with the speed.
I know that's
We are
the
concerned
content.
with the quality of information. That is the point. Then, my lord, your lordships may kindly see, my lord, if I may trouble your lordships in this context to see paragraph number 30, my lord. I'm sorry to take your lordships back.
3-0.
Yes, my lord.
Argued by.
It is argued by the learned additional solicitor general that a relaxed standard of reasonableness and restriction should apply regard being had to the fact that the medium of speech being internet differs from other mediums on several grounds. To appreciate width and scope of his submissions, we are setting out his written submissions verbatim. My lord, I'm going to skip that, my lord, with your lordship's kind permission. Now, my lord, please see para 31. As stated, all the above factors may make a distinction between the print and other media as opposed to the internet, and the legislature may well therefore provide for separate offences so far as free speech over internet is concerned. There is therefore an intelligible differentia having a rational relation to the object sought to be achieved, that there can be creation of offences which are applied to free speech over internet alone as opposed to other mediums of communication. Thus, an Article 14 challenge has been repelled by us on this ground later in this judgment. But we do not find anything in the features outlined by the learned Additional Solicitor General to relax the court's scrutiny of the curbing of the content of free speech over the internet. While it may be possible to narrowly draw a section creating a new offence, such as 69A for instance, relatable only to speech over the internet, yet the validity of such law will have to be tested on the touchstone of the test already indicated above. In other words, my lord, the Honorable Supreme Court is saying that insofar as testing the validity of the law is concerned, whether it is print media or whether it is electronic media or internet, same principles apply. That seems to be the approach, my lord, in Shreya Singhal as explained. Now, my lord, when your lordships are at this, would your lordship just look at paragraph number 90 also, my lord? It is at page 270 of if I may trouble your lordship to kindly see para 90 at page 270 of your lordship's.
Yes, yes. In 1970 judgment, that is Arun Ghosh.
Yes,
at para 37.
Yes, ma'am.
The end of that para, the apex court says, the question, last 4 lines,
Yes,
it virtually distinguishes Lohia to say that it would depend on facts of each case.
Yes. Yes, ma'am.
Yes, now para 90.
Para 90, my lord, your lordship gets it.
Yes.
At page 200. My lord, page 270.
The content and right under article.
Yes, ma'am.
Yes.
That the content and right on article 19(1)(a) remains the same. Whatever means of communication, including internet communication, is clearly established by Reno case and by Ministry of Information and Broadcasting, Government of India versus Cricket Association of Bengal. At para 78 already referred to. It is thus clear that not only are the expressions used in 66A expressions of inexactitude, but they are also overbroad and would fall foul of repeated injunctions of this court that restrictions on the freedom of speech must be couched in narrowest possible terms. My lord, what have they done? I ask myself in Rule 3(1)(d). Instead of couching it in the narrowest possible terms, my lord, the attempt appears to be to make it a catch-all. This is the complete negation of the law laid down
In Shreya Singhal.
in Shreya Singhal. Then, my lord, in point of fact, judgments of the Constitution bench of this court have struck down sections which are similar in nature. A prime example is the section struck down in first Ram Manohar Lohia case.
Yes.
Namely, section 3 of the UP Special Powers Act, where the persons who instigated expressly or by implication any person or class of persons not to pay or to defer payment of any liability were punishable. This court specifically held that under the section, a wide net was cast to catch a variety of acts of instigation ranging from friendly advice to systematic propaganda. It was held that in its wide amplitude, the section takes in the innocent as well as the guilty, bona fide and mala fide advice, and whether the person be a legal advisor, a friend or a well-wisher of the person instigated, he cannot escape the tentacles of the section. The court held that it was not possible to predicate with some kind of precision the different category of instigation falling within or without the field of constitutional prohibitions. It further held that the section must be declared unconstitutional as the offence made out would depend upon factors which are uncertain. Which one?
Yes.
My lord, your lordship may now kindly see paragraph number 95, my lord. Learned additional Solicitor General cited a large number of judgments on the proposition that the fact that 66A is capable of being abused by the persons who administer it is not a ground to test its validity if it is otherwise valid.
Yes.
He further assured us that this government was committed to free speech and that section 66A would not be used to curb free speech, but would be used only when excesses are perpetrated by persons on the rights of others. In Collector of Customs with Nathela, this court observed, this court has held in numerous rulings to which it is unnecessary to refer, that the possibility of the abuse of powers under the provisions contained in any statute is no ground for declaring the provision to be unreasonable or void. Commenting on a passage in the judgment of the Court of Appeal of North Island, stated, if such powers are capable of being exercised reasonably, it is impossible to say that they may not be exercised unreasonably, and treating this as a ground for holding the statute invalid. Then, madam, the possibility of abuse of a statute otherwise valid does not impart to it an element of invalidity. The converse must also follow, that a statute is otherwise invalid as being unreasonable cannot be saved by it being administered in a reasonable manner. That's the point, the sentence I rely upon. The constitutional validity of a statute would have to be determined on the basis of its provisions and on the ambit of its operation as reasonably construed. Therefore, my lord, whether it is being abused, whether it is being used in a proper way, both are irrelevant for the purpose of finding out as to whether a provision is constitutional or not. That seems to be the approach of the Honorable Supreme Court. The constitutional validity of a statute would have to be determined on the basis of its provisions and on the ambit of its operation as reasonably construed. If so judged, it passes the test of reasonableness. Possibility of the powers conferred being improperly used is no ground for pronouncing the law itself invalid. And similarly, if the law properly interpreted and tested in the light of the requirements set out in Part 3 of the Constitution does not pass the test, it cannot be pronounced valid merely because it is administered in a manner which might not conflict with the constitutional requirements.
Yes.
Then, my lord, I straight away take your lordship's, my lord, to paragraph number 112. Where, my lord?
69A.
Yes, respectfully. Sections having set out all this, my lord. Then, my lord, 66A is struck down. Now, the Honorable Supreme Court is considering 69A. Section 69A of the Information Technology Act has already been set out in para 2 of the judgment. Under subsection 2 thereof, the 2009 rules have been framed. These are the blocking rules. Under Rule 3, the central government shall designate by notification in the official gazette an officer of the central government, not below the rank of a joint secretary as a designated officer for the purpose of issuing direction for blocking for access by public any information referable to in section 69A of the Act. Under Rule 4, every organization as defined in Rule 2G, which refers to Government of India, state governments, union territories and agencies of the central government, as may be notified in the official gazette by the central government, is to designate one of its officers as nodal officers. Under Rule 6, any person may send their complaint to the nodal officer. My lord, I am going to skip this paragraph only for the reason that whatever has been stated in this paragraph in the form of a narrative has been now put in the form of a flow chart before your lordship. So therefore, my lord, in order to be
the entire procedure is in the
entire procedure is there, my lord. It has been put here in a narrative form. I have put it in the form of a flow chart. Therefore, I am going to skip it. Now, my lord, please be kind enough to see paragraph 114. You want to see 113?
Yes.
113 also, my lord.
All right.
Learned counsel for the petitioners assailed the constitutional validity of 69A and assailed the validity of the 2009 rules. According to learned counsel, there is no pre-decisional hearing afforded by the rules, particularly to the originator of the information, which is defined under section 2ZA of the Act to mean a person who sends, generates, stores or transmits any electronic message or causes any electronic message to be sent, generated, stored or transmitted to any other person. Further, procedural safeguards such as which are provided under sections 95 and 96 of the Code of Criminal Procedure are not available here. Also, the confidentiality provision was assailed, stating that it affects the fundamental rights of the petitioners. It will be noticed that section 69A, unlike section 66A, is narrowly drawn provision with several safeguards. First and foremost, blocking can only be resorted to where the central government is satisfied that it is necessary so to do. Secondly, such necessity is relatable only to some of the subjects set out in Article 19(2). Thirdly, reasons have to be recorded in writing in such blocking order so that they may be assailed in a writ petition under Article 226 of the Constitution. The rules further provide for a hearing before the committee set up, which committee then looks into whether or not it is necessary to block such information. It is only when the committee finds that there is such a necessity that a blocking order is made. It is also clear from an examination of Rule 8 that it is not merely the intermediary who may be heard. If the person, that is the originator, is identified, he also is to be heard before a blocking order is passed. Above all, it is only after these procedural safeguards are met that blocking orders are made, and in case there is a certified copy of a court order, only then such blocking order also be made. So, my lord, it is, one is you have a certified copy of a court order, blocking. Otherwise, my lord, it has to go through the entire gamut of procedure before various authorities, before a
Correct.
block.
Procedure is obviated if there is a court order.
Of course,
That's
that's
always
the court
there.
has seen this. Court has seen it. Then nothing more the officers can do when it's a court order. It is only an intermediary who finally fails to comply with the directions issued who is punishable under subsection 3 of section 69A. Merely because certain additional safeguards such as those found in section 95 and 96 CRPC are not available does not make the rules constitutionally infirm. We are of the view that the rules are not constitutionally infirm in any manner. Therefore, my lord, 69A is upheld. Now, my lord, kindly see 79. What does the Honorable Supreme Court say about 79? Section 79 belongs to Chapter 12 of the Act, in which intermediaries are exempt from liability if they fulfill the conditions of the section. Section 79 states, Section 79 is extracted. Now 118. Under the 2011 rules, by Rule 3, an intermediary has not only to publish the rules and regulations, privacy policy, and user agreement for access or usage of the intermediary's computer resource, but he has also to inform all users of the various matters set out in Rule 3.2. Since Rule 3.2 and 3.4 are important, they are set out herein below. I am going to skip that one for the present. Now kindly see para 119. Learned counsel for the petitioners assailed Rule 3.2 and 3.4 on two basic grounds. Firstly, the intermediary is called upon to exercise its own judgment under sub-rule 4, and then disable information that is in contravention of sub-rule 2. When intermediaries, by their very definition, are only persons who offer a neutral platform through which persons may interact with each other over the internet. But net neutrality is a well-accepted norm all across the world. Further, no safeguards are provided as the 2009 rules made under 69A. Also, for the very reason that 69A is bad, petitioners assailed sub-rule 2 of Rule 3, saying that it is vague and overbroad and has no relation with the subject specified under Article 19.2. One of the petitioners' counsel also assailed Section 79(3)(b) to the extent that it makes the intermediary exercise its own judgment upon receiving actual knowledge that any information is being used to commit unlawful acts. Further, the expression unlawful acts also go way beyond the specified subjects delineated in Article 19.2. Now, my lord, comes the most important.
121 and 4,
That
last
is the
5
crux.
lines of 122.
Crux of that. I read all this only to show to your lordships what is the flow of thought in the Supreme Court before they came to the conclusion.
Conclusion at 121 and 122.
Before that conclusion, how it has all been analyzed. That's the reason why, my lord, I pointed out all these paragraphs. Now, please see 121, my lord. That's a very important aspect of the case.
Yes.
It must be appreciated that Section 79 is an exemption provision. It being an exemption provision, it is closely related to the provisions which provide for offences, including 69A. We have seen now under 69A, blocking can take place only by a reasoned order after complying with several procedural safeguards, including a hearing to the originator and intermediary. We have also seen how there are only two ways in which a blocking order can be made. One by designated officer after complying with the 2009 rules, and the other by a designated officer when he has to follow an order passed by a competent court. The intermediary applying its own mind to whether information should or should not be blocked is noticeably absent in 69A read with 2009 rules. 79(3)(b) has to be read down. This is what I mentioned. Your lordship asked me whether it's been read down. It's been read down here. 79(3)(b) has to be read down to mean that the intermediary, upon receiving actual knowledge that a court order has been passed, that is where, my lord, that was added, has been passed, asking it to expeditiously remove or disable access to certain material, must then fail to expeditiously remove or disable access to that material. This is for the reason that otherwise it would be very difficult for intermediaries like Google, Facebook, etc. to act when millions of requests are made, and the intermediary is then to judge as to which of such requests are legitimate and which are not. We have been informed that in other countries worldwide, this view had gained acceptance, Argentina being the forefront. Also, the court order and or the notification of the appropriate government or its agency must strictly conform to the subject matters laid down in 19.2. Unlawful acts beyond what is laid down in Article 19.2 obviously cannot form any part of Section 79. With these two caveats, we refrain from striking down. This, my lord, is the position so far as Shreya Singhal is concerned. So what emanates or flows from Shreya Singhal? One, my lord, that 79 is an exemption provision. Second, my lord, 79(3)(b) is not a standalone provision.
Yes.
It is to be read closely related to Section 69A. It is subject to the same procedural safeguards as contained in 69A. Therefore, my lord, if these three propositions clearly flow from the reasonings and the findings of the Honorable Supreme Court in Shreya Singhal, I ask myself, my lord, how can it be said that under 79(3)(b) we will appoint officers, designate officers all across the country, not one, it can be in tens and thousands, and I receive these don't provide access orders. I'm using the language of the statute. Don't provide access orders from thousands of officers all across the country. Each has his own sense of what is lawful and what is unlawful. Now, this, I would respectfully submit, my lord, is a classic example of arbitrariness at Article 14. In fact, I would say, my lord, this is a textbook example of how Article 14
is violated.
This is, now my lord, contrast this with what is there in now in 79, contrast with 69. 79 is one officer. 69
is a committee.
No, my lord, 69 is committee, but 79 is only one officer.
79, one officer.
One officer.
Correct.
And officers, at the discretion of the government, they can nominate whomsoever they think is appropriate.
Yes.
My lord, I suppose, my lord, it's now well established that a decision taken by a body of individuals is superior, is deemed to be superior in quality than decision taken by an individual. Your lordships have held that way in so many cases, my lord, especially where we challenge tenders. Award of tender will say, no, it's done by a committee. And a decision taken by more than one application of mine by more than one person is better than the application of mine by one person, however good or bad the decisions may be.
Collective decision.
Collective decision. Now, what happens to that concept of collective decision? Is that not, I ask myself, my lord, part of non-arbitrariness under Article 14? I would say, my lord, if you leave it to the decision of one individual and in respect of the same subject matters. Now, is it not, my lord, not only arbitrary, but also discriminatory? A government can choose to say, with respect to the same information, in a given case, I will go through the process of 69A. With respect to the same information of somebody else, I will simply adopt the course under 79. That, my lord, would be treating equals as unequals, and that is fatal for the purpose of Article 14. That's, my lord, my submission on this aspect. Now, my lord, I will request your lordship to kindly see, my lord.
The rules?
No, I want to point out your lordships, my lord. how one must read 79 as a holistic provision. 79(3)(b) cannot be dissected from the subject matter of 79. The only object of 79
Exemption.
is to grant exemption. It was never intended that under 79 there is a conferment of a power. It is a disabling provision. If
This is to buttress your challenge of 3D. Yes.
yes, and to say that you cannot use 79(3)(b) as an engine to pass a non-access order, which according to me is a blocking order. You may use any language, make it. And importantly, all these provisions were introduced by the same amendment. One was introduction, the other, my lord, was substitution.
Substitution.
It doesn't really matter too much for the purpose of this case. When all this was there, when the parliament knew that they were introducing 69A and they were also introducing 79, it was not their intention that 79 can subvert 69A. It was obviously for that purpose. In this context, my lord, I want to place for your lordship's consideration. My lord, I will give your lordship's, my lord, a list of authorities, my lord, which I want to place for your lordship's consideration.
Given already?
Kortai.
2 volumes of. List of authorities?
Yes. List of authorities with the authorities.
With the author.
With the, and I'm not going to. My lord, what we have done is, in order,
No,
I
with
understand.
that list of authorities, if you had given a gist of authorities.
We have,
it
my
would
lord. The list also contains a gist.
All fine. Yes.
I initially thought that there are four sets of one volume.
Four volumes.
No, 4 volumes.
4 volumes. Yes.
The list also contains a gist. So that, my lord, I don't want to take your lordship's way. Everything. I'm
Yes,
just going to
that
show
is
the
fair.
list and then say these are the proper and fairly well settled, familiar propositions. There are a few propositions that I want to show to your lordships particularly.
Yes.
But generally, my lord. Now, my lord, kindly look at the first one, my lord. Heading of a chapter and marginal notes can be referred to while construing a statute. Lord, I'm not going to read that.
Settle.
I've just given it for purposes of completeness. I'm not going. Then, my lord, statute will be read as a whole, and one provision should be construed in reference to another provision in the same act. My lord, that if your lordship will kindly see, my lord, page 57.
Yes. '79 should be in reference to 69.
Yeah, that's the. Therefore, you should not use 79
In
as
isolation.
a standalone. Read it along with 69. That's the point.
79 cannot be read in isolation.
Yes,
It should be read in,
Okay,
in
that's-
tandem with 69
Yes,
is what you say.
Yes, please see para 18, my lord.
Yes.
A statute will be read as a whole. And
Yes.
one provision of the act should be construed with reference to other provisions of the same act so as to make a consistent enactment of the whole statute.
Yes.
Then, my lord, serial number 3, my lord, I'm not going to detail your lordships. Then, my lord, serial number 4 is also a well-established proposition.
Yes.
Namely, my lord, courts make every effort to save a statute from becoming unconstitutional. In any event, my lord, today, 79 is not unconstitutional because
It's
Honorable
already
Supreme Court has
considered.
upheld it. Now, my lord, the one judgment that I want to place for your lordship consideration, my lord, is the 5th one. That is, my lord, in Sharad Babu's case. If your lordships will kindly see, my lord,
Sharad
page
Babu.
111. Paragraph number 31. Having noticed the provisions,
Yes.
it has to be recapitulated that section 67 clearly stipulates punishment for publishing, transmitting obscene materials in electronic form The said provision read with 67A and 67B is a complete code relating to offences that are covered under IT Act. 79, as has been interpreted, is an exemption provision conferring protection to individuals. However, the said protection has been expanded in the dictum of Shreya Singhal, and we concur with the same.
Yes.
So therefore, my lord, section 79 is not to be used as a sword. It is an exemption provision, and this has been reiterated, my lord, following Shreya Singhal in Sharad Babu's case.
Yes, sir.
Then, my lord, Samtel says once it has been upheld in one case, because one of the objections taken in the statement of objections is 79, the virus of 79 has not been challenged. My lord, the complete answer to that contention is serial number 6. A provision need not be challenged in subsequent proceedings if it has already been read down in prior proceedings. And then, my lord, another defense taken, that's the reason why we are giving this serial number 7.
Minerva Mills.
Minerva Mills case. My lord, the reason why we are giving this to your lordship is because defense taken is, you are a company, therefore you don't have a right under Article 19.
No, you're a company not not
Doesn't matter.
Indian origin.
Doesn't matter. Even if it is a company in India.
Only 14 is applicable.
That's right.
No, no,
That's-
for a foreign company,
14 is available.
14 is available.
Available.
Not
Yes,
19.
exactly. Man. I'm saying, my lord, even if it is an Indian company,
That is
19 may not be available.
19 is citizen centric. 14 is person centric.
Exactly.
Yes.
But the answer to that is 14, 21, 19 is a golden triangle. Therefore, something which falls foul of 19 cannot be said to be intra-virus 14. But if something is bad under 19, it cannot pass the muster of 14. My lord, arbitrariness, my lord, is a very all-encompassing concept. Therefore, my lord, even if 19 is not applicable, but if it is violative of 19, it would fall foul of 14. And I rely, my lord, upon Minerva Mills case to say that Article 14, 19, and 21
Golden triangle.
golden triangle insofar this country is concerned. Therefore, my lord, a foreign company, even if it is not entitled to protection under Article 19, if I am able to show that
14, yes.
14, and why 14, my lord? Because it falls foul of 19.
No, 14 is the only article in the constitution that is pervasive to every person. As I said, 19 is citizen centric. If otherwise you can,
Yes, ma'am.
that's what I.
Yes, and the 21 is also, my lord, all pervasive. Of course, it doesn't apply to corporates. Even a foreign national can invoke 21. 14 and 21 are available, my lord, to foreign nationals and foreign corporates, whereas 19 is citizen centric.
Yes, 19 is citizen centric.
Of course,
Corporates,
I
yes.
agree.
Corporates
21 doesn't apply to corporate.
The
Absolutely.
individuals.
Huh?
Putaswamy says it applies.
Which one?
Putaswamy.
Which one? Yeah, what does it say?
Putaswamy is there.
What does it say? What does it say?
That it applies to corporations.
Even
Which one?
foreign companies can take this one.
So,
So please go to page 238.
Which paragraph?
363, sir.
Huh?
363.
Putaswamy, 363.
Madam,
As it is now clearly held by this court, rights guaranteeing confinement may only be incorporated.
My lord, there's some. I'm thankful to Melon friends for pointing it out, my lord. There is some development in the law. Please see the judgment of the Honorable Supreme Court in Putaswamy's case. My lord, if your lordship will kindly see serial number 8, and your lordship kindly turn to page 230, paragraph number 363. Yes, page 230, para 363.
Yes.
The question now arises as what is the purpose of the framers of the Constitution sought to achieve by specifically enumerating some of the freedoms which otherwise would form part of the expression liberty. To my mind, the answer is that the Constituent Assembly thought it fit that some aspects of liberty require a more emphatic declaration so as to restrict the authority of the state to abridge or curtail them. The need for such an emphatic declaration arose from the history of this nation. In my opinion, the purpose sought to be achieved is twofold. Firstly, to place the expression liberty beyond the argumentative process of ascertaining the meaning of the expression liberty. And secondly, to restrict the authority of the state to abridge those enumerated freedoms only to achieve the purposes indicated in corresponding clauses 2 to 6 of Article 19.
Oh, they corporate. To counter the statement of the learned SG.
Yes, there seems to be some
No,
development.
here, as of now, clearly held that this court has rights guaranteed in 14 and 21, not confined only to citizens.
Yeah.
21, yes, it is.
But available
Even to non-citizens, aliens,
or
or
incorporated
incorporated
bodies.
bodies, even if they are incorporated, not incorporated in India.
I'm aware of it. I'll
Is
deal
it?
with it.
Yes.
No, no, I just wanted to bring it to your lord.
Not a statement of law.
This is the, this is not, this passing reference, I guess.
My lord, not really. I will reserve my
Obiter.
submissions on that
Obiter.
after I have had the benefit of hearing the learned solicitor, my lord. I will be
Yes,
more
sir.
enlightened after we hear my learned
Yes,
friend's
yes,
submissions.
yes.
Well, there's one other judgment. Please be kind enough to turn to page 252. Of course, my lord, it is a judgment of the single judge of the Calcutta High Court, but I'm placing it for your lordship's consideration as throwing light on the subject. Para 5. This position would not change in respect of a company incorporated outside this country. A foreign company in any event has a right to sue, and there is no bar under the CPC also in that regard. In the Constitution of India, rights under 19 can be enforced by a citizen alone. So far as Articles 14 and 21 are concerned, the expression citizen has been omitted, and the fundamental right guaranteed in these articles protect the citizens and non-citizens alike.
Challenging industrial award.
Yeah, that's true. That's true. That's true. But that was by a foreign corporation. But
Correct.
then,
Hong
my
Kong,
lord,
Hong Kong and HSBC
yeah,
Bank.
HSBC.
Bank.
Yes, my lord, HSBC. Yes. My lord, that's the proposition, my lord, that I wanted to place. And then, my lord, of course, serial number 11.
That is settled. Article 14 can be invoked by a non-citizen.
Today, Article 21 also can be done. And it can be done by a incorporated company, even
There-
though it is incorporated outside the country.
There I am a little, anyway, the learned SG will.
Very well. But I will, as I said, I will
Yes.
reserve my submissions after.
Indian companies cannot have Article 21. That's the-
Let
my
alone for
understanding.
peace, yes.
Very well. Very well. Now, my lord, I started my submissions by pointing out your lordships that Article 14 has two components, substantive and procedural. And even if I am able to show that substantive is within the passes the muster of Article 14, if procedurally it does not, then, my lord, there is a problem. And therefore, read down 79 to make it fall in conformity with the procedure prescribed in 69A. That's the submission. That is the doctrine of.
So ultimately, you want to intertwine the two, draw the procedure under 69A into 79, according to you, to make it constitutional.
And that is how the Honorable Supreme Court and Shreya Singhal said, we will read it down. And Shreya Singhal, my lord, upheld it only because of the reading down.
3.2 and 3.4 is interpreted in Shreya Singhal. 3.2 and 3.4 of the 2011 rules.
Yes.
Correct.
Yes, correct.
Now, the apex court did not interpret the subsequent, it had no, this 2021 rules.
No, not,
21 rules are not interpreted
but
by,
in any event, my lord,
by-
there is not much of a
there is,
change.
I
I
don't
will
think
show to
the-
your lordship the truth.
the apex court has not, because
No.
Shreya Singhal was rendered on 24th March 2015.
Yes.
2015, I guess.
Before
It
the
was
new rules.
2015 judgment, when 2011 rules were in place. Now 2000, blocking rules are there then, now, and of course, future we don't know. But these rules 3, 1 and D, which is now come in 79, and the rules of 2021 has not been interpreted by any court. or the Bombay High
But
Court.
it
that's
is,
all.
there's not too much of
So
change.
there's-
There's not too much.
That's
of
a different
change.
thing. I'm only asking whether
Yes, my lord. Answer to your lordship is yes.
the apex court definitely has not interpreted. There is a change in 2021.
Bombay has.
Bombay has. Apex court has not there's a change in 2011 rules and 2021 rules, even according to you given a chart in that memo. What is the difference?
No, my lord. This one. Oh, this, your lordship is referring to this chart. Yes, yes, correct.
Last page of
Yes,
that
my
chart.
last
Yes,
page, your
correct?
lordship, yes.
You've given that chart.
Yes.
So there is a change in both. The
Yes.
change has not been interpreted. That's
No,
all.
it's not.
So there is no apex court judgment which binds this court of interpretation of the 2021 amended rules. That's
But,
no, it may be the same or whatever. I just wanted.
yes, but,
There is no interpretation.
but 79 has been interpreted.
79 has been.
79 has been read down.
No,
The question is,
79
what is the
Shreya
meaning of
Singhal
reading
has
down?
been interpreted. It is said we are saving it from becoming,
reading
declaring
it down.
unconstitutional for these reasons. That's all.
That's the crux of the matter. my lord.
That's
If 79 has been read down and saved because of what we are reading in 69A, and we are reading the two as forming part of one holistic scheme, then, my lord, I ask myself, can 79 be said to be a separate source
That
of
way,
power?
yes.
That's the question. According to me, my lord, when we read the judgment in Shreya Singhal in its completeness, this is the inference, according to me, which falls from Shreya Singhal. Now, my lord, I go to the next one, my lord, 31D. Your lordship may kindly see serial number 12.
rules.
Yes, my lord.
2021 rules.
Yes, my lord.
Yes.
My lord, it must conform both procedurally and substantively. It must conform to Article 14.
Yes.
And that, my lord, is the old judgment of
No, that is,
Sarkar.
Article 14 is all pervasive.
All purpose.
Yes.
My lord, I'm leaving this, my lord. I don't think I want to. Then, my lord, your lordship may kindly turn to serial number 15.
50,
1-5. I want to point this out to your lordships.
seal number 15, where?
Yes, one.
Judgment.
Sitaram Sugar. Yes.
Yes.
The judgment. Yes, my lord.
Yes.
The gist and the
Yes.
both are there.
Sitaram Sugar Mills. Yes.
Sitaram Sugar.
Yes.
Now, my lord, Sitaram Sugar Mills lays down a very important proposition that equality should govern every state action, whether it is legislative, executive, or quasi-judicial. Now, my lord, I ask myself, same act, because if we read, my lord, 69A and we read Rule 3(1)D, they virtually cover the same heads. If your lordship will kindly take that comparison chart between 69A and 3(1)D.
Yes. Last page.
No, my lord, page 2 of this memo.
Memo.
Before the flow
Yes,
chart.
yes, yes.
Before the flow. Please see, my lord. 19.2, your lordship may keep it aside. That's it. That's a point on which I've already made my submission.
Yes.
That you can't go beyond 19.2.
Yes.
Now kindly see 69A. Now, my lord, these 6 grounds or heads provided in 69A are also found in Rule 3(1)D. Therefore, you will treat somebody under 79 read with 3(1)D, somebody else for the same post, you will treat under 69A, adopting totally different procedures. That, my lord, is impermissible, is what Sitaram Sugar Mills case is. Now, my lord, please be kind enough to turn to that. If your lordships will be kind enough to turn, my lord, to page 583. If I may trouble your lordship to kindly see para 45. Though, of course, my lord, we understand this is the essential commodities act, price fixation. No, that's a different matter.
The concept of
Concept,
equality.
exactly. Price fixation is in the nature of a legislative action, even when it is based on objective criteria founded on relevant material. No rule of natural justice is applicable to any such order. It is nevertheless imperative that the action of the authority should be inspired by reasons. The government cannot fix any arbitrary price. It cannot fix prices on extraneous considerations. Any arbitrary action, whether in the nature of a legislative or administrative or quasi-judicial exercise of power, is liable to attract the prohibition of Article 14 of the Constitution. I'm on para 45
yes,
and 46 at page 583. My lord.
46 is what?
Yeah. As stated in E.P. Royappa versus State of Tamil Nadu, equality and arbitrariness are sworn enemies. One belongs to the rule of law in a republic, while the other to the whim and caprice of an absolute monarch. Please substitute the word absolute monarch with the nodal officer in the notifications issued.
Yes.
Unguided and unrestricted power is affected by the vice of discrimination. The principle of equality enshrined in Article 14 must guide every state action, whether it be legislative, executive, or quasi-judicial. Therefore, my lord, whether it is arbitrariness or whether it is discrimination, either way, Rule 3(1)(d) must go.
Yes.
You choose one person for the same content and take action under 79 read with Rule 3(1)(d), saying there is a power given to me under 79, therefore I will follow the procedure prescribed under 3(1)(d), which is no procedure at all. But in another case, I will go through the rigmarole of the elaborate procedure given under 69A. I ask myself, what is who chooses this? So, and very interestingly, my lord, every officer who is authorized, how many officers are authorized? How many? My lord, I'm given to understand in all across the 30 states of the country, notification for how many thousands of officers? I don't know. And I'm sure hundreds of officers have been appointed. So, my lord, that officer will decide.
As nodal officers.
Nodal officers under the notification. I showed your lordship the
No,
notification.
under the act, officer means a nodal officer appointed.
The agency is what they say. Agency. Under 79, the word used is agency.
Agency, correct.
And so, my lord, one officer thinks this is in my. Each one, my lord, has their own sense of right and wrong. Each one, my lord, has its own sense of morality. Each one, my lord, has a sense of what is lawful and what is unlawful. So this is dependent upon what is good in one state. The other state may not think it is requires to be notified. How does it work, my lord? How does this work? At the whims and fancies of that one person? This is nothing is centralized. There is no coordination, nothing. This is a serious flaw in 3(1)(d), my lord. That's why these notifications are issued without any regard to the scheme of 69A. This is the point that I want to drive home to your lordships, my lord. Now, my lord, in Madras Bar Association case, we are also placing reliance on that to say that separation of powers is a very important aspect of the Constitution. On that proposition, there can be no dispute. Why am I importing that into this case, my lord, is what your lordships may ask me. Now, my lord, there is a particular act which has been done, which comes within the purview of any information which is prohibited under any law for the time being in force. Whether a particular information is prohibited under any law for the time being in force, and I'm now going to show to your lordships what BNSS says with respect to this, and how there is a parallel. One is a complete judicial approach under BNSS, the other is a complete arbitrary approach at the instance of a sole officer.
Nodal officer.
Nodal officer. And now, my lord, one officer can say, well, according to me, this information which you have put on your portal is prohibited under a law. And he issues a non-access order or notice under 3(1)(d), read with 79(3)(b). Tomorrow, my lord, after years, the court takes a view that this information is not something which is prohibited under any law for the time being in force. So, my lord, who judges whether it is prohibited under any law or not? It is the court which has to judge it, not this nodal officer. That is why, my lord, we are saying the power to judge has been vested with an executive officer who does not perform even a quasi-judicial function under the rules. That is why, my lord, we are saying that the doctrine of separation of powers has been violated. Now, my lord, I pause for a moment here to point out to your lordships, my lord, an important provision of the BNSS. My lord, would your lordship kindly look at BNSS? Criminal, first, give me BNSS or criminal procedure? BNSS, give me the. Yeah. Yeah, the destroyer.
98.
The destruction of.
Yes.
Yeah.
Section?
I give you. In a minute, I'll give you.
501.
Well, please be kind enough to turn to section 501 of BNSS. On a conviction under section 294, section 295, or subsection 3 and 4 of section 356 of the BNS, the court may order the destruction of all the copies of the thing in respect of it the conviction was had and which are in the custody of the court or remain in the possession or power of the person convicted. So, my lord, when you want to order destruction of whether, my lord, it is a accepting, as your lordship indicated, the speed of communication. The content is the same whether it is in print or whether it is in electronic media. The content is offensive.
So
When it comes
that is
to
the whole problem. If it remains or once broadcast, I may forget, you may forget, you may forget. Internet never forgets.
internet never forgets.
It remains there. That's the reason why it is asked to take down or delete or whatever. If it is unlawful, it is offensive or whatever.
But when can it be done is the question. Now, if in respect of a book, which also is permanent, my lord,
Correct.
it remains. Books always remain whether we read it or not.
No, it may remain, but sometimes it is localized. This is not that way. It is global.
It's true, it's true.
Reaches
It's true,
beyond
It
imagination.
is true. Without any doubt, it has revolutionized the entire information dissemination industry. There's no doubt, my lord. But what I'm trying to point out to your lordship is, if, as I point out to your lordships, the rules for the application of Article 19, whether it is to the electronic media or to the print media, the same rules apply for the purpose of testing constitutionality. Now, I'm giving your lordship another indication to show that insofar as a defamatory matter is concerned, because this refers to libel, doesn't matter. Defamatory matter is concerned, if you want to destroy a book which has defamatory matter, it is only after the court has looked at it.
Correct.
Now here, you are destroying it before the court has looked at it. Is that purpose?
69A is not predicated on unlawfulness.
And then, my lord, if this is the position so far as the book is concerned under 501, now please go back to 69A for a minute.
Yes.
If your lordship will kindly see 69A for a minute, my lord, once again. All that it says is defense, interest of the sovereignty and integrity of India.
Correct.
Defense of India.
Yes.
Security of the state.
Friendly relations
with foreign states.
Public
or
order.
public order. Or for preventing incitement to the commission of any cognizable offense related to the above. My lord, I ask myself, where is unlawful? In 69A.
Everything connected to this is unlawful.
That is all. That is all.
Absolutely.
Not the catch-all provision.
No,
that is there
I'm not talking of the third column in the chart.
Yes.
This is only 69 with reference to whatever is there,
Yes.
any act contravening these things would undoubtedly be unlawful.
Somebody has to determine it.
No, unlawful acts are already determined because
No,
they are,
whether-
no,
whether a
those are penal provisions already there.
Right, these are enumerated.
Enumerated unlawful acts, imaginary unlawful acts, nobody is telling.
Whether the facts of a particular given circumstance constitutes an unlawful act has to be determined.
Oh, you mean to say determined by a court of law?
Yes, of course, my lord. There are so many instances. For example, my lord, your lordship, I'll give your lordship some examples of where it has to be determined. Where are those examples that we had?
That's exactly what I said in the morning. By the time of such determination, damages cost.
That is why, my lord, we have emergency provision. That is also been envisaged by the statute and the rules. That is why, my lord, emergency provisions, post-decisional hearing, completely absent in 79. Where is this? If we can refer to this. My lord, if your lordship will take these notes that we had given.
Yes. Huh.
My lord, please see para 9, page 3.
Notes, which notes?
The notes that were filed yesterday, my lord, it was given, I don't know whether it will put up in the file.
Notes, yeah.
We have another copy.
Yesterday you gave?
We have another copy. Well, we have another copy. Can we give it to you?
Please. Even if it is marked, don't worry.
Give this.
Which notes? Yesterday you gave, is it?
Nenne mentioned, it appears.
Oh, yes. I may not have been with in
But
the
it
file.
could be.
Yes, yes.
In fact,
Copy is given to the other side?
yes, but copy go to the other. Given a copy to the other side. So given it. Oh, give another.
Oh, your synopsis of arguments.
Yes, but yes, but that's what I meant.
Ah, yes, yes.
That's what I meant. Give me. But may I request your lordship to kindly see. Lord, page 3, para 9.
Yes, I'm there.
79 3B.
Yes.
Does not empower the government or its agency to unilaterally determine that information is prohibited and unlawful for the time being in force. To arbitrarily determine that information is unlawful would be the exercise of a judicial function and violate the doctrine of separation of powers. There should be a determination that the information is an unlawful act by a court, not unilaterally by executive officers and police. This can be explained by the following examples. Now, your lordship may kindly see, my lord, we have tried to be as clear as possible on this aspect. Defamation. Whether a content is defamatory requires a judicial determination in cases of both civil and criminal defamation. Executive authorities cannot decide if content is defamatory. In fact, as held by this honorable court in
When police has no power.
Police also has no. But here, a nodal officer has got the power. That is the problem.
So
my
that is for the purpose of conviction.
No, my lord. See, that is for the purpose. I understand, my lord. That whether it is for the purpose
That
of
interpretation is for the purpose of
yes,
conviction.
my lord. I understand, my lord. I understand, my lord. Divya's case is for the purpose of conviction. In fact, it's my lord's.
Correct. Yes, it's my order.
I know.
Yes.
I am aware of that. But it makes that fact
Makes no difference.
makes no difference. The question is, can a police officer make a determination that something is defamatory? Can a nodal officer?
You want to paraphrase police officer with nodal officer?
Absolutely.
Yes.
In fact, I want to paraphrase that and say, and as the Honorable Supreme Court said, my lord,
In Shreya Singhal.
in unquestioned monarch.
With the nodal officer.
And some of the persons who are appointed are all only police officers under the notifications. I'm going to show to your lordship next those notifications. Yeah, I'm coming to that. I'm coming to that. So may I read this?
No, police officers may be appointed as nodal officers, but the power that they are wielding is on different statutes.
Exactly. But I am not for a moment saying that you can't appoint a police officer. But if you have the power to appoint an agency, you can have anybody as an agent. That is the wisdom of the government. We are on the question of not who is the nodal officer or who is the agent. We are on the question as to what power that agent can wield?
Yes.
That's the question, my lord. And if a particular defamatory content, what is defamation, my lord? What is constitution defamation, as your lordships would be aware? What is defamatory in one part of the state is not defamatory in Bangalore. What is defamatory in Bangalore is not the same words which are used elsewhere are not defamatory. In fact, my lord, in some parts of the state, some words which are used here, which we take offense, are used there, my lord, as
Colloquial.
colloquial, and they're used, my lord, for the purpose of affectionately calling somebody. Now, in a situation of this kind, the officers will decide, my lord, who is going to take into account all these factors. This is completely, my lord, unbridled power given to an executive officer to come to a conclusion on a set of facts which are complex in order to arrive at a conclusion as to whether it is unlawful or not. Now, my lord, may I complete reading this, my lord? We just put one more example. In fact, as held by this honorable court in Divya, a police officer has no power to investigate defamation because it is a non-cognizable offense under 199 of the CRPC, 222 of the BNSS. It is only after a court adjudicates that the information is defamatory and issued an order under 501 BNSS that 79(3)(b) can be invoked. This is our first submission. Now, my lord, kindly say about obscene material. Publication of obscene material is a distinct offense under 294-296 of BNS or section 67 of the Information Technology Act. Whether the material is obscene or not is a matter for determination by the courts under CRPC or BNSS.
No, if an obscene material concerning a person's privacy is posted on the platform, you want determination under the IPC.
That is one way.
Saying that whether it is obscene.
No.
On the face of it, it would be obscene.
Just 1 minute.
Then what do you do?
Can the police officer arrest a person posting obscene material?
Yes.
Because then he would be a judge in his own.
Yes, that procedure is to be followed now.
All that I'm
What
saying
is
is
said is when such obscene material is posted on a platform or an intermediary, it is on the face of it obscene.
Yes.
So nobody need judge that it is obscene or not. Take down that is what is
Respectfully,
said.
my lord, respectfully. Even on obscenity, there are no objective standards. I mean, I make this statement, my lord.
No. Then you are saying what it is in the eyes of the beholder?
My lord, it is not only in the eyes of the beholder, it is also depending upon time and circumstances.
All
But
right.
it's a very complex question, my lord. It's a very complex question which requires the application of a judicial mind. And it cannot be decided by a police officer.
No. Obscenity pervades everything. Obscenity to the eyes. That's what I said. That the eye who sees obscene, it is obscene.
Correct. Adopt 69A. 69A.
That's a different thing.
That's
you
the
say
point, my
even obscenity cannot be decided by a nodal officer. If something is, you take for example the deep fake pictures that are there of it invades right to privacy straight away.
Yes.
And that is posted.
Yes.
You mean to say there should be a judicial adjudication whether that is
69A.
69A. 69A again goes to the committee and other.
No,
it
that
is on the face of it obscene.
No, that is why, my lord, I said there is an emergency power. My lord, that is the complete answer to say that all this process of going to committee, review committee, monitoring committee, all that takes time. But there is the emergency power. My lord, lawmakers have already envisioned that situation. It is not a vacuum. If everything has been taken care of, then
69A with 79 comes in 2008. Amendment in 2008.
Together. 79 came in, 69A was substituted.
All right, yes.
So it's the same. So I ask myself, why not go into 69A procedure? What is so objectionable about it? Which 69A has all the procedural safeguards, 79A has no
So
procedural
the
safeguards.
entire fulcrum of the submission is dehorse procedure 79 should not be permitted to stand. That's
Well,
all.
I know,
31D rather.
31D cannot
31D should not be permitted to stand.
Correct. It's because 79, my lord, because
It's
the
already
Supreme Court
by
has-
the apex court in Shreya Singhal. Now this 31D should not be, that's the fulcrum of the
That's the
submission.
fulcrum. And what is the meaning of the words? Read it down. The On the face of it, it looks like 79 is a very wide power given. No, no, read it down to say that that power is circumscribed by the procedural restraints in 69A and therefore 79 is valid. That's how, my lord, the rationale of Shreya Singhal is. Now, my lord, please be, let me complete this. I'll come. Now, please see obscene material. Publication of obscene material is a distinct offense under 294-296 of BNS. Whether material is obscene or not is a matter for determination by courts under CRPC or BNSS. It is only after a court adjudicates that information is obscene and issues an order under 501 that 79(3)(b) can be invoked. That is one circumstance. Now, my lord, please be kind enough to go to next one. After a blocking order is passed under 69A of the IT Act, pursuant to the procedure in 69A2 and 2009 blocking rules, 79(3)(b) can be invoked to notify the intermediary. That is the second way in which 79 can be enforced. One is when there is a court order. Of course, my lord, what will be put to me is, look, that's going to take time. So do you mean to say that all this can remain for years, which will be consumed in completion of a criminal trial? Is there no way in which it can be stopped, having regard to the potency of a media like this? That is why they came up with a new law. Though, my lord, general law covers many things, they said, no, I must have a new law which covers a new situation, namely the information technology. That is why the new law came into force. Now, the new law envisages that without going to court, I should have the power to stop something. Now, does it mean that that power can be exercised by one officer? They said, no, no, it can't be done that way. We have to make it reasonable, because protection of information is very important, having regard to 19(1)(a) and having regard to the fact that we cannot have arbitrary exercise of power under Article 14. Therefore, the lawmaker said we have to provide certain safeguards. And they were right. It stood the test of the judicial scrutiny. If they had not, 69A also would have been struck down. Now, this is how the history of legislation is. And now, please see. Therefore, is it the requirement that there should be a court order always for the purpose of 79? No. 69A is there. 69A is there. Do it. And emergency provision is there. My lord, see, my lord, how the legislatures have covered almost every aspect of this subject. And this is a completely occupied field. And your lordships may wonder why I'm using that word occupied field when I'm making my submissions on the Sahyog portal. That becomes relevant. My lord, let me read this, my lord, complete, just this paragraph. After a blocking order is passed under 69A1 of the IT Act, pursuant to the procedure in 69A2 and the 2009 blocking rules, 79(3)(b) can be invoked to notify the intermediary if respondents allege that information takedown is necessary or expedient in the interest of sovereignty, integrity of India, defense of India, security of the state, friendly relations with foreign states, or public order, or for preventing incitement to the commission of any cognizable offence written above. They must follow the 69A process, not issue takedown orders under 79(3)(b).
Even for obscene material?
69A. My lord, there, under 69A, there can be an order for takedown. Because, my lord, your lordship may kindly see that the chart that I gave your lordships, my lord.
Under which clause?
My lord, kindly see, my lord, where is that? My lord, please look at this.
Rule
Comparison
9.
chart.
That's in Rule 9.
Yes, that is the emergency provision. That is right. Now, please see, my lord, the chart again. Kindly see, my lord. Decency and morality will be covered under 69A and under 6. For preventing incitement to the commission of any cognizable offence. And decency or morality is also.
Public order.
And.
I just
Ah,
legally
yes, yes.
I'm not sorry for the interruption. The term decency and morality within which the obscene material would fall is only in 3(1)(d).
Yes.
69A does not have decency and morality. My learned senior is reading 6 in 69A, preventing incitement to the commission of any cognizable offense relating to above, meaning thereby interest of sovereignty, etc.
It is only in 3(1)(d)
That
of
decency and
the
morality.
2021 rules that you find that obscene, that's what's it, decency and morality.
Correct.
69, it doesn't contain that.
That is why, my lord, concentric circles argument becomes relevant because it comes under public order. That is why I cited that judgment for your lordship's consideration.
Yes.
My lord, that public order, which is serial number 5 in 69A,
Correct.
encompasses serial number 5 in rule 3(1)(d).
No, public order is already there in 3(1)(d).
Yes, it is there.
It is there in
It doesn't matter, my lord.
3(1)(d). It is added thing is
Added
decency and
thing,
morality.
added thing. It doesn't really matter.
So 69A and 3(1)(d) are the same insofar as a few options up to public order is concerned.
Yes.
What is later is decency and morality and any other information prohibited by law.
Yes, that's correct. That's why, my lord, now decency and morality is found only in rule 3(1)(d). Correct?
Yes.
Now, is decency and morality part of public order? Answer is yes. Answer is yes. Having regard to, my lord, the judgment of the Supreme Court.
In Ram Manohar Lohia.
Yes, that's the concentric circles.
That's why I said Ram Manohar Lohia in 1966. Yes, then nothing was there to say whether decency or morality. Public order, interpretation of public order then was of a different
But kindly
idea.
look at
The
one other.
horizons of interpretation has now grown so much that you'll have to bring in decency and morality into public order also. So that is why separately it is done.
They enumerated it separately, but it does not mean that it is not part of public order.
I'll see, yes.
That's how I would put it. Otherwise, and this concentric circles argument is not discarded, my lord.
No, it's not discarded.
It is followed. It is followed.
No, that is slightly distinguished in the very subsequent judgment of Ajay Mohan or something, para 37 of Shreya Singhal. Last 5 lines of para 37 of Shreya Singhal says, this Ram Manohar Lohia judgments, the concentric circle, its application should be on case-to-case basis.
No problem, my lord. Please do it that way.
That's how even the flow of thought in Shreya Singhal goes.
Good be.
Yes.
Show me. Social Kishore. Well, there's one other judgment that I want to point out, your lordships, my lord, on this point.
Page 1285.
1285,
volume 3. Volume 3, page 1285.
Which my 30?
Volume-
Well, it is serial number 34.
Volume 3, 1285.
And your lordships may see 1289.
Obscenities at
Paragraph?
1286.
1286, bottom of the page.
Decency and morality.
Not public
Well,
order.
please see para number
298 IPC. IPC, it's always there.
Public order.
Public order, decency, morality, they are there in IPC.
No, my lord, kindly see from para 31.
Even in BNS, you'll find it.
Yes. Kindly see para 31, my lord, from at page 1285.
But what are its ingredients are found there only. Uttering words, etc. with deliberate intent to wound religious feelings is also there. That is 298 IPC. That is why those are for the purpose of ingredients of those offences and securing conviction or otherwise or even acquittal. But here it's a specific law with regard to specific instances on the internet for the intermediary's responsibility. That's what is left. Yes.
I see the point that your lordships are making, my lord. But I ask myself the question.
No, procedure is what you say we'll have to.
And I also ask myself the question. Is not decency and morality a breach of which does it not lead to public order? Are the two, public order on the one hand and indecency and immorality on the face of it on the other, as your lordships put it, are they not strange bedfellows?
Let's see.
I would say they are.
Strange-
They just don't go together.
Strange bed partners, we'll see, yes.
They just don't go together. If something is indecent, something is immoral, it cannot obviously be in tune with public order.
Public order of today, not 1966.
It doesn't really matter, man.
No, it does.
It doesn't.
Public order of 1966 was a different concept. Today, even that is dynamic. It has evolved. Crimes you see of 1966 and today are totally different.
Different.
Because human psyche today of commission of such crimes then and today are totally different.
Totally. Yes.
That's why there is a whole lot of a new concept in criminal law. Now, what used to be robbery in 1960 or 19, no robbery at all. See, today it is on the net. At the click of a button, you lose money.
Yes.
So it's not that robbery was necessary, dacoity was necessary.
I see. For example, something like fishing.
Fishing?
Wasn't PHI
Oh,
SING.
yes. Right.
That was never thought of.
Yes, correct.
And I saw something called doxing.
Doxing.
That is another type of it.
New generation ಹೇಳ್ಬೇಕಷ್ಟೇ ನಾವು.
ನಾನೆಲ್ಲ ಓದ್ತಾ ಇದ್ದೆ ಕಲ್ತ್ಕೊಂಡೆ. Doxing, not.
So that is why
ಕಲ್ತ್ಕೊಂಡಿದ್ದೆ.
laws.
I learned only what it is.
Laws should evolve according to what is evolving as a crime.
Absolutely.
Otherwise, we will remain then and apply the laws of today.
That's why.
If the crimes have evolved, so does the laws evolve. Investigation evolves.
Undoubtedly. Something which was never heard of or today.
Those crimes then never heard are crimes today.
Yes, quite right. I bow down.
That's because the advent of the internet and advent of ease of information.
Yes, my lord.
And the unipolar world with regard to.
We had never heard of what is called as cyber arrest.
Adu agutte.
It's becoming it's a rage.
Then how do you control such things?
Control it. That is by a procedure established by law.
Advent of information technology should not take away the rights of citizens. It should, yes, it does protect the rights of citizens some way or otherwise, but it should no point in time take away the rights of the citizens. So, if it is unregulated, then it becomes a problem.
And my lord, I cannot demur to what your lordships are saying. None of this should be unregulated. The question, my lord, is how far should the regulation go?
That is
how
an
should
answer
the regulation be done?
That we will do.
There's no doubt, my lord. On that, I don't think there is any quarrel with the state. Not difficult.
Yes. Unless the other way he.
I'm coming to it. I'm coming to it.
Aditya Sodhi will.
My learned friend will.
Yes.
He will give a totally different perspective from the point, from the view of a.
I feel like what Karun Nair must have felt, Lord, like Jaiswal was battering.
Okay. Yes.
Very tough act to follow.
All right, we'll see. Yes.
Very well. My lord, I just want your lordship to kindly see Kaushal Kishore for a minute.
Yes.
Please see para 31 onwards, my lord. A careful look at these 8 heads of, my lord.
19.2.
Yes. A careful look at these 8 heads of restrictions would show that they save the existing laws and enable the state to make laws restricting free speech with a view to afford protection to individuals, group of persons, sections of society, classes of citizens, the court, the state, and the country. This can be demonstrated by providing in a table the provisions of the Penal Code 1860 that makes some speech or expression a punishable offense, thereby impeding the right to free speech, the heads of restriction under which they fall, and the category or class of person or persons sought to be protected by the restriction. Now, my lord, then all the provisions of the IPC are extracted. I'm going to skip that. Please be kind enough to turn to para 32. We have taken note of in the above table, 1289.
I'm there.
We have taken note of in the above table only the provisions of the penal code that curtail free speech. There are also other special enactments such as Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989, the Prevention of Insults to National Honor Act 1970, etc., which also impose certain restrictions on free speech. From these, it will be clear that the 8 heads of restrictions contained in 9 clause 2 are so exhaustive that the laws made for the purpose of protection of the individual sections of society, classes of citizens, both the country and the state have been saved. So, my lord, what is contained in 19.2 is very broad. Nothing more needs to be added to 19.2. That seems to be the approach of the Honorable Supreme Court. Now, my lord, I want to point out to your lordships, my lord. Which one?
Page 9 and 10. Just show you.
Uh.
You are authorized. Thank you.
Show it.
Page 9. You are authorized.
Now, my lord, I want to show to your lordships how 379 and 31D are completely arbitrary and therefore 31D requires to be struck down. Kindly see para 38 at page 10 of our notes.
Of the writ petition.
Yes, no, my lord, of the submissions.
Submission.
Submissions. Procedure, the end, Saka. No?
Para 38.
Yes, madam.
Yes. Clause G.
Yes, madam. G. Rule 31D creates a mechanism that allows countless executive officers such as police officers, railway officers and GST officers to decide whether information is unlawful as a matter of law. This includes Superintendent of Police, Deputy Commissioners of Police, Departments of State Police and various officers of central ministries like the Ministry of Finance who can issue takedown orders. Thus, 31D empowers executive officers and not the judiciary to decide unlawfulness, which is ex facie in violation of the doctrine of separation of powers. Under Rule 31D, the following executive officers have been authorized to issue takedown orders through censorship portal. Various officers of central ministries like Ministries of Home Affairs, Defence, Railways, Finance, Heavy Industries, Rural Development, police officers in West Bengal, Goa, NCT of Delhi, Punjab, Bihar, Haryana, Karnataka, Kerala, Nagaland, Odisha, Rajasthan, Sikkim, Tamil Nadu, Tripura, Manipur, Ladakh, Assam, Jharkhand, Jammu and Kashmir, Meghalaya, Mizoram, Andhra Pradesh, Maharashtra, Andaman and Nicobar, Telangana, Chhattisgarh, Puducherry, Himachal Pradesh, Gujarat, Arunachal Pradesh have all been authorized. Police officers have all been.
Bharat Darshan.
Bharat Darshan. And
yes,
Bharat Darshan, and unfortunately, my lord, by a person who has no clue of what is happening in the next door. That is the tragedy. Insofar as 69A is concerned, my lord, it was all centralized. They knew what's happening everywhere. Here, my lord, what somebody who is sitting in Jammu and Kashmir does not know what is happening in Karnataka. The Karnataka police officer does not know what is happening in Madhya Pradesh. This is the type of thing, arbitrary way in which it's done. That is why, my lord, it requires to become regulated in accordance with the principles laid down in Shreya Singhal and the Constitution. That's the point.
Information on the internet has no boundaries.
Unfortunately,
to know
nodal
what
officers
is
have
what
boundaries.
Jammu and Kashmir happens here, what happens
Yes,
here.
unfortunately.
Whatever. It is spread everywhere.
Yes.
Yes.
Information has no boundaries, but unfortunately, the nodal officers have boundaries.
Nodal officers in those jurisdictions may have.
Not only, my lord. When I say boundaries, I am not talking about geographical boundaries. Boundary in thought.
Boundary in thought.
Each one has his own notions of what is right and what is wrong.
Every human being is different.
That should
Boundaries
not,
in thought cannot happen.
But that should not be done in a society governed by rule of law.
That will see.
It can't be that each individual does what he wants on the basis of his or her perception of what is right or wrong. That only can be done by a judge. Of course, my lord, a judge has certain perceptions and the law has given that freedom only to a judge. Each judge, my lord, has his or her own perception. We know, my lord, that there are judges who have a leaning towards management, labor, tenant, landlord. Nothing wrong about it, my lord. Each individual has their own inclinations. I won't even say bias. They have their own inclination, but that is given only to a judge. It can't be to
nodal officer.
Nodal officers. That is why I am saying, my lord, it cannot be that each one does whatever he or she wants. And now, my lord, please see para 40 at page 11.
Yes.
For example, railway officers have issued multiple unlawful takedown orders, and police have issued takedown orders for legitimate public speech, discussion of social and political issues, satire and parody content, and information about the suffering and exploitation of women. Respondents also consistently use 3(1)D to issue takedown orders for alleged defamation. Now, my lord, please see some annexures that have been filed. I want to show to your lordship this. Which is the one that you want to show? Where is that? Huh? Yes, my lord, if your lordship will take the writ petition, or you want to go to the? Yes. My lord, kindly turn to annexure S. Page 325. Page 325
Of
the writ petition, my lord. 326. Please be kind enough to turn, my lord, to page 326 if your lordships are kind enough. Please find attached herewith a notice issued from nodal officer of the Ministry of Railways, along with copy of the Gazette notification authorizing him as a nodal officer for the purpose, wherein he requested the sensitive and disturbing content shown in the links URLs provided as Appendix 1 may please be restricted from public access immediately. An acknowledgement in this regard shall be highly appreciated. Now, my lord, that is a notification appointing him, my lord. And now, please be kind enough to turn to page 300. Where is what is to be taken now? Where is it? Show it to me. That's important. Now, please see page 329, my lord. This is the notice calling for block the access issued under 79(3)(b).
Yes.
Now, what is it that sought to be blocked? My lord, that your lordship will find it's not in this. It is found, my lord, in the rejoinder that we have filed. Huh? Lord, please turn to page 375. Of the rejoinder. No, it's not. That's why I said I didn't call it a blocking order. I call it a non-access order.
Disabling access to
Disabling access order. Disabling access notice.
It's a notice.
And as I said earlier, my lord, to me this is only semantics.
So it's virtually a blocking order.
It's virtually a blocking order. What else is it, my lord?
All right.
I mean, it's all right to make a very difference without a distinction. Kindly see parent 3. In fact, a complete answer to that is found in the writ petition itself. Before your lordship goes to the, kindly turn to page 330 of the writ petition.
Yes.
Now, therefore, in accordance with the above mentioned provisions of law, the intermediary EXCOM or YouTube is hereby notified to remove and disable access to all the above mentioned accounts within 36 hours of the issue of this communication without vitiating the evidence in any manner. What else does it mean? My lord, it's just completely a blocking order. Then, my lord, please go to the rejoinder. 375? What is it? My lord, what is the content, my lord? The content which is asked to be removed.
The railway track.
No. Kindly, no, that's different, my lord. That is different.
Which is the content?
375 of our rejoinder.
Where is the rejoinder? Rejoinder out there.
And some.
Yes, sir. You read. Will get it.
Yeah, rejoinder.
When did you file?
Just help, help. Yes. Just pass on this way. Whenever the court says stop, I stop.
One second.
Whenever the court says stop, I stop.
It was amended writ petition.
No, my lord, please don't see the amended writ petition because the annexures are not, you will not see the
370?
rejoinder, 375.
Yes.
My lord, what is so offensive? What offense does it commit, my lord? Somebody traveled to Mahakum sitting on a railway on top of a coach. So,
All right.
my lord, there's so many ways in which people reached Prayagraj.
No, this is inspiring someone to do the same thing.
My lord, what is this, my lord?
No, no,
My
correct.
lord, one can,
I may not say that.
one
See,
can imagine anything.
no,
My lord, it all
Mahakum
depends.
Jane ka last option
My
is what
lord,
is
if
said.
one can imagine anything,
Yes.
you wear a colored glass.
No, no. Yes.
Look at the name of the person who wants everyone to go to Mahakumbh.
I don't know who it is, my lord. I don't know who it is.
But he's inspiring others to go in the same way.
My lord, you wear a colored glass,
No, no, that's in the light of this.
everything looks colored.
In the light.
And in fact, my lord, I was telling my learned friends also in later when I went to Mahakumbh, my lord, the only way I could reach that place in so much of crowd was to take a ride on the as a
Chopper.
pillion on a pillion of a motorcycle.
A motorcycle, correct, yes.
That's the only way in which we could go. There are things happen. So what is the offense in this, my lord? I don't understand. Now, my lord, I showed your lordship something more glaring. It becomes curiouser and curiouser.
What is that?
I showed your lordship. Kindly turn to page. Yeah.
73 of
Kindly turn to page 73 of our rejoinder, my lord. 70? West Bengal Police issues an order under 79, read with 3-1D. My lord, what is this? Just because you show, I don't want to say anything. My lord, this is the risk. My lord, I'm not saying one isolated instance of misuse will invalidate. That's why I let your lordship that provision. It has, without the safeguards, this is what can happen.
So that is why you say it is unconstitutional.
This is how it is, my lord. And now, my lord, please turn to page 75 of the same volume. My lord, that there was a sexual assault in Anna University in Chennai is a matter of public knowledge. It's reported in the newspaper everywhere. My lord, what is the grievance that's being made? Why is the government not speaking about it and taking any action? Is it, what offense have I done with it? What offense has anybody done with this?
No, this is ordered to be taken down.
Yes,
By whom?
by the Tamil Nadu Chennai police, one of the officers. I'm showing all this not as just an instance how law is misused. I'm saying without the protection, this is what is going to happen. And if this happens without the protection, then Article 14 is violated, Article 19(1)(a) is violated, and therefore 3(1)(d) must be struck down. That is the submission.
All right.
Anything else you want to show?
Sorry. See, this 234 is another. So because police operate under
Where is that? I don't like that. What is that? Maharashtra? We don't like the Home Minister.
Yes.
Malad, kindly just see one other instance, Malad. With that, I shall end for the day. Kindly see page 72, para 234.
End for the day?
Today.
Allah, submissions are not over.
No, I have to take your lordship to the Sahyog portal.
I'll mugsi, tondre illa.
Wait a minute. I will.
I will sit.
Wait a minute.
Difficulty for tomorrow, my lord. One matter is not adjourned, my lord. If for my purpose, my lord, your lordships can have it on any earliest possible date convenient to the court and.
Oh, whatever.
Friday?
My lord, can it be next Thursday?
No, no problem. It can be. But you finish it off. Yes.
Yes, I will.
That would be 17th.
So
That would be
Friday he can conclude, my lord.
Whatever. Yes, my lord. I also see if I have omitted any point before my lord.
I don't think you
before
left
your
any
lord-
stone unturned.
Before your lordship shows me the red light. My lord,
Yes.
No, I have the answer because he looks at the matter and my learned senior looks at the matter from Twitter or X-centric perspective. I'll have to look at the matter from intermediary the spectrum. And then I'll be able to justify, but I'll need some time.
No problem, no problem. So, if sir concludes today, can we take it
I
on
may
the?
not conclude today, my lord.
Okay, we'll give you on 11th. If sir concludes on 11th, we'll have it on 17th?
17th.
17th at same time.
Yes.
Same. You're there. Yes, yes.
I may have something to say on this, my lord.
No, I'm
I
not.
don't think, my lord, Twitter
I'm
needs
not
any
allo-
crutches, my lord, of private
Correct.
individuals, my lord, who are already.
No, I'm not permitting allowing the application, but I'll permit him to submit. If that's, what assist, yes.
Because the applicant keeps on, my lord. Anyway, my lord, I'll address. my
Then
lord,
somebody else should not again come into these proceedings like impairing applicants later. Will not,
But please see.
as time passes by, some
Yes,
more
sir.
applicants coming in, then won't be correct.
That's correct.
It's already heard, yes.
That's true. Of course, my lord, your lordship's time is.
Yes, that's what, it's
I know,
not,
it has to be there. But para 234, my lord, I just point this out and then conclude today. Sadhana Police Section 79(3)B order. This order issued under 79(3)B, para 234 at page 72 of the rejoinder.
234.
Para 234.
Yes, sir.
This order issued under section 79(3)B and threat of criminal prosecution directs X to block a comment made 2 years ago about the Home Minister of Maharashtra for failure to act after a woman was beaten on the street. A useless Home Minister has been bestowed upon Maharashtra. What's wrong about that, my lord?
All right.
On the contrary, my lord, I think people should be able to say.
That's why what SG sir said, intermediaries
That is, it makes
responsibility,
no difference.
accountability.
At the end of the day, he need not remove this.
I lose the protection
Will
under
be, only
79(1).
thing will, only consequence would be this. Suppose, my lord, my learned friend posts about me some defamatory statement, which is per se defamatory.
Yes.
The government informs them that this is defamatory. Take it down under Rule 31D,
31D, yes.
not under 79, because it won't. It may
Yes.
not fall. I'm giving a wrong example. So what happens if he does not take it down? But for the order under Rule 31D, he would not be facing the court proceedings if I take him to the court. There he will have to go to the court and say that I am only a platform. He is responsible if at all. What would happen, my lord? Suppose he would have been a press owner of say Times of India. And the similar defamatory material is posted. He is given a special exemption under 79, and I'll point out, my lord, what is the distinction between the medium in which you are disseminating the information.
Yes.
If 79(1) was not there, there may be some semblance of merit in that approach. But even there, I would say, if 79(1) was not there and I was made liable to prosecution, I would challenge that on the ground of Article 14. Why I ask myself, should I be driven to defend myself in a prosecution, taking away the protection given under 79(1) because of something unconstitutional that you do under 31D? There's no answer to say, no doubt 31D may be unconstitutional, but anyway, what has happened to you? Go and face a prosecution. So therefore, 3(1), I am only pointing out all this, how only for this singular purpose, namely that if that filtration mechanism is not there as per section 69A, look at the
So
absurdity we come to.
you want this court to hold 31D to be unconstitutional.
Yes.
Because your exemption is taken away.
Because exemption is taken away by virtue of 79(3)B. Yes, my lord, that's true.
Well, yes.
That is true. I am saying that because the exemption under 79(1) will be taken away, not they take away. The
will be
statute says
taken as
takes, it's
statute.
gone. I'm saying that you can't therefore operate 3(1)D in this manner. That is why we have attacked 3(1)D. Yes, my lord, the answer is yes.
Yes, no, that's your submission.
Not today.
All right, then we'll have continue your submission on 11th at 3:30.
3:30. my lord.
One more hour. I guess that should be enough.
I will try to.
Because the whole day.
Yes, my lord. I understand. No, my lord, your lawyers have been very generous. my lord.
Don't
My
worry.
learned friend can argue after, my lord. I
Let the
respond, that's
SG
all.
sir finish, then you can always submit.
Since Lord's, our submissions are also
Supporting the Twitter.
not supporting.
They don't need the crutches. They have a very eminent
I
counsel
go
too.
many steps beyond Twitter, in fact. I'm the original content creator. Therefore, if your lordships think fit, and I complete my submissions in 30 minutes, then the learned solicitor would also have occasion to meet that. So I think that may
Yes,
be
that's-
the.
But that's your lordship's prerogative. Fixing, my lord.
Then 11th,
Maybe 3 PM if your lordships.
no, you want to argue at 6 PM, no problem, I'm there.
So I'll go after this.
I sometimes go at 7:30, 8 o'clock, that's all right, yes. No problem.
Great.
Yes, sir.
Immensely great.
Heard, so then 17th, SG sir submission, yes. 17th at 12 PM will start, yes. This at 3:30 is enough?
Yes.
Yes, on 11th.
Yes, yes.
There are some other matters. I'll
Yes,
take.
my lord, I understand.
Can I join virtually on Friday?
11th, yes, sir, yes. That's at your convenience, no problem, yes. 2:30 mood matters. Yes.
This you keep. Keep it here. This and submissions. We don't have.
ಎಲ್ಲ ಚೇಂಬರ್ ಕಳಿಸ್ಬಿಡಿ 11th ರಿಪೀಟ್ ಮಾಡ್ಕೊಂಬಿಡಿ ಇಲ್ಲ ಎಲ್ಲ ಚೇಂಬರ್ ಕಳಿಸ್ಬಿಡಿ
Bill number 1, Murli Babu M. Murli Babu.
ಮುರಳಿ ಬಾಬು ಯಾರು ಕೊಡಿ ಡೆಮಾಲಿಷನ್ ಅಂತ ನಾನು ಲರ್ನಡ್ HCGP ಅಲ್ಲಿ ಬರಲ್ಲ ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ಫೈಲ್ ಕೊಡಿ
Bill number 2,
ಉಪಾಧ್ಯಾಯ
Kiran.
ನಿಮ್ಮ ಹೆಸರು ವ್ಯಾಸ್ ಕಿರಣ್ಣ
Along with, but I'm seeking, not to disperse the compensation,
ಯಾಕೆ ಏನ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ
No suit is pending, nothing, my lord.
Then?
This honorable court, at least in 5 instances, have held that acquisition which was taken place in my favor, that under in 1938, that has reached finality and it cannot be challenged by anyone, or that it has set aside that order. Despite that, my lord, now the special land acquisition officer once again goes to the very same question and holds that acquisition has lapsed in 1938 acquisition which was happened in my favor. That has lapsed and hence I am not the owner of the property.
Which are those writ petitions?
Annexure, yes, the annexure K page 102, my lord. It refers to 1995 order. It is 2009, my lord. Annexure K page 102. Lord, the challenge is at 105. Not with respect to this particular land, but the entire notification, 118 acres was acquired in my favor. 106, my lord, it refers to another writ petition.
Acquired for you.
Who are you? Mysore Stoneware, my lord, Maharaja, Mysore Maharaja had acquired around 118 acres of land.
1 minute. Repeat, sorry, sorry.
Annexure B, page 28, is the acquisition notification in my favor. In 118 acres of land was acquired in my favor for the benefit of company.
What is this prayer? Not to directing pronounce the order pertaining to adjudication of entitlement.
Lord, what had happened with respect to adjacent, not to disperse compensation.
KDB Naidu?
KDB, Lord.
HL Pradeep Kumar is directed to accept notice for respondent number 2, 1 HCGP.
PN Harish.
3 yaru?
Harish.
PM Harish. 3, Madam 3 PM Harish. 4
Malafide, my lord.
4 is private part.
Private part.
4 by way of hand summons. List the matter on 24th. Till such time, the respondent KIDB is restrained, or respondents are restrained from disbursing compensation to any of the beneficiaries. Yes, a first matter towali. Adralli, first matter li. Learned HCGP for the first respondent. Baby Patil for the second respondent. The petitioner shall not be dispossessed from the subject property if not already dispossessed as on today. Next, Aditya.
Aditya Vijay Karla.
That's essentially in this case.
You are a decree holder.
Yes, we are the decree holder.
What are you now apprehending?
My lords, what has happened is even the respondents have approached this honorable court.
I have granted stay in that.
Yes, my lords.
All right. On the strength of the stay, they are now wanting to.
Yes, my lords. What they have done is, I'll just read out their prayer information.
Number.
My lords, I will hand over this copy. This is from the court's website itself.
1 minute, yes. Tag this petition along with WP 17879 of 2025.
My lords, if my lords may have the prayer, what they are seeking for. My lords, the second prayer is what is of concern. As of
release the sum of 31 crores.
31,20,000.
31 lakhs.
520.
Yes.
My lords.
Now, what is the interim order you're seeking here?
My lords, what has happened is they have the order was dismissed on the 10th of June.
Where is the interim prayer?
My lords, what has happened, my lords, I will just make my submission.
Where is the interim prayer?
Will orally submit it, my lords.
Forgot.
No.
Then?
My lords, at the stage that I had filed this petition, at that point in time, they hadn't sought for the release of amounts from the commercial courts.
Where is the application at least now?
My lords, I will provide the application what they have submitted on the 7th.
No. Where is your application to state?
My lords, I'm
There should be
not,
something for
I'm,
me to pass an order.
my lords, considering the urgency, I haven't been able
not the
to.
way.
My lords, at least oral prayer may be taken on.
Orally, I'll say interim order, not printed. Oral prayer,
lords-
oral prayer, oral order.
No, I absolutely understand, my lords.
That should
But
not be.
what
See,
has happened is they have
Urgency should not make diligence vanish.
absolutely, my lords.
Can't do that.
Done that.
Now I'll tag this petition along with this.
My lords, what has happened is they have moved a duplicate application before the commercial courts
Correct.
on the same issue.
One
Now they are seeking for release. That is
Tag this
pending for
petition.
orders.
Tag the petition along with WP ಹೇಳಿದ್ನಲ್ಲ ಅಜಯ್, so and so. The learned counsel for the petitioner submits on the strength of the interim order that is passed in the aforesaid petition, in which a prayer is also made for the release of the sum deposited with the petitioner in commercial AP 84 of 2024. The respondents have already moved the matter before.
721, my lords.
Respondents have
Execution.
moved they are judgment debtors.
Yes, my lords.
Respondents have moved the matter before
Before this honorable court only, my lords.
Eh?
What has happened is they have.
where is the sum deposited?
It's deposited before the commercial courts, my lords. Commercial
Alright,
courts
so
they have deposited, they have filed an application.
Tag this petition along with so and so. What is the interim order granted by me?
My lords, it's on the very next page. What they have stated, my lords, is
Has
that.
prayed for. This court has tag this petition on so and so. In writ petition 17879 of 2025, this court has granted the interim order as prayed for. The prayer was for release of a sum already deposited. The judgment debtor has now preferred the subject petition on the score that is appeal is pending, is it?
My lords, they have filed a section 34 before the Kanpur courts, which is the appropriate forum. No stay has been granted. They have been asked to deposit the 75% of the award amount, for which they want to seek the release. The issue is that
they appear to have.
My lords, we had filed the execution petition. The court had ordered for attachment of movable assets.
No, that I understand. Now, without an IA, how to protect is what I'm asking.
My lords, only.
Tag this petition along with tag this petition along with so and so. Listed. Madam.
Because the problem is.
Take a madam. Second list. Second list. List is tomorrow along with this.
Lords, it's reserved for orders for today.
The concerned court, which court is that?
86th, my lords.
Concerned court shall defer its proceedings, including pronouncement of judgment till the next date of hearing.
I will undertake to submit the IA as well, my lords.
Tomorrow.
For.
I'm posting it tomorrow
Yes,
in
my
second
lords.
list.
100%. I will.
Yes.
Much obliged, my lords.
You should have some procedure in doing it. What is this?
My lords, it was a utter chaos last evening. Perhaps I had to have the
There should be method in madness. In chaos, it should
Absolutely, my lords.
Yes.
I would keep in mind, my lords.
Yes, yes.
Much
Next.
obliged.
Anup.
My lords, one small submission. I have received the wakalatnama because the client is staying in Kanpur. He has sent the wakalatnama. Emergent notice was issued in the other writ petition filed by the respondents.
Don't worry about that. Tomorrow you come. We'll all
All
resolve
right,
tomorrow. Yes. They have put the property to sale now.
No, man, what happened is I'm the obstruction applicant. I filed the, my lord, I am the petitioner, my lord, is the franchisor of petrol retail outlets. They were trying to dismantle the, my lord, underground tank, because of which I filed an application. Now, my lord, the decree holders files a memo stating that they have no objections for me to remove the installations. Court directs me to remove within 15 days, my lord. 15 days, my lord.
How much time you want to remove?
Minimum of 120 days is required, my lord, because, my lord, this.
The learned counsel for the petitioner submits that in the fight between the decree holder and the judgment debtor, he is caught in the crossfire. The petitioner runs Petro Products Private Limited in a property owned by the decree holder, and who has now sought that the petitioner should the eviction of the petitioner should happen for demolition of the petrol pump in the said property. The learned counsel submits that where minimum of 4 months or 5 months is required to remove the entire, remove the entire petroleum products, and so to give the vacant possession to the decree holder. It is not that they are wanting to squat over the property. Placing the submission on record, demolition of the petitioner objector's obstructor's property shall not be undertaken till the next date of hearing.
Proceedings may kindly be stayed. Otherwise, the order is, my lord, if I do not remove within 15 days, that I shall be liable.
stay ಮಾಡಿದೀನಲ್ಲ.
Otherwise, I will be liable to pay
ಪ್ರೊಸೀಡಿಂಗ್
rent.
ಸ್ಟೇ ತಗೊಂಡು ನಿಮ್ಗೆ ಏನಾಗ್ಬೇಕು? ನಿಮ್ ಪೆಟ್ರೋಲ್ ಪಂಪ್ ಮೇಲೆ ನಿಮ್ದು ಅಷ್ಟೇ ಇರ್ಬೇಕು.
Otherwise, I will be liable to pay rent. That is the order.
ನೀವು
If I do
ಪೆಟ್ರೋಲ್
not-
ಪಂಪ್ ಯೂಸ್ ಮಾಡ್ಬೇಕು, ರೆಂಟ್ ಕೊಡಲ್ಲ ಅಂತ.
I am not, I am not using it. I have
But
applied
you're
for
holding
permission.
it.
I have applied for permissions. Not
You're holding it. As long as you hold it, you have to pay rent.
It is not even their submission, my lord, that I must pay rent.
Then why do you invite that orders?
Court takes upon itself, my lord, and directs.
All right, demolition of the,
At least order, my lord, order
the
dated.
order dated, so what is the date?
Order dated 25/6 may kind.
In that light, the order date so and so shall remain stayed. ನಿಮ್ದೇನು?
I have wrongly moved it, but my lord had disposed it. Yesterday I had moved it for the Jim Corbett matter. Adu file kalsila, my lord. In view of the 21st circular, only my lord can hear that matter. Aliaro, yes, so they are not setting the file. I've done everything. 2:30 barbegit, my lord. There's a grave urgency. In fact, annexed D is my lord's order.
What's your writ, madam? Yaradu, who is that? Get them.
My lord, in fact, this is my lord's order at annexed D, my lord. I can't move before any other bench. This is my lord's order.
Who is the section? Get it. ಈಗಲೇ ಕರ್ಸಿ.
Grateful, my lord.
Yes, Kalyan Basaraj.
ಯಾವ್ದು ಮೇಡಮ್? ಇನ್ನೊಂದಿದೆಯಾ? ಇದೆ ಸೇಮ್. ಎಲ್ಲಿ ಇವರು? Where is that man? He went away. ಅಲ್ಲಿ ಎಷ್ಟಾಗಿದೆ ಲಿಸ್ಟ್ ಟುಮಾರೋ ಅಂತ ಮಾಡಿ, ಸೇಮ್ ಥಿಂಗ್. ಅಲ್ಲ ಟ್ಯಾಗ್ ಅಲಾಂಗ್ ವಿತ್ ಎರಡು ನಾಳೆಗೆ ಹಾಕ್ಬಿಡಿ. ಇನ್ನೊಂದು 482 ಇನ್ನೊಂದು ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗ್ಬೇಕು ಅಂತ ಮಾಡಿ. ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ. ಇದು ಹೇಳಿದ್ರೆ ಬರಕ್ಕೆ ಮೇಡಮ್? No time. Yes, you should.
Same lenience to me also.
You should. ನಿಮ್ದು ಆಗಿದೆಯಲ್ಲ?
ಆಗಿದೆ.
Yes.
Kindly produce the charge sheet, my lord.
Mike.
If your lordships may kindly produce the charge sheet, my lord, that page number 70, my lord. This is the case wherein it's clear prima facie case has been made out regarding the offences of 420 and 406. The investigating officer has clearly, in column 17 of the charge sheet, my lord, has said that there's been a discrepancy in the ledger book which is present at the hotel physically, my lords, versus the final report submitted to the complainant, my lords.
Correct.
The clear case of cheating is what they have indicated, my lords. In
Page
the
71.
Page 70, my lord, 70.
70, all right, yes.
If I may draw your lordship's attention to the, my lords, wherein the numbers are there, my lords, wherein they. Sakshi 1 Ravarige email ಮೂಲಕ ಸಲ್ಲಿಸಿದ.
Yes.
They have highlighted the discrepancies, my lords. Thereafter, they have gone on to say that ಹೀಗೆ ಆರೋಪಿಗಳು ಪ್ರತಿ ತಿಂಗಳು ತಪ್ಪು ಮಾಹಿತಿಯನ್ನು ನೀಡಿ ಆಕ್ರಮ ಲಾಭವನ್ನು ಮಾಡಿಕೊಂಡು ಸಾಕ್ಷಿ 1 ರವರಿಗೆ ಮೋಸವನ್ನು ಮಾಡುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ಪ್ರಶ್ನಿಸಲಾಗಿದ್ದ ಸಾಕ್ಷಿ 1 ರವರು ಜಯನಗರವರ ಹೋಟೆಲ್ ಹೋಗಿ ಪ್ರಶ್ನೆಯನ್ನು ಮಾಡಲಾಗಿದ್ದಾರೆ. My lords, further in the my lords, next sentence they have said that bouncers were kept by the petitioners, my lords. All of this indicates to the intent, my lords. There's been an intent to cheat the complainant, my lords, time and again, my lords.
Bouncers will cheat you?
Illa, my lords. I'm just trying to just to highlight the intention of the petitioner, my lords, that so that we don't go. This was on a surprise visit by the complainant that we got a hold of this ledger book, my lords, and we were able to see the discrepancies, my lords. Subsequently, after that, my lords, they've kept bouncers and trying to restrict our entrance into the premises, my lords. And in the, my lords, when the charge sheet has clearly indicated prima facie evidence, my lords, we believe that intention is a matter of fact and is a question of fact, my lords, and it must be
To be
tried,
tried.
my lords. There's also a judgment of
Could he?
your lordships.
You gave it in the morning.
Please, my
Yes,
lords.
yes.
And there's another judgment of your lordships itself, my lords, wherein
Both civil and crime.
Ila, my lords, wherein
Yeah,
your
no.
lordships have said that in case of, even though a civil dispute regarding money recovery is pending, my lords, if cheating has been established, my lords, which has been established by the charge.
Could you, madam?
That's paragraph 17, my lords. It's the sixth line, my lords.
Yes.
It is the trite law that criminal law cannot be set into motion for recovery of money unless the offense of cheating or even criminal breach of trust is established. My lords, in this case, my lords, the investigating officer has held that there has been a case of cheating, my lords. There has been an intention to cheat the complainants, my lords. In fact, the two other similar cases, my lords, this has been going on. The petitioners have been doing this, have been trying to defraud hoteliers and hotel owners, my lords. In fact, the owners of the Federation of Hoteliers, my lords, have filed a case before the Supreme Court, in fact, my lords,
Against that.
against the petitioners.
You have completed, Matin. Sandesh, sir.
ಅಲ್ಲ ಫೆಲೋಸ್ ಇವತ್ತು ಸಿನಾಪ್ಸಿಸ್ ನಾವು ಕೊಟ್ಟಿದ್ರಲ್ಲಿ so much has been told about what the charge sheet contains. The investigating officer, my lords, who filed the charge sheet, if my lords would notice serial number 21, 22, 23, my lords. Now what he does is
In the charge sheet.
ಅಲ್ಲ ನಮ್ ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ in synopsis
ಇವತ್ತು ಕೊಟ್ಟಿದ್ರಲ್ಲ.
ಹೌದು
All right, yes.
ಅದರಲ್ಲಿ 21 ತಾವು ನೋಡಿದ್ರೆ they issue a notice under 41A, my lords, 3/4/2023. Then, my lords, 10/4/2023, second notice which was issued under 41A. Now, please notice, my lords, 26 ali, 10/4/2023, the police team, they go to Gurgaon.
One sec, Jevai.
Yes. My lords, I'm sorry. This notice Kodwaga, they gave us 7 days to reply. 10th they go to Gurgaon. Please notice 26, what they do there. Police team barge into Gurgaon, office of Oyo, and 80 lakhs forcefully extorted from Oyo management at the behest of the complainant. Now we gave a complaint, my lords, to the Commissioner of Police, my lords. There was an inquiry that was to happen. My lords, I understand the investigating officer, my lords, he passed away. When he was facing the heat about what he did in Gurgaon, my lords, he passed away. And this is the charge sheet, column 17, which is being read. And column 17 is only to the effect of saying discrepancy in accounts. Now, what is their case, my lords? Their whole case is certain benchmark which they should have got, they have not got. What is the claim filed by them? They have asked for some 51 crores, my lords, for the 3 properties, which includes what is there in this. My lords, the judgments which were relied on, whether it is Preeti Shroff or my lords' judgments, distinctly where there's criminal intent. But my lords, where a matter is arising out of an agreement, there's dispute in terms of who owes whom what. We have made the claim, they have done the counter claim. In our claim, my lords, we have asked for few crores from them. They say we owe them 51 crores, which is subject matter now before the arbitrator. Now, in case of this nature, my lords, whether we see any ingredients of offense being made out or whether it is predominantly civil in nature, my lords, and the judgments which I have given is till 2025. And in fact, my lords, finally, my lord's judgment in Malavika, Periyaswamy, but my lord's judgment.
I think latest.
25th June 2025. My lords, yes, my lord, where they say even just merely because you make your complaint voluminous or charge sheet voluminous, that is not what has to be taken into consideration. The content is important. And that's why, my lords, on the aspect of clever drafting, my lords, we have put in the other 3 judgments.
Muhammad Ali.
Yeah, Muhammad Ali and then, my lord, Salib, then wajib. Even wajib is also one more case of clever drafting.
Correct.
3. Here, my lords, even
950 and 951. 950 is Muhammad Ali, 2023 SEC online is, 951 is Muhammad Wajid.
and my lords, similar complaints which were done under OYO, the coordinate bench which has quashed it is also part of that compilation, my lords. So anyhow we look at it, my lords, on 3 factors also. Predominantly a civil dispute, a cloak of criminality.
We'll see.
Ingredient is absolutely lacking, and this is done as an only vengeful act of arm twisting us to come to a settlement.
Well,
Those two just to clarify, those 2 cases are on a separate footing, my lords.
yeah,
because there
this
was-
is Hemant Avardu.
Please, my lords, and no investigation was conducted in that, no charge sheet was filed, my lords.
It was at the threshold, it was quashed.
At the stage of FIR, that those 2 petitions were quashed, I mean allowed.
That's the difference. Yes, Jagdish.
In fact, my lord.
Hello. Sorry.
Hemant Avardu FIR, huh?
Alla, Hemant avre FIR alla, the out mugisli, my lord,
I
the judgment.
yes.
The fact, my lord, that they've undershown the bookings, undershown the accommodation in the hotel.
So intention to cheat.
Itself, intention to cheat is manifestly exists in the complaint. Just because the civil suit has been filed, my lord, this cannot be taken away.
Civil suit ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ, arbitration.
Even arbitration, my lord.
Civil suit is pending? Civil
No.
suit is filed.
Illa, my lords.
No.
Only arbitration.
Even arbitration, my lord, even
My lords,
arbitration.
NCLT, they filed petitions that has been dismissed, and there they say there's no debt. That's the reason the insolvency proceedings have been dismissed.
No,
3 insolvency proceedings that were initiated, dismissed on the ground that there's no debt
We'll see.
itself.
Now, all those things, my lord, is with respect to whether there is a debt exists or not exists. But here, my lord, is with respect to whether certain bookings was there, whether they have shown in the books and the accounts have been done. The very fact that the bookings were available and they have undershown itself shows, my lord, that the misappropriation and cheating both exist.
My lords,
Cannot be
booking
brought-
takes, yes, I'm sorry.
And this can,
Yes, Jagdish, ಹೇಳಿ ನೀವು.
this cannot be said, my lord, this is not an offense because manifestly exists. The investigation report says it's not clever drafting. It's an investigation report of the investigation officer, which subsequent investigation found out how many bookings have been done and then what is the booking shown to the complainant. Therefore, my lord, it cannot be brought within the purview of those exemptions which.
Yes, Sanjeevani, anything else?
Please, my lords,
Ashtana?
I just wanted to say, my lords, to invoking your lordship's extraordinary jurisdiction under 482, my lords, when it's a prima facie case against the petitioners, my lords, who it's unwarranted is all.
So I should not entertain the petition.
Illa, my lords, I mean,
Well, let's say, just
Why-
the aspect of,
Why are you diffident? You argue whatever you want, you should. Yes.
she's really doing well, my lords.
No,
I
no,
must
that's why.
say.
You should argue whatever, don't worry. If you say, no, this court cannot entertain, yes, that's a submission that you are entitled to make, you should make. Ashtena?
I will.
Enilva,
My
Ashtena?
lords, we have filed a synopsis, my lords, as well.
Where
as,
have you filed synopsis?
My lords, on the last date of hearing, my lords. My lords, an alternate remedy for them would be to file a discharge, my lords, before.
That's there.
Trial court. my
That
lords.
if I don't accept,
Please.
then yes, they would have to avail the remedy of discharge. Discharge
Synopsis
ಆಗ್ತೀರಾ?
dated 25.
This court should not go into the venture of entire investigation paper to conduct a mini trial. They have an option available. Let them go and then come back.
482 will get scrapped. We don't have to look at budget line, we don't have to look at.
In that case, discharge will be scrapped.
Well, it's just 2 aspects. One is about the booking. They were saying discrepancy in the booking. Well, it's booking when it is done by one person and the family comes, 4 persons come on one booking. Now this, according to them, is a discrepancy. Booking will be one. When it's done online, booking is shown, my lords, 1 person books.
Oh, the booking is shown as one.
Oh, but 4
Individually
person-
shown as one. 4 people are residing.
That
I
they
think
say is
ಆಗುತ್ತೆ.
discrepancy.
Obviously.
My lords,
4 ಜನ ಯೂಸ್ ಮಾಡೋ ರೂಮ್ ಒಂದೇ ಬುಕಿಂಗ್ ತೋರಿಸಿದ್ರೆ
booking ಆಗೋದು ಒಂದು ಮೇಲೆ ನಾವು ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಈಗ ಬುಕ್ ಮಾಡುವಾಗ ಇಲ್ ಬಿ 1 person who's done the booking. He might have done the booking on behalf of others. And my lords, finally, my lords, this Mitesh Kumar Shah Ali, when they said, my lords, in fact, 2021,
easy.
my lords, 2021, the case relating to
I'm aware,
Preeti
sir,
Saraf,
yes.
that they have shown in this, my lords, under Preeti, there was 18 crores which was misappropriated, and right from the inception, Preeti Saraf. So there they said, even if there's an arbitral proceedings, you can still have a criminal proceeding. That has been distinguished here, my lords, in Mitesh.
My lords, all the submissions just made, my lords, all those matters are questions of fact, my lords, which must be decided in trial whether, please, my lords.
Correct.
Whether
Yes,
that
we'll
must
see.
have, whether the booking was done by for a family of 4, a family of 6, or
We'll
what.
answer that.
And it's pending before the arbitrator, same aspect of it.
That.
Excess booking.
No, in Volkswagen India,
Yes.
the judgment, Supreme Court says mere pendency of proceedings before the arbitrator would not mean that
But same
criminality
in
goes
Preeti
away.
Shah. Same, my lords, but they said, because in that case, right from the inception, the cheating was evident and they have cheated to the tune of 18 crores. After that, if you say arbitration, it doesn't work. Not in a case where, my lords, the accounts have to be reconciled, who has to give what to whom, our claim, their account.
What will the police do there?
What do they do there? Are they going to be sitting and seeing, my lords, how the benchmark is to be calculated? Now, ultimately, my lords, their grievances, 9 years was the agreement, 3 years was lock-in period. In the lock-in period, you have terminated, which the agreement provides for. There was a fire incident which took place in one property.
Alright.
We asked them for documents, they didn't give it.
All right. ಅದು ಬಂತ ಮೇಡಮ್ ಏನು ಇನ್ನೊಂದು ಸೆಕ್ಷನ್ ಆಫ್ಸರಲ್ಲಿ ಬಿಲ್ಡಿಂಗ್ ಕೇಸ್ ಅದು ಹ್ಮ್ ಹ್ಮ್ ಯಾವಾಗ ಬರುತ್ತೆ ನಾಳೆ ಬರುತ್ತಾ ನಾಳೆ ಈಗ ಬರುತ್ತಾ ಮತ್ತೆ ವೇಟ್ ಮಾಡ್ಬೇಕಲ್ಲ ಇನ್ನೊಂದು ಪಾಸ್ವರ್ಡ್ಗೆ ಸರಿ ಆಲ್ ರೈಟ್ ಹರ್ಡ್ ರಿಸರ್ವ್ಡ್
Obliged, my lords.
Agrees that forest officer, for the forest thing I have watched. Adrilla, I did not see the complaint. For the PCCF is the complainant. ಬೇರೆ ಕೆಲಸ ಇರ್ಲಿಲ್ವಾ? What is this? I was shocked to see the complainant ಯಾರು ನೋಡಿರ್ಲಿಲ್ಲ ಅವರು ಡಿಕ್ಟೇಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನೋಡಿದೆ. PCCF is the complainant. DCF is the complainant.
Passed over 22.
15 days punishment.
Appearing for the petition.
Punishment is 15 days. ಮತ್ತೆ correct. Punishment is 15 days. Where 2 years ಆದ್ಮೇಲೆ can you register the complaint? I have gone on that test. Sara Mehta.
My lord, in this case, respondent has asked for a apology letter.
Apology na?
A defamation case.
Oh, defamation. Oh, correct. Apology ಕೊಟ್ರಾ?
Ready ಇದೆ ಸ್ವಾಮಿ, our presence.
ಮತ್ತೆ settlement ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
It may be tomorrow.
Tomorrow ಆಗಲ್ಲ. We'll take it on Friday. Friday at 2:30.
Please, ma'am.
ಹೌದಾ ಮೇಡಮ್? ನಿಮ್ದೇನ್ ಪ್ರಾಬ್ಲಮ್? ಜಿಮ್ ಕಾರ್ಬೆಟ್. What amount?
1 crore rupees.
ಮ್ಯಾಚ್ ತಗೊಳ್ಳಿ.
1 crore rupees will be released, my lord. My
ಯಾವ್ದಕ್ಕೆ ರಿಲೀಸ್ಡ್?
to a third party account. Complainant Tande, he filed a third party application against the Jade Blue company. My lord, I'll pass on my office.
ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ?
You,
ಇದು 482 ನಾ?
That's the same file which I'm waiting.
No. If this GM or 482?
This is GM res read with 482, my lord.
Correct, sir. How is it 482 now if they are releasing it? ಅದರಲ್ಲೇ ಐ ಹಾಕಿದ್ದೀರಾ ನೀವು?
Our
Dispose of matter.
My lord, this is the disposed of matter. My lord has disposed of. Ide complaint alli same check number amounts ellanu ide. Complainant father has filed a 451 application in the same crime number. Same crime number, he has filed an application by making by attaching the company account. In that company account, he has taken a permission for release of that amount to his account number. He is no way concerned. On
1 crore ಯಾವ್ದರ್ದು ಅದು?
That 1 crore is the allegation saying that amount
Fund
is
of dowry.
Correct. Now that is the subject matter of the entire case. ಈಗ ಅದನ್ನ ನೀನು
ಈಗ ನಾನು what is my order there?
You have to go for trial to determine on that 1 CR to
Against the husband.
Against the husband only.
And Dowry Prohibition
Section
Act
3 and
against
4, yes,
the
to attract
in-laws.
that offense, you go
In-laws.
there and you do it anta heli. My lord has
ಈಗ
upheld
where what is the application filed now?
a 451 read with 4 for release of property, my
Copy
lord.
ಕೊಡಿ ಜಗದೀಶ್ sir.
This is my copy parole. I'll do it from my notes. My lord, annexure E is what I am aggrieved with.
What is this Jade Blue Style?
My lord, that is
Textile
the
Limited.
company, my lord. That is the company account which is attached, my lord.
How can this be 482?
My lord, because the crime number 188, which my lord which was disposed by my lord on 13th September.
The order dated.
In the same crime number, my lord. The order sheet is at Annexure E, my lord, starts at ink page 66.
451, 457.
Please, my lord. Say ink page 66 ali, that is
But
the.
what is the next date there?
I'll put up after the chart sheet anta. What I am worried is Annexure F, my lord, ink page 79.
You are the husband. Who are you? What company is this?
Jade Blue, I am appearing for the counsel for the petitioner.
Who is that?
It's an entity.
The entity, managing director. Yaru. How is it connected with the crime?
Yes. There are two directors, my lord. One is Bipin Chauhan and Jitendra Chauhan. Jitendra Chauhan is the father-in-law.
All right.
So.
Now, where is the application filed?
My lord, application is at Annexure G, page number 80, my lord.
Ee 230 ಯಾಕೆ move ಮಾಡಿದ್ರಿ?
Because Annexure F ಅಲ್ಲಿ ನಿನ್ನೆ my lord, that 1 crore amount intimation is Annexure F, my lord. Ink page 79. Intimation dated 24/6 saying you please release the amount immediately.
Who has given this intimation? Court.
A court to the SBI manager,
Please.
respondent number 4.
Will for now stay this and you look into it. We'll take it on Monday or Tuesday whenever you want.
So grateful, my lord.
The petitioner is before this court crying foul of release of rupees 1 crore, which was the subject matter of crime in crime number
188 of 2023.
188 of 2020, which was dealt with by this court. The learned counsel submits that the allegation of receipt of 1 crore to a company by the father-in-law is now attributed to dowry. The said attribution is yet to be decided by the concerned court. The matter is pending adjudication. In the interregnum, it transpires that an application is made for release of the said 1 crore by directing defreezement of the account. In that light, the amount so standing in State Bank of India shall not be released in favor of any person till the next date of hearing.
Annexure F and Annexure E also, my lord. Intimation and the order, operation of the order 16/6 ಬರುತ್ತೆ.
Annexure F, no? In that light, there shall be an interim order of stay of the order directing release and an intimation of such release till the next date of hearing.
I'm so grateful, my lord. My apologies if.
Nenne
So
ಎರಡು ಮೂರು
grateful.
ಸತಿ,
I have
yes,
nothing more to say. I'm
That's all
indebted,
right,
my lord.
yes.
So grateful, so grateful.
ಬಟ್ ಕೇಸ್ ನಡಿಬೇಕಾದ್ರೆ ಮಧ್ಯದಲ್ಲಿ ಬಂದು ಹೇಳ್ಬಾರ್ದು.
My apologies. I'll never do it, my lord.
ನಿನ್ನೆ you did that, yes.
So grateful.
ನಾಳೆ tomorrow. That also we'll see. Yes. Yes, Rahul. ಆಯ್ತು ಕೊಡ್ತೀನಿ. ಯಾವ್ದಾರು ಆಗಿದೆ ಮೇಡಮ್? ಯಾವ್ದಾರು ಆಗಿದೆಯಾ? ಇದೆಲ್ಲ ಮಾರ್ನಿಂಗ್ 10:30 you take.
ಯಾಕೆ ಇನ್ನೂ ಜಾಸ್ತಿ ಕುಂತಾ ಇದ್ದಾರಲ್ಲ? ನಾನು ಬೇಲ್ ಸ್ಪೋಕನ್ ಟು ಸೇವ್ ಅಂದ್ಬಿಟ್ಟು ಜ್ಯೋತಿ ಅವರು ನಿಮಗೆ ಫೋಟೋ ಕಳಿಸಿ ಟೆಸ್ಟ್ ಮಾಡಕ್ಕೆ ಹೇಳಿರಲಿಲ್ಲ ಸರ್. ಅದು ಇವತ್ತು ಎಷ್ಟು ಆಗಿತ್ತು ಅವ್ರಿಗೆ ಏನು ಟೆಸ್ಟ್ ಆಗಿದೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು